Living in Milwaukee now?
Yes, sir. Grew up here. We left Detroit when I was I don't even think I was walking and talking yet. So
Okay.
Milwaukee's home, Wisconsin's home, born and raised.
Okay. Not working right now, right?
No, not at the moment. No.
What do you do when you're working? What do you consider your job?
The last job I just had, I was working at a sheet metal place.
Okay.
Basically just they would have these hook things, you just basically, it's strenuous because you got to do a lot of lifting, and it's a lot of heavy lifting, but you basically just hanging these pieces on these hooks, and they're going through the thing, they're steaming them, painting them, then they come back around, and then you just box them up and load them.
So you're not married?
No.
You have a girlfriend?
Yeah.
You live with her?
No.
What's her name, your girlfriend's name?
Her name is Erica Patterson.
How does she spell it?
Erika.
P-A...
Yeah, Patterson.
Okay, and it's 4014 North 19th Street in Milwaukee. Do I have the right address?
Yes, sir.
Is that an apartment or a house?
It's a house.
Okay. What's the zip code there?
53209.
Okay. And last grade you completed in school?
12th.
Grade? Okay. Graduated high school?
Yes, sir.
What school did you go to in Milwaukee?
Riverside.
Riverside?
Yes, sir. Milwaukee Riverside Tigers. I see you smile. You know about Riverside, man?
I heard things.
We kicked y'all butt in football.
It was West Dallas.
Oh, no.
I don't think we play Riverside.
Yeah.
Okay. All right. So, yeah, I appreciate all the cooperation and all the good dialogue we've had, to this point, Darrell. Being that you're sitting here and I had some handcuffs on you before and all that jazz.
Absolutely.
You familiar with your legal rights?
Yes,
Have you ever had those read to you before?
Yes, I have.
Okay. So as you can see, they're written on this paper. So because, if I was sitting here and talking to you on your couch, we wouldn't have to worry about this. But because you're here and not in your home, it's kind of a thing I got to read to you, okay? And again, it's just something I got to read to you before I kind of get your side, or hopefully get your side here, and love to hear your side. I'd like to know what Darrell has to say about, okay, we got some people calling us saying this, he said you made hundreds before. No, I wasn't driving. Someone thought you might have been. He had to get that warrant. He ended up calling a guy just to use his phone, kind of loitering around, and just, how you ended up kind of being there. That's what they say.
No. I was going to say, I knocked on his door to use his phone.
Yep. Right, but it probably wasn't him that called because he got his phone, but someone was concerned about something. So just trying to figure out what's going on down in that neighborhood. Does that make sense?
Yeah.
Okay. All right, Darrell.
He kind of, like I said, that wasn't probably the best, but I was just like, I need to get an Uber. Yep. I have money on my Cash App card.
Yep.
So I'm not trying to rob anybody.
Sure.
I'm not trying to break it and obviously you can tell I'm not drunk. I'm not, under the influence of anything. So.
Okay. All right.
So basically what it was.
Okay. All right. In regards to these, Darrell, then, do you understand that you have the right to remain silent? Just answer everything with a yes or no.
Yes, sir.
Okay. And then I just write down your reply. You understand if you give up that right, anything you say may be used against you in court?
Yes, sir.
Do you understand you have the right to consult with an attorney and have an attorney present during any questioning?
Yes, sir.
Do you understand if you cannot afford an attorney, one will be provided to you by the court?
Yes, sir.
Understanding the above rights, Darrell, are you willing to speak with me, us, primarily me? I'm the one that's going to be doing most of the talking probably.
I just want to know a little bit more about what's going on. Just a little bit, because
like I told you, I know very little. I just know that, you were down in this neighborhood, someone called, they didn't know what you were doing down there and things like that. So I got limited from their side, but I'm looking to see, what you have to say about it. I'm looking to see, maybe the caller was just on some BS down there. I don't know. I don't know. But I can't really show the court that if I don't have, if I haven't talked to you. So that's why I'm here, just to kind of see what you got to say about it. Get your side of it. Running around a neighborhood's not the end of the world. It's not a huge deal.
Right. Unfortunately, I wouldn't have had to do that if if I made better decisions with women.
Yeah.
But not gonna point the finger.
Sure.
I'm a grown man. I make my own decisions, so I'm not gonna point the finger at nobody. I just didn't think.
Didn't think, yeah.
What the hell?
You willing to speak with me, Darrell?
Not right now.
So, was a decision made to speak with Mr. Brooks the following day?
Objection. I don't consent to being called that name, leading the witness.
The objections are overruled. The witness may answer.
Yes, ma'am, it was.
Now, when you spoke with the defendant on the 21st, what did you have some general information as to casualties from
Yes.
the parade?
Yes, I did.
What information did you have at that point?
At that point, not all the information was in yet, but I knew, as I stated in previous testimony, our emergency department was very full. I knew there were significant injuries to many people. I knew some were deceased. I did not know the exact number at that time.
You had approximately another couple minutes of conversations with Mr. Brooks before you called it a night. What was the vibe that you got from him during those couple minutes?
Objection. I don't consent to being called that name, just leading the witness.
The objection's overruled. You may answer.
I would say friendly. I think when you heard the clip there, Mr. Brooks jokes about Riverside and football. The individual he was talking to at that time was Detective Stern, as you can't obviously see him in the video. I could sense, and I believe you can hear it in Mr. Brooks's voice in that clip, the FBI put him on edge. It was unusual to see them. I could sense the nervousness. He did transition as I talked to him more throughout that clip into a more normal conversational tone again. But when I was speaking with Mr. Brooks casually throughout the night, that was the type of tone he had with us. It was very friendly, and he seemed, when it came to myself and Detective Stern, very comfortable speaking with us.
Now, you had stated your initial intent was to talk to him about loitering in the area that he was arrested. Do you recall that?
Objection. Speculative.
Overruled. The witness may answer.
Yes, I do.
Did Mr. Brooks at all talk to you about the loitering in terms of what the focus of your investigation was that night?
Objection. I don't consent to being called that name, leading the witness.
Overruled. The witness may answer.
Yes, the statements he made in there, about, being in the area because he needed an Uber. He says more, to us about not knowing the area of Waukesha. He doesn't know the streets, things of that nature, and he just needed an Uber to get home. So yeah, that was his reasoning for being down there, and he stuck to that reasoning the entire time.
Direct your attention then to the next day. So, strike that. That night, was he transported to a Muskego Police Department?
Yes, he was.
And did you go to Muskego Police Department?
Yes, I did.
Did you transport him?
So it was a dual transport. Officer Leha from the Waukesha Police Department responded to Waukesha Memorial Hospital in a marked squad car that has an appropriate rear backseat transport compartment. Mr. Brooks was placed in that car, and myself and Detective Stern followed in a separate car.
So once you get to City of Muskego Police Department, do you do anything there?
Objection. Leading.
Overruled. You may answer.
Not the first night. Myself and Detective Stern stood by while some basic medical questions that were part of Muskego Police Department's policy as far as holding a prisoner were asked of him. I was there until Mr. Brooks was placed into his cell. once Mr. Brooks was in his cell, I explained to him that me personally, would be returning the next day to speak with him more and give him more information about the investigation.
Did Officer Leha end up staying at the Muskego Police Department with the defendant?
Objection, speculative.
Overruled.
Yes, he did.
Why was that?
Objection, leading.
Overruled.
That was Muskego's request, being Mr. Brooks was, because of the transition and we did not have our own municipal lockup facility, we requested to use Muskego Police Departments and they allowed it. But being Mr. Brooks was technically in our custody, they requested that one of our officers stay there to do the monitoring and the jail checks.
So did you return to the City of Muskego Police Department the next day, November 22nd, to speak with Mr. Brooks again?
Yes, I
Objection,
did.
I don't consent to being called that name.
Overruled. You may answer.
Yes, I did.
Did you return with anyone?
I returned with Detective Ben Stern.
Now, what was the plan for this interview? You had said the previous day the intent was to kind of start very low, just looking at loitering. Did you have a plan going into the interview on the 22nd?
Objection, leading.
Overruled.
I did.
What was that plan?
So the plan was different from the prior day. So the interview with Mr. Brooks on the 22nd didn't start till about a little after noon that afternoon, 12:11 p.m. to be exact. Around 8 a.m. that morning, there was a briefing with all officers that were involved where I learned some additional information. One of the things I learned that morning was that there was a domestic abuse incident that had occurred between Darrell Brooks and Erica Patterson, something I was not aware of when I was with Mr. Brooks during the evening hours of November 21st. There was also much more information at this point in regards to the parade incident. As I had stated in my earlier testimony, it was very, very chaotic that first night. Between radio traffic and what I could hear going on down in the downtown, as I had stated, it was really unlike anything I've ever been involved in. But by Tuesday morning, the 22nd, we had narrowed it down to basically just Mr. Brooks, that there were not 4 people in this car. We were looking at one man. So he was now a suspect in the domestic abuse and driving in the parade. So I chose to begin the interview on the less serious matter, that being the battery charge that he was looking at with Erica Patterson.
Now, you said Tuesday the 22nd.
Monday, excuse me.
Okay, thank you. And what do you try to do when you're meeting with someone? Do you try to establish any type of rapport with that person? Is that helpful? How did you approach this interview on the 22nd?
Objection, leading.
I'll sustain as to the form of the question. It was actually compound, and if you could rephrase.
How did you approach the questioning of Mr. Brooks on the 22nd?
Objection, I don't consent to being called that name.
Overruled. The witness may answer.
So when I began to speak with Darrell Brooks on the 22nd, I began with some very light conversation. I explained to Mr. Brooks that I had more information from the previous day. I explained to Mr. Brooks that his girlfriend at that time, Erica Patterson, had made some domestic abuse allegations against him that were physical in nature. I didn't indicate to him exactly what she said he did, but that there were physical allegations. I explained to Mr. Brooks that there's always 2 sides to a story, and that, a lot of times in my experience as an officer, it can be about perspective. There's side A, there's side C, so to speak, and maybe B, somewhere in the middle, can be your truth. And I basically just implored him to be honest. I touched on the fact we had talked extensively the night before about things such as him enjoying baseball, him having watched the Packer game, him having been disappointed by the result of the Packer game. And in situations such as interrogations, I think it's always important to let a person know that obviously I'm an officer, but I'm a human being, as are they. And you want to try to not let them see that barrier and feel comfortable talking to you. I think in any interpersonal relationship in society, there needs to be rapport. and I try to establish that before getting into the specific details of the crime at hand.
Now, you said that you had a briefing prior to going back to the City of Muskego Police Department.
Yes, ma'am.
Did you have, you said you had more information about the parade incident and also the domestic incident, correct?
Correct.
Objection leading.
Overruled, his answer may stand. Next question.
Did you know at that time, prior to speaking with Mr. Brooks, how many people had died during the parade incident?
Objection leading.
Overruled.
Yes, I did.
And how many people was that at that time?
Objection leading.
Overruled.
At that point, it was 5.
So did you confirm, again, personal information for the defendant before starting the interview?
Yes, I did.
Did you read him the Miranda form like you did the night before?
Yes, I did.
I'm going to show you what's been marked as State's Exhibit 174. Now, is that the Miranda statement form that you completed on November 22nd with Mr. Brooks?
Objection leading.
Overruled. You may answer.
Yes, it is.
And what time was that completed?
12:11 p.m.
What exhibit is that?
174.
174?
174. And did you read that form to Mr. Brooks?
Objection. What did it say?
Overruled.
Yes, I did.
And did you read that form to him in its entirety?
Yes, I did.
I'd ask that Exhibit 174 be moved into evidence.
Objection. Relevancy.
Exhibit 174 is received.
Now, when we look at Exhibit 174, it says spouse's name, it says Erica Patterson. Do you see that?
Objection leading.
Sustained it to the form of the question. You did not ask the published. I did not. I just want to make sure that's what you were not looking to do.
Correct. No.
Okay. Thank you.
There's a spot in this form that says spouse's name. Is that filled in?
Yes.
And what does it say?
Objection leading.
Overruled. The witness may answer.
It says Erica Patterson.
Did he say that they were married?
He did not. He said that was his girlfriend, however.
And he indicated he had children?
Objection leading.
It's background foundational. It's the witness may answer. The objection's overruled.
Yes, he did.
How many children did he have?
Objection leading.
Overruled.
3.
Okay. And you read each of the 5 rights that are listed on this form?
Yes, I did.
And did he agree to speak with you?
Yes, ma'am, he did.
Okay. I would ask that Exhibit 174 be published to the jury.
Objection. Relevancy.
The exhibit's already been received. Noting your objection, it's overruled. Permission to publish is granted.
Now, as that form is coming up in the jury box, just for the jurors to see, when you initially had contact with the defendant that morning, did you verify if he had been fed?
Objection. Speculative.
Overruled. The witness may answer.
Yes, I did.
And had he been fed dinner the night before, breakfast that morning, lunch that afternoon?
Objection. Hearsay.
Overruled.
Yes, he had.
And was he complaining about any physical injuries?
Objection. Hearsay.
Overruled.
Yes, he was continuing to complain about, excuse me, he was continuing to complain about the injury to his right shoulder, which he still at that time was asserting. That would be correct.
Okay. And you've had the opportunity to listen to that interview?
Yes, I have.
I'm going to go through that interview with you. I'm not going to play the whole 5 hours, but just portions of that. I'll stop it during specific clips that I'm providing to Ms. Gussie, and we'll talk about it. Is that all right?
Yes, that's fine.
Okay.
Before you do that, I'm told our interpreter will be here momentarily, and rather than you start, I think it would be best if we just take a short break till the interpreter's here. Is the witness here?
I believe he was coming at 10.
Oh,
We thought
okay,
we'd take
that's
a
fine
break.
then. Then I appreciate that additional information, then we'll keep going. Sorry for the interruption.
Let me see if maybe he's here early.
Okay.
Okay. He's not here yet.
Okay, then we will keep going and just let me know when the witness gets here.
Okay, you can take this exhibit off the screen. If we can go to 7 minutes and 30 seconds to 8 minutes and 20 seconds. To 8. Now, before she starts it, is this the interview room that was at the Siemens-Hewitt Police Department?
Yes, it is.
Okay. And it's paused right now, but who's in that room?
Objection leading.
Overruled.
The person in that room in the red t-shirt with the mask partially covering their face, longer braided appearing hair, is Darrell Brooks. The same individual sitting to my left in this suit, jacket, shorter hair, and surgical mask.
Okay. And the other two people depicted here?
The person, as you would look to the screen to the left, is myself, and on the right is Detective Ben Stern.
Okay. So again, going to 7 minutes and 30 seconds. We're going to play it, but not with sound, until 7 minutes and 30 seconds.
Go ahead.
Okay. So it now is at 7 minutes and 30 seconds. If we can play until 8 minutes and 20 seconds.
Hang the metal pieces on the little machine thing that comes around. They take them. The pieces go through like this little steamer type machine thing, and then they paint it. And my oldest daughter is 14, and my youngest daughter is 7.
You said your oldest son's grown. How old is he?
He's 18.
They all live with you then in Milwaukee?
Well, my son doesn't.
Your son doesn't?
My son doesn't. But
Okay. All right.
So initially, what were you speaking with Mr. Brooks about when he was describing doing something with metal?
Objection leading, and I do not consent to being called that name.
Overruled as to both objections. The witness may answer.
Just about work, he was, Mr. Brooks was explaining a job he had prior. He indicated he was laid off due to the pandemic. So it was just general conversation about his work history.
And he talked about his kids. Do you recall that?
Yes.
And his two youngest kids, who did he say they lived with?
Objection leading.
Overruled. The witness
Objection
may answer.
relevancy.
Mr. Brooks was indicating they were living with him. However, the investigation showed that not to be the case. Of the two daughters, one lives down in Georgia in the Atlanta area and the other lives in Iowa.
Thank you. Now directing your attention to 14 minutes and 15 seconds into the interview, and I'd be playing that until 15 minutes and 48 seconds into the interview. It is currently at 14 minutes and 15 seconds.
Can I have those timestamps again, please?
Sure. 14 minutes and 15 seconds beginning to 15 minutes and 48 seconds.
Thank you.
I'd ask that that be played at this time.
Go ahead.
We're not on your college set. I gotta read it, okay? And I know you've heard it before, so you kind of understand that.
Yes, sir.
Okay. Do you have any questions before I start for me?
Only thing I want to know is, what in the heck, am I being charged with anything?
Well, she's making some, like I said, alleged allegations against you, kind of, for being physical. So that's what, if that's BS, that's what I'm looking to hear from you. Okay?
Total BS.
You know what I'm saying? And that's kind of, we couldn't track her down, so that's kind of where we're at. It's this typical back and forth stuff that guys like you go through with their baby mama all the time. And they're all, there's a lot of guys out there in your spot, and a lot of times, maybe it's not always fair to them, but that's kind of what
I
I'm
wish they
trying to
had a
figure
law
out.
to where people can, if you do that shit, you should get in trouble.
Sure. Yeah.
Like, why? You shouldn't be able to just be like, oh, I'm pissed off, so I'm going to call and do this.
Yep. I agree.
Like, why would you put me in that situation and then we're going to end up being together anyway?
And that's
Why would you do that?
Trying to judge that credibility.
Yeah, and that's total BS. So that's what that's why we're sitting in here with you, to try to sift through the BS, if that's what we got, and go from there.
Crazy, man.
Does that make sense?
Yeah. Oh,
All right.
this fucking girl, man. I said this last night too, didn't I? She gets drunk and remember I kept saying that she fucking acts a fool and I'm the one that pays for it.
Yep.
Can you tell the jury a little bit about this clip?
Overruled.
So in this clip here, I'm just explaining to Mr. Brooks the background of the domestic abuse allegations that officers had received from Erica Patterson, and that I was looking to get basically clarity on that, his side of the story on that, have him help me understand what aspects of it may or may not be true, and just walk me through what had occurred between the two of them.
Again, although we're approximately 15 minutes into the interview, have you mentioned anything about the parade incident or any victims?
Objection. Lee.
Overruled. The witness may answer.
I had not said anything about that at this point.
And why was that?
So what I wanted to do with this interview, as I stated in my earlier testimony, I wanted to start with the smaller things and get to the bigger things. The parade incident with the injuries of the individuals and the loss of life was obviously very serious. Part of what I believe as an investigator is very important is gauging credibility into the interview. And one of the ways you do that is you need to be careful. Obviously, at some point, if I'm going to take Mr. Brooks to jail, I have to tell him what he's being charged with. But I want to be very careful in giving too much information early on, so that I'm not leading him, so that I'm not giving him the opportunity based on information to create lies. I want to see how he reacts to things to help me gauge whether he's being truthful. And I found starting with the smaller aspect and seeing how truthful he was with that could help lead me into the more serious allegations and see if he was going to be truthful about those things as well.
Now, as I watched the snippet of the video that we showed, at one point you had indicated, guys like you get into these kind of situations with girls like that, or something to that effect. Do you recall that interaction in this video?
Yes, I do.
What do you mean by that? Or what were you trying to establish by making that statement?
Again, as I had stated in my earlier testimony, part of what I believe is important is simply building a rapport with an individual. Again, you always have with any individual in any interrogation, there's the natural barrier that can occur with them seeing you as a law enforcement officer. I've been doing this job for 18 years. That was not intended on any way on my part to suggest to Mr. Brooks that everything his girlfriend was saying was a lie. I just wanted him to feel comfortable telling me the truth, whatever that truth was, man to man or person to person, human being to human being.
Lying.
Directing your attention to 30 minutes and 26 seconds and playing this clip until 40 minutes and 30 seconds. Let's do that now.
Objection. Wasn't it just said we was 15 minutes in the interview? Why is it playing from 30 minutes?
Your objection is noted, it's overruled again, that's 30-26, you said?
30-26 to 40-30.
To 40-30. Go ahead.
No.
What brought you to Waukesha yesterday? How did you get out here?
I was meeting up with a friend to watch the Packer game.
Okay.
That's the only reason why I was out here.
Where did you go to watch the game?
To a friend named Stephanie.
Her house, a bar, or?
A house.
Yeah, I don't mean to make you uncomfortable or anything, but what's the address there? What street
I
is it on?
have no idea about Waukesha. I don't know the streets.
What was it near? I know you had to see something near it. So what was it near?
Like a gas station?
Have you been to the house before?
No.
Never before?
No.
What's Stephanie's last name?
I have no idea. I have no idea.
When did you guys set this up?
Maybe a couple of days ago.
Okay.
Like I said, I have a few friends. I have a few friends in Milwaukee that have people out here, so
Okay.
it's not, I don't, like I said last night, I don't know the streets in Waukesha. It's not where I usually hang out at, so I couldn't say, well, this street, and this, you know, I couldn't.
All right.
Stephanie, like a friend of yours or like a friend of a friend?
A friend of a friend, mutual friend.
And what did you say
She's
her
just
last
like,
name was?
I have no idea.
How long have you known her?
That was my first time meeting her. So,
How did you get the number to know the house to go to?
a friend.
So how did you get to her house?
My friend. I went with my friend.
Okay, who's that?
My friend, I don't really want to say his name. I don't know if that's going to incriminate him in anything. So.
Okay, so let's go with this. How did you come? I know you saw Erica yesterday in Waukesha because we talked to her. Now I don't know everything that went on, and I'm not saying I believe everything she told the other officers. How did you come to meet with her in Waukesha? One, and two. You say you don't know Waukesha, but where did you meet her? A gas station, a park? I know you met her. Where did you meet her? What happened yesterday?
Yeah,
because if this is BS, like you say, and I know you met her, what happened?
I met
What
her
happened when you met her? Where did you meet her? Let's start with that.
by a gas station.
Okay.
I don't know what I was supposed to be getting some money from her.
Okay. For what?
It was the rest of my money that she had of mine that she was holding for me.
Okay, how much?
It was supposed to be $350.
Okay. And why did she have it? Why was she holding
Well,
it?
she had been holding it for me for a few weeks now, but like I said, I hadn't seen her. She had seen
Right,
my
but
mom
what was she
already-
holding? Why did she have it? Why was she holding it for you?
She was just holding it for me because I told her to hold it for me. But it didn't have anything to do with, this was weeks ago. She had been holding the money. And because I had no contact with her, I couldn't tell her, and my mom wasn't going to let her come to the house to bring it.
Mm-hmm.
And I told her, look, man, if I'm going to be out there, I'll meet up with you and get the money, but I'm not hanging out with you. I'm not having sex with you. And she was just like, oh, you want to kill? I'm like, I'm not finna do none of that.
Okay.
You know what I'm saying? I'm not supposed to be around you. I get that. I understand that. I'm not going to lie to y'all. I'm not supposed to be around you. I love you to death, man. You're my baby mama. I'm not going to, you know what I'm saying? It wasn't supposed to be like a hangout thing. I told her, I'm like, I'm out here. And she's like, oh, where you at? Where you at? Where you at? And I'm like, look, I'll meet up with you to get the money and, you know, give you a hug or whatever. But she was like, well, I need something. I'm like, no, we can't do it all that. I'm not going to have sex with you. I'm not going to hang out with you or none of that.
All right. So you told her you weren't going to do any of that stuff.
No.
How did you set the meeting up? Did you talk to her on the phone, Facebook Messenger, text message?
'Cause
I talked to her.
I don't think she said anything about that. So just, I mean, if she's BS, how did you
Yeah, because
create a meeting with her?
This is what she does.
Well, hold on one second. Hold on, one thing at a time. How did you set the meeting with her? How do I verify?
That's what I'm saying. If she can't get in touch with me, that's what she'll do. She'll go to social medias and do all this and try to talk to people and all this and that. I got in contact with her through a mutual friend that we both know. And I was like, okay, tell her I'm out in Waukesha or whatever, and I'll meet up with her to get the money. And then she put us on the call. And she was just like, where you at?
Call?
Yeah. And she was just like, where you at? I'm like, look, I don't know where I'm at. Do you still got that money? She's like, yeah, I want to give you the money, and I want to do this and do that. I'm like, no, I'm not gonna hang out with you. I'm gonna meet up with you, get the money, give you a hug and kiss. We'll talk later.
Was it still daylight?
It was still daylight. It was still daylight.
So
after the fact.
This was, I think the game was still on.
Game was on. So
the game was still on.
Left Stephanie's to go.
Yep. The game was still on. So I was like, fuck it. You know what I mean? I want to see you. I ain't seen you in like a month. You know what I'm saying? So I'm not going to lie and say, man, that's my baby mama. I love this woman. But I can't hang out with you. I can't do anything with you, you know, that type of thing, deal, and whatever the case may be. But, yeah, that.
And this is on your cell phone? The three-way call, obviously, is your cell phone because you're not on the phone, right?
My friend's phone.
Friend's phone.
Yeah.
But yesterday, so do you have your phone?
No. That's what I'm saying. No.
So who is the friend whose phone you were using to talk to her on a three-way call?
I don't want to say his name because I don't want to.
Okay, I guess, so you saw her though, right? You met up with her? Okay. So, how did the conversation with her end?
With me walking off and her being pissed off that I didn't want to hang out with her. I said, look, I'm not supposed to be around you, I'm gone.
Okay.
When she
Whose
said,
car did you use to get out
she
here?
said, I didn't have a car.
No, whose car did you use to get to Waukesha?
My friend is the one that said he was going to go hang out and watch the Packer game. I said, I'm going to go with.
Okay. Whose car did you use to get out to Waukesha?
I didn't use anybody's car.
Where does your friend live?
My friend lives in Milwaukee.
So you didn't walk to Waukesha. Whose car did you guys use to
My
get
friend,
out?
I just said my
What
friend.
type of car does he have? I'm just trying to figure out how you got here.
Yeah, I know, but it seemed like you trying to, like, spin me up or something. Like,
I'm just asking how you got here. Whose car did you drive out here?
I didn't drive at all.
Whose car did you come out here in?
My friend.
Okay, right. What kind of car is it? So here's the thing, Darrell.
Okay.
Obviously, you know, she's coming at us. I told her she's talking about some domestic-related issues, okay? You know, and I don't know if she's on BS. I don't know if she's not.
I'm telling you.
Hold on, let me finish.
Okay.
Let me finish. I don't want you to get...
Yeah, because
Hold on, let me finish. You know, I don't entirely know all that, okay? I'm just right now trying to figure out how you got out here. So I got to step out with my partner for a minute. Just relax. I don't want you to get you all nervous, okay? But, you know, I'm not trying to be confrontational, but I don't think when you meet her out in Waukesha, and you're not from Waukesha, I think a reasonable question is to ask, how did you get out here?
Yeah.
Whether you drove, someone else drove, and if so, when you got out here, what type of car you were in. So just, every hour or so, my boss, he knows we're out here. I just got to call him and say, yeah, we're talking. I'll call you back later. Just got to step out, throw in a line with him, and we'll come back. Just chill out here, enjoy your soda. We'll be right back. All right? Sound good? Okay.
So we done talking or?
No,
No,
we'll be
no,
back in
we'll
a
come back
minute.
and
Just
talk.
chill out, and we'll be back.
You just gotta make that
back
call.
in that, so I just got to make that call.
That check-in call.
All right?
In the middle of the conversation?
Well, do you want to tell me about the car?
Just go another couple minutes.
Yeah, but I'm
I mean, I got to call him. I can come back, but I just...
listen, I'm willing to, listen, Carpenter, you've been straight up with me, you've been straight up with me, right? All I'm saying is, I just want to know what I'm looking at, and if I can just notify my girls. That's it. I don't have a problem with talking to you guys at all. I just want to know what am I looking at. That's
Well,
it.
at the start, she called about some domestic abuse related stuff. Now, I didn't talk to her myself. I told you that at the start. You said she was crazy. We talked
Y'all
about
know that. Y'all talked to the woman.
No, I didn't. I didn't.
Oh,
Other
I
officers-
apologize. You talk.
Slow,
Other
Darrell,
officers that we listened to the interview.
slow down,
Did
Darrell.
she look beat up? Did she look like, dude?
Darrell,
Like,
listen
come
to me.
on now, man.
Slow down, dude. All right? We can't explain it to you if you keep talking over us. You know what I'm saying? All right? I didn't talk to her. I didn't see her. Okay? Now,
Okay, with regard to that clip, sir, we have a lot of talk about her, meaning her. Who is her?
Objection leading.
Overruled.
The her in this case is Erica Patterson.
So did you have some conversations with Mr. Brooks before this clip about his relationship with Miss Patterson?
Objection leading. I do consent to being called that name.
The objections are overruled. The witness may answer.
Yes, I did.
Now, at the end of this video, not the end of the video, but the end of this clip, again, he is saying, "What am I looking at?" Do you recall him saying that in this video?
Objection leading.
Overruled.
Yes, I do.
Was this a theme throughout this 5-hour video?
Objection leading.
Overruled. The witness may answer.
Yes, it was.
Did he, you had stated initially when he came into the room, he had complained about some shoulder pain.
Yes, he did.
Did that continue throughout the interview?
Objection relevancy.
Overruled. The witness may answer.
So I would say what happened is it went on and off. So at this point here, the interview at this point in time was what I would describe as laid back. A lot of it was simply getting background about the overall relationship between Mr. Brooks and Miss Patterson. During that time, he was fine. He was moving his arms, as you could see in this clip. He wasn't complaining about pain. What I noticed and made me question the legitimacy of the injury before ever actually even seeing the body cam is I noted at times of stress later in this interview as I continue to push on a vehicle. I can see, as you could see here, I believe it can be seen here in this interview, talking about the car made him uncomfortable. Complaints about the pain would suddenly come back.
How about the request to be told what he's looking at? Did you see any correlation between that and what was occurring during the interview?
Objection speculative.
Overruled. The witness may answer.
Yes, that, as I say, that continued throughout the entirety of the interview, and really at this point was a little unusual because right now he had been told he was looking at the domestic. The parade hadn't come up, so a reasonable person, I believe, at this point of the interview knew what they were looking at. They were looking at a domestic abuse incident. Why simply asking him how he got out here as far as transportation made him nervous was alarming.
An example of him, you said that you had seen him using his arms a little bit in this clip, is that correct?
Objection leading.
Sustained as to the form of the question.
You had stated that, what observations did you make during this clip about the use of his right arm?
He would move it from side to side, so, I mean, both his arms would come out like this and move. He would make mannerisms when he was speaking with both arms that were, to me, what a person would do when they're normally conversing. And it would seem unusual to make those movements if he was, in fact, in as much pain as he was claiming to us he was in.
Now I'm gonna just let the record reflect that when you had indicated he'd move his arms this way, you moved both your right and left arm out parallel to the ground at about shoulder level. Would that be accurate?
Yes, it would.
Okay. I'm gonna show you a clip beginning at 52 minutes and 15 seconds to 52 minutes and 42 seconds, so a very short clip.
Go ahead.
That, and then she makes this complaint, which gets you back.
Yeah, and it's like, why do you do this to me? And I promise you, my right hand to God Almighty on the throne with Jesus next to his side, the woman is going to sit up there and say, I was drunk, I was mad, blah, 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 blah. But it's like, now I got to go through everything just for you to do that. Why did you do this to me?
So you think she's gonna come back to us?
So we saw some motions with his arms during this clip. Would that be an accurate statement?
Objection, relevancy.
Overruled, the witness may answer.
Could you explain to the jury what you observed?
So I observed Mr. Brooks move his arms to his side, above his head, his right arm almost fully above his head at points. Quite frankly, showing that arm seemed to have full range of motion.
Now, you had testified yesterday, you had seen a video or a still shot from a video, and you identified the defendant driving a red SUV. Do you recall that testimony?
Objection, leading.
Overruled, the witness may answer.
Yes, I do.
And when the defendant was telling you about his friend bringing him out in a tan Kia, I think he said, did you believe that to be true?
Objection.
Sustained. It's for the jury to determine credibility. The witness will not answer that.
Did you ever see any video of the defendant driving in a tan Kia during the time of the parade?
Objection, hearsay.
Overruled, the witness may answer that.
No, I did not.
Directing the video to 1 hour, 4 minutes, 30 seconds, and playing until 1 hour, 18 minutes, and 2 seconds.
Before we go to this clip, I know we have the witness, I've been told, and the interpreter available, so I would like to put further testimony and watching of these clips on hold. We do need to take a witness out of order in order to accommodate the interpreter that the court has arranged for. So, Detective Carpenter, you may be excused momentarily. And then if Mr. Ryan would accompany the witness, this will be Mr. Juan Marquez being called by Mr. Brooks. Yeah, Jen, can we have you guys share up there? Sorry about that. We can get another chair. And Mr. Brooks is calling Juan Marquez. Is that true, sir? Mr. Brooks, are you calling Mr. Marquez as a witness at this time?
Yeah.
All right, Mr. Marquez, if you would accompany the interpreter all the way to the witness stand. Where's my instruction? When you get there, we're going to have the interpreter sworn first.
Do you swear that you will interpret truly, accurately, completely, and impartially in accordance with the standards prescribed by law, the Code of Ethics for Court Interpreters, and Wisconsin Guidelines for Court Interpreting?
I do. Certified Spanish interpreter Patrick Ryan.
Thank you. And Mr. Marquez, would you please raise your right hand to be sworn by my clerk?
Secretaria.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sí.
Yes.
Please have a seat.
Toma asiento ahí, por favor.
Ladies and gentlemen of the jury, I have an instruction to read to you. No matter what language people speak, they have the right to have their testimony heard and understood. You are about to hear a witness in which an interpreter will translate for one of the witnesses. The interpreter is required to remain neutral. The interpreter is required to translate between English and Spanish accurately and impartially to the best of the interpreter's skill and judgment. The evidence you are to consider is only that provided through the official court interpreter. Although some of you may know the non-English language used, it is important that all jurors consider the same evidence. Therefore, you must base your decision on the evidence presented in the English translation. You must disregard any different meaning of the non-English words. You must evaluate interpreted testimony as you would any other testimony. That is, you must not give interpreted testimony any greater or lesser weight than you would if the witness had spoken English. Keep in mind that a person might speak some English without speaking it fluently. That person has the right to the services of an interpreter. Therefore, you shall not give greater or lesser weight to a person's translated testimony based on your conclusions, if any, regarding the extent to which that person speaks English. With that, sir, the first thing I will ask you to do is to state and spell your first and last names for the record.
Juan Marquez.
Juan Marquez.
Juan.
Juan.
Marquez.
Marquez.
Thank you. Go ahead, sir, you may question this witness.
Good morning, Mr. Marquez.
Buenos días, señor Marquez.
You were at the parade on November 21st, 2021, is that correct?
Usted estaba en el desfile del 21 de noviembre de 2022, ¿correcto?
Es correcto.
That is correct.
And do you recall who you were there with that day?
¿Se acuerda con quién estaba ese día?
Con mi esposa y mi hijo.
With my wife and with my son.
And were you marching in the parade that day?
¿Usted estaba caminando el desfile ese día?
Sí.
Yes.
Do you remember who you were marching with? Was it a
caminando?
particular group?
Un grupo particular?
Sí.
Yes.
Do you recall who that group was?
¿Se acuerda quién era el grupo con el cual estaba desfilando?
Sí.
Yes.
And at some point, you felt something hit your leg?
Y en un momento usted sintió que algo le pegó su pierna.
Es correcto.
That's correct.
And do you remember what that was?
¿Se acuerda quién fue?
Un vehículo.
A vehicle.
And did you see the vehicle?
¿Vio el vehículo? ¿Lo vio?
No.
No.
At some point, did you go to Freighter Hospital?
¿En algún momento usted pasó al hospital Freighter?
Sí.
Yes.
And were you interviewed by any law enforcement at that time?
¿Usted fue entrevistado por algún agente policial, policía?
Sí.
Yes.
Do you recall if it was regular officers or FBI?
¿Se acuerdan si fue un oficial regular o fue la agente de FBI?
FBI.
FBI.
Do you recall telling them that the truck was black?
¿Se acuerda que usted le
Grounds.
The objection is sustained as to leading. Please rephrase your question.
Do you remember what color you told them the truck was?
¿Se acuerda, si usted se acuerda qué color dijo él, qué color la troca fue?
No recuerdo.
I don't remember.
So it would be fair to say you don't recall seeing anything at that time?
¿Se puede decir que usted no se acuerda de nada en ese tiempo?
No.
No.
And did you at any time file a claim related to this incident?
¿En algún momento usted archivó un reclamo con respecto a este incidente?
No recuerdo.
I don't remember.
Do you know if anyone you were with filed a claim related to this incident?
¿Sabe si alguien alguien que la acompañó si archivó un reclamo con respecto a este incidente?
No lo sé.
I don't know.
Would you consider yourself an injured party in this incident?
¿Usted se considera una parte herida, lesionada debido a este incidente?
Sí.
Yes.
Any reason why you wouldn't file a claim since you considered yourself an injured party?
Por el hecho que usted
Grounds.
se considera una persona no herida durante ese incidente, ¿alguna razón por la cual no archivaría un reclamo?
There's an objection. It's sustained as to the form of the question. Please rephrase.
Por favor, diga la pregunta de nuevo.
¿Me puede repetir la pregunta?
There's an objection. You don't need to answer.
No tiene que contestar. Could you repeat the question, please?
Please rephrase, Mr.
Por favor,
Brooks.
diga la pregunta de diferente manera, señor Brooks.
It's kind of hard to rephrase.
Es un poco difícil decir la pregunta de diferente manera.
Did you intend on filing a claim related to this case?
Objection.
¿De archivar un reclamo con respecto a este caso?
Hold on. There's been an objection. The ground.
Your Honor, first of all,
Primero,
this witness testified he doesn't
Testigo testificó
recall
que
filing
no
a
se acuerda
claim,
de eso.
so I'm not sure what the relevance then would be of the question.
The question was, did he intend to?
I'll sustain the objection as to the form of the question. Please rephrase.
Do you recall at any time filing a police report?
¿Se acuerda en un momento usted de archivar un reporte de policía?
Sí.
Yes.
And was that with local law enforcement,
Eso
if
fue
you recall?
la agencia de policía local, ¿sí se acuerda?
No recuerdo.
I don't remember.
Did any law enforcement from that report follow up with you at any time?
¿Alguna representante de una agencia policíaca hizo algún tipo de seguimiento con usted en ese tiempo?
Sí.
Yes.
And do you recall what agency that was?
¿Se acuerda qué agencia lo contrató?
No.
No.
Do you recall at any time being notified that you could possibly testify in this incident?
¿Usted se acuerda que en un momento que le notificaron que en un momento usted podría testificar sobre ese incidente?
¿Me puede repetir la pregunta?
Could you repeat the question?
Sure. Do you recall at any time being notified that it was a possibility that you could testify in this incident?
¿Se acuerda que en un momento podría, si lo notificaron, que habría sido una posibilidad que usted podría testificar con respecto a ese incidente?
No.
No.
Were you ever subpoenaed in relation to this incident?
¿Lo citaron alguna vez a corte con respecto a ese incidente?
Sí.
Yes.
Do you recall who you received this subpoena from?
¿Se acuerda de quién recibió el citatorio de corte?
Del distrito de la oficina del fiscal.
From the office of the district attorney.
And do you recall when that was?
¿Se acuerda cuándo fue?
Un mes y días.
A month and a few days.
And following being subpoenaed, or following, rather, to strike that back, after receiving the subpoena, did you follow up with the district attorney's office at any time after?
Después de recibir entonces el citatorio, ¿recibió algún tipo de seguimiento por medio de la oficina fiscal después del incidente?
Sí.
Yes.
Do you recall whom you spoke with?
¿Se acuerda con quién habló?
Susan.
Susan.
Would that be referring to Attorney Opper, who is seated at this table?
¿Se refiere a Susan Opper, que está sentado a esa mesa?
Sí.
Yes.
And were you at any time informed of a plaintiff in this incident?
Objection of relevance.
Sustained.
Confirma la oposición.
You don't need to answer that
No
question.
tiene que contestar la pregunta.
Were you at any time notified that there was a plaintiff in this incident?
Objection of relevance.
The objection is sustained. The witness does not need to answer.
Do you even know if there's a plaintiff in this incident?
Objection of relevance.
The objection is sustained. The witness does not need to answer.
Do you recall ever seeing, excuse me, do you ever recall, sorry. Do you recall ever seeing or reading a complaint in this matter?
Entonces, ¿cuál es usted vio, si leyó la acusación criminal en este asunto?
No.
No.
Going back to the actual incident, would it be fair to say that at the time you were very confused?
Volviendo entonces al incidente, ¿se puede decir que en ese tiempo usted estaba bastante confundido?
¿Me puede repetir la pregunta?
Could you repeat the question?
Going back to the time of the incident at the parade, would it be fair to say that you were confused at the time?
Volviendo entonces al momento del desfile, ¿se puede decir que usted estaba confundido en ese tiempo?
No.
No.
Any reason why you don't recall seeing anything?
¿Hay alguna razón por la cual que usted no se acuerda de ver algo?
¿Me puede repetir la pregunta?
Could you repeat the question?
Any reason why you don't recall seeing anything?
¿Alguna razón por la cual que usted no se acuerda de ver nada en ese tiempo?
No vi el vehículo.
I did not see the vehicle.
Solo pasó.
It just passed by. So the interpreter needs to make a clarification on his last response. If I can inquire.
Cuando te dice que pasó el vehículo, ¿quiere decir que ocurrió el incidente o que el vehículo pasó por usted? Cuando usted dice pasó el vehículo o que pasó como ocurrió?
Ocurrió, me pegó y pasó rápido.
For clarification, the interpreter inquired if he meant the vehicle passed by or if the incident happened. The defendant, interpreter for clarification, the interpreter would like to say that he meant that it just happened, that the vehicle just hit him, rather than, I believe the interpreter translated what he said as it passed by. What he meant to say is that it actually happened, rather than passed by. So for that point of clarification for the record.
Thank you.
Also, for clarification, just so we're clear for the record, you don't recall actually seeing the vehicle.
También, sí, vamos a estar clarificando por el acta. No se acuerda que vio el vehículo.
No.
No.
No further questions.
No más preguntas.
Any questions, Attorney Basie?
Briefly.
Brevemente.
Good morning, Mr. Marquez.
Buenos días, señor Marquez.
Good morning.
On November 21st of last year, were you walking with the Catholic communities of Waukesha?
El 21 de noviembre del año pasado, desfilando con Catholic Communities of Waukesha.
Es correcto.
That's correct.
Hold on. What was the objection?
¿Qué fue la acusación?
I mean, you already
You have to
answered.
speak up. I couldn't hear what you said.
I have a code, so I can't.
Mr. Brooks, was there an objection so I can rule on
Yeah, yes, there was
On
an
what
objection.
grounds?
I can't even remember now.
Well, if you were objecting on relevance, it's relevant. His answer may stand.
It wasn't relevant, so I'll tell you that.
Mr. Marquez, if you hear the word objection, please wait until I rule on the objection before you answer. Thank you.
Gracias.
Go ahead.
Adelante.
So we did answer the question?
¿Sí contestó la pregunta?
Sí.
Yes.
Thank you.
Muy bien, gracias.
You were with your wife and your son?
¿Estaba con su esposa y su hijo?
Sí.
Yes.
And your son's name is David Marquez?
Objection leading.
¿El nombre de su hijo es David Marquez?
Overruled. You called the witness. The state may lead. Go ahead and answer.
Contesta la pregunta, por favor. Si puede contestar.
What does that mean?
Go ahead and answer, sir.
Conteste, por favor.
Sí.
Yes.
You testified that at some point you were struck by a vehicle.
Objection.
Usted testificó en un momento que usted testificó que
Overruled.
fue pegado por un vehículo.
You may answer.
Puede contestar la pregunta.
Sí.
Yes.
Did you have any warning before you were struck by the car?
Objection.
Tipo de advertencia,
Hearsay.
de aviso antes de que fue chocado por el carro. Me pongo de evidencia por referencia.
Overruled.
Anulada. La
The witness
acusación.
may answer.
Puede contestar la pregunta.
No.
No.
Did you hear a horn honking?
Escuchó
Objection.
una bocina, un claxon.
Hearsay.
¿Está sonando el vehículo? ¿Un claxon?
Overruled. The witness may answer.
Puede contestar la pregunta.
No.
No.
Sir, I'm going to show you what's been marked as State's Exhibit 161.
161.
Go ahead.
Adelante.
Can you see that picture on the screen in front of you?
¿Pantalla frente a usted? ¿Lo ve en la imagen?
Sí.
Yes.
And do you see the approximate area where you landed after the vehicle struck you?
Usted fue el área aproximado. donde
Objection
se
leading.
cayó después de que el vehículo lo
Overruled. The state may lead. It's not their witness.
No es un testigo.
Go ahead and answer, sir.
Adelante y conteste, por favor.
So I can lead too if it's not my witness?
No.
No.
Well, hold on. We'll get to that later.
Vamos a llegar a esa
There's been an objection.
Con
I'm
acusación
overruling
de
it.
anulada la acusación.
Go ahead and ask
Adelante
your
y
question.
haga
So
su
the
pregunta.
state can do what they want. Got it.
Do you see the area in which you
Donde
landed
usted
after
se
the
cayó
vehicle struck you?
Después de que el vehículo lo chocó.
Sí.
Yes.
I'd ask that this exhibit be admitted to evidence, which is 161, and published to the jury.
Objection.
Obligado, entonces 161.
We can't even see what exactly is the state referring to.
¿Qué se refiere al Estado?
You can't even see who it is.
No veo quién es.
Just state your objection.
De su
It's
oposición.
overruled
Anulada.
Of course it's gonna be overruled.
because it's attempt to testify. But if the state could just ask a few more foundational questions, please.
Certainly. When you met with the state, did you review some video of the parade?
Objection, hearsay.
Me pongo de evidencia por referencia.
Overruled. The witness may answer.
Puede contestar.
Sí.
Yes.
And after reviewing that video, were you able to determine the area in which your body landed after you were struck by the car?
Objection, hearsay, and leading.
Overruled as to both. You may answer, sir.
Después de que entonces se recibió entonces el choque del carro, determinó el área. ¿Se acuerda dónde su cuerpo quedó después de que el vehículo chocó?
Sí.
Yes.
And do you see that area on this exhibit?
Objection, leading.
Overruled. The witness may answer.
Sí.
Yes.
I'd ask that this
Every objection.
exhibit be admitted to evidence and published for the jury.
Objection, what's the relevancy?
The objections are noted. They are overruled. And Exhibit 161 is received. Permission to publish is granted.
And it's indicated that that is now being seen in the jury box. Sir, the screen in front of you is a touch screen. Can you circle the area in which you believe you landed?
Objection, leading.
Overruled. The witness may answer.
How do you say where they believe? Either you know or you don't.
The witness may answer.
Sí.
Yes.
Ridiculous.
Can you do that now?
Puede ser eso, entonces marcar el lugar donde se cayó.
That's where it just fixed the whole case.
If we can take a snapshot of that.
I don't know what Mr. Brooks just mumbled, but it's not his turn to ask questions. There was no objection. The jury will disregard that.
And this would be Exhibit 161A.
And we'll screen capture that. Exhibit 161A has been captured. Are you moving that in?
I am.
And Exhibit 161 is received. 61A. Sorry.
Thank you. And do you see anyone that you recognize standing in that area?
Objection, leading.
Overruled. The state may lead. It's cross-examination of your witness,
So I
sir.
can lead on nation then?
I direct your attention to 90611 sub
Can I
3,
lead
sir.
on cross-examination?
I'm not going to answer that. Go ahead,
So
sir. You may
judicial
answer.
determination that you don't have to answer that? If I don't understand something?
The jury will disregard the comments being made by Mr. Brooks.
Judicial determination, okay.
Go ahead and answer the question if you recall it, sir.
¿Me puede repetir la pregunta?
Could you repeat the question?
Yes. Do you see, actually, do you see David, your son, in that picture?
Objection. That was
Sí.
Yes.
And is he wearing?
So my objection is not going to be noted.
The objection is overruled. The state chose to ask a different question. That's fine.
And is he seated near some blue chairs wearing a blue jacket?
Objection, leading.
Overruled. You may answer, sir.
Sí.
Yes.
And sir, is that you laying down and you can see in this picture your legs and they're hanging into the roadway?
Objection, leading.
Witness may answer. Overruled.
Sí.
Yes.
Now, is that where you were walking when you were struck from behind?
Objection,
in that
leading.
position?
Overruled. You may answer.
No.
No.
How far from the position that you recalled yourself to be at when you were walking did you land?
Objection, leading.
Overruled. You may answer.
Entre 15 a 20 pies.
Between 15 and 20 feet.
So your body flew through the air between 15 and 20 feet. Is that
Objection,
what your testimony
leading.
is?
Sí.
Yes.
Sorry, I didn't rule on the objection, but it is overruled and his answer may stand.
Was David also struck by a vehicle during the parade?
Sí.
Yes.
Did he received injuries as well?
Objection, relevancy.
Overruled. You may answer.
Sí.
Yes.
Can you describe what your injuries were, sir?
Objection, leading.
Overruled. You may answer.
Sí.
Yes.
What were they?
Objection, leading.
Overruled.
La fíbula
My fibula
y ligamentos.
and ligaments.
Your fibula was broken?
Objection, leading. Speculative.
Overruled as to both.
That's
The
not
witness
what he
may
said.
answer.
Sí.
Yes.
And you had torn ligaments?
Objection, leading.
Overruled.
You didn't say that in the question before?
Sí.
Yes.
And were those both in the same leg?
Objection, leading.
Sí.
Sorry,
Yes.
overruled. If we
Yeah, of course.
just wait when there's an objection. I'm overruling it. It's relevant. It's not leading. The witness's answers may stand.
I mean, yeah, you overrule every objection.
And the jury will disregard the additional commentary made by Mr. Brooks at this time.
Judicial misconduct at its finest.
And which leg was that, sir?
Objection, asked and answered.
Overruled. You may answer.
El pie izquierdo.
My left leg.
Did you have to have surgery on that leg?
Objection, leading.
Overruled.
Sí.
Let's
Yes.
see what y'all
Just
trying
one?
to get here.
Dos.
Two.
That's not gonna work either.
Mr. Brooks, you are advised to stop with the commentary.
No, I'm gonna say what I want
You
to say.
called this witness. I'm going to take a break right now and excuse the jury and this witness.
All right.
What you doing is judicial misconduct. Judicial misconduct. But you don't want the jury to hear the truth. That's not fair to the jury. They have a right to hear everything. I'm not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
Mr. Brooks, please stop.
No, there ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are being
please.
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
say somebody's being disruptive because they want the truth to be out there. Man, quit it. You supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be present
and
in this courtroom.
under what law and
during
fact can you do that?
Illinois versus Allen.
Okay,
sir.
but the fourth option that you made up, that's not even in the law.
Mr.
Because
Brooks,
you can't do that.
I need to make a
By law,
ruling.
you can't do that.
I need to
And
make
you
a
know you
finding.
can't.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom. Please make sure he has his objection signed and a pad of paper.
So is that
he can.
So is that holding me in
meaningfully
contempt?
Participate, and I will make a ruling when I.
So are
after
you
we
holding
come
me in
back up.
contempt? Is that civil or criminal? BS, man. Y'all do the same thing every time, man. Every time she don't want to tell the truth to the jury, somebody got to get put out of the courtroom. That's contempt. That's contempt of court. I'm not ignorant, man.
You can just have a seat quick and get that on so you can skip these off.
BS,
Can you
man.
throw that thing forward next?
No.
Have him back up.
Okay, slide back, sir. Take 2 steps back, just so he doesn't bump your leg. There we go. Perfect. Okay, sir, have a seat. Thank you.
That's what I'm saying. You can't just make up no law, make up a fourth option. I don't want them right there, man.
You want them on the other side over on the right?
Where do you want him?
good, Becky?
Yeah.
Okay, let's get them on.
How am I supposed to move and look at my paperwork with the boxes right here?
Okay, well, let me take off the wrist restraints, and then you can put.
You want them on the other side?
Where you want them.
There you go, sir.
Thank you. Be seated. I need the state back.
Hi, this is Teresa calling from Branch 2. We would like to...
The record, Mr. Brooks has been removed to the other courtroom. The jury is not present, and the witness that was on the stand is also not present in the courtroom.
Actually, he is, Judge.
Oh, all right, then we'll have
Step him
him removed. Thank you. Thank you for that clarification. I didn't see him seated all the way back behind a couple of individuals. So this morning, Mr. Brooks, prior to the court removing him, had interrupted the court approximately 10 times prior to 10:19 a.m. Then, of course, he was removed. This does not include the repeated commentary, either under his breath but still audible for the court to hear, the jury to hear, and witnesses to hear, related to a variety of topics, including subject matter, jurisdiction, misconduct by the court, disapproval with the court's rulings. This very last witness was a witness called out of order at the request of Mr. Brooks. As I know the attorneys are well aware, and certainly this court is well aware, under 906.11, the court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following: make the interrogation and presentation effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. That's all under sub 1. Sub 2, scope of cross-examination. A witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. I frankly haven't exercised my authority under that particular subsection, I have generally relied upon sub 1. In addition, sub 3 says the following: leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And during the cross-examination of this last witness, Mr. Brooks objected almost without fail, if not without fail, to every single question asked by the state on grounds of either leading or relevance. And then when the court overruled the objections, as time went on, it seemed to me that his commentary became much more audible. He was muttering under his breath and clearly showing disrespect for the court and the proceedings. In my opinion, they're baseless objections. Again, because this witness was brought into court on a subpoena that was from Mr. Brooks, served, of course, by the state to assist with him in that regard. But the state was well within its rights to ask leading questions. It's this court's opinion that the repeated interruptions by way of baseless objections is to disrupt these proceedings, disrupt the testimony of the witnesses, and in particular, Mr. Marquez. This court has been abundantly patient this morning, noting the repeated interruptions by Mr. Brooks, starting right away at 8:31. There were a couple of interruptions, continuing at 8:37. At 8:48, I think we had a total of 5 more at that point or so. At 8:49, and then of course at 10:19, this court removed him under its authority in Illinois versus Allen. I also had warned him, or at least at times I would give the jury an admonishment, not really an admonishment, but an instruction: please disregard the commentary by Mr. Brooks. It's been very apparent that any time this jury is brought in or taken out, Mr. Brooks begins making statements that are misstatements of the law, or generally his disagreement with whatever is going on at that particular time, accusing the court of either bias or misconduct, accusing this court of hiding information from this jury. This court is not doing any such thing. I will make a finding that based upon the conduct of Mr. Brooks, that he has forfeited his right to be present during the cross-examination and any redirect of Mr. Marquez. Mr. Brooks's conduct has been anything but respectful today. It's been disruptive. As this court was stepping off the bench, he made some type of statement about contempt. Are you finding me in contempt? This court is well aware that one of the permissible ways to handle a defendant who shows flagrant disregard in the courtroom for elementary standards of proper conduct is to find a defendant in contempt. However, I'm not dealing with a defendant who is out of custody. I'm dealing with a defendant who is in custody on very serious charges, including, if convicted, facing the possibility of life sentences without the possibility of extended supervision. It is my opinion that finding him in contempt is not really a viable alternative to this court. Frankly, it would, in my opinion, it would serve to give the defendant, let me restate that. In my opinion, if this court were to find Mr. Brooks in contempt, it would allow him to profit from his own wrongdoing because it would result in a delay of these proceedings. I would have to, of course, make certain findings. One of the possibilities for contempt is to hold him in custody until such time as he's willing to abide by the rules. That is just not something this court is willing to even do because it would delay the proceedings. I am aware that that is a option identified by the Supreme Court in Illinois versus Allen, but I would remind the parties once again that Illinois versus Allen was decided in 1970. Certainly the technology that we have available in this courtroom was not something available to the parties in Illinois versus Allen. We have a very new state-of-the-art courthouse that I am operating out of. I'm in courtroom 13. Next door is courtroom 20. These are just the room numbers that I'm referring to. As you can see, we have the ability to see and hear into that courtroom, and that courtroom has the ability to see and hear into ours. I will confirm with the bailiff and the clerk that the audio is working. I'm told that it is from my clerk. If I could also get verification from the bailiffs who are in that courtroom. But we have the ability, I have the ability, through that technology for Mr. Brooks to meaningfully participate. He does have, and it was provided with him when he was taken to that courtroom, the objection sign. I also instructed that he be given a pad of paper and a writing utensil so that he could write down his objections. Or if I feel it appropriate, I can unmute and hear what his objection is. But it's my belief that the use of my ability to mute and unmute will assist the proceedings so that it's orderly, that it is free from disruption as best as I can control it under my authority under 90611 and my authority given to me and expressed by the U.S. Supreme Court in Illinois versus Allen. Although I'm making a finding that he's forfeited his right by his conduct to be present for the continued cross-examination and any redirect of Mr. Marquez, I'll also make an alternate finding that the technology that I've just described provides the functional equivalent of Mr. Brooks being present during this case. With that, I would like to have the jurors brought in. I'll have the witness brought back to the witness stand with the assistance of the interpreter, and the state can continue with its cross-exam of the witness called out of order, but on behalf of Mr. Brooks. And I am getting verification from the bailiff in the other courtroom through my bailiff here that the audio and video is working as it should. Would also like to point out that there are headphones at the table in front of Mr. Brooks should he choose to wear them. He has not worn them in quite some time. Previously made reference to needing it when he was in the other courtroom, so they are there and available. All right, would Mr. Marquez and Interpreter Ryan please take the stand, and we'll have the jury brought out. And just for the record, I will certainly let Mr. Brooks know he can ask to come back in when he's willing to abide by the rules of decorum and courtesy. The record should reflect the jury is being brought back in. Thank you, everyone. Please be seated. The record should reflect that Mr. Brooks is appearing from another courtroom. That should not affect the jury's verdict in any way. The state may continue with its cross-exam of this witness.
The state would have nothing further.
All right, Mr. Brooks, do you have any redirect for this witness? Mr. Brooks, do you have any further questions for Mr. Marquez? The record should reflect that Mr. Brooks is reading out of a book. He has not answered the question. I will ask one more time. Sir, do you have any further questions for Mr. Marquez?
Am I unmuted?
You are, you have been.
What's going on?
Do you have any redirect questions for Mr. Marquez? This is your opportunity to ask any follow-up questions that you have for this witness.
Say something. I'm trying to see if the headphones on. It's supposed to be on a certain channel. Can someone say something from the other courtroom?
Have any questions for Mr. Marquez at this time? It's your opportunity to ask follow-up questions. The state indicated it did not have any additional questions.
Nope, I don't got no follow-up question.
All right, thank you. Then, Mr. Marquez, you may step down. Thank you for being here today. All right, I need to excuse the jury momentarily. Please rise for the jury. All right, thank you. Be seated. Mr. Brooks, under Illinois versus Allen, which that case clearly tells me to do that, once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. The court is going to continue with the direct examination by the state of Detective Carpenter. I would like you to come back to this courtroom. Are you willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings?
I didn't do anything to be held in contempt in the first place.
So are you willing to abide by the rules of decorum and civility? I would direct your attention to SCR Chapter 62, which has been provided to you previously.
Does that say anything in there about me being held in contempt?
That does not, no.
So why have I been held in contempt?
I didn't hold you in contempt, sir. You are simply in a different courtroom based upon your disruptive behavior. I'm giving you the opportunity.
Has not been disruptive.
I've put my findings on the record, sir, and the record stands in that regard. I'm giving you the opportunity, if you can, indicate to this court that you will conduct yourself with courtesy and decorum. Are you willing to do that, sir?
Is Your Honor willing to tell me why I've been held in contempt?
I did not hold you in contempt, sir. I've already indicated that.
Removing me from the courtroom is like holding me in contempt.
I didn't hold you in contempt. You were removed pursuant to the authority given to me by the United States Supreme Court in Illinois versus Allen, based on your disruptive behavior.
My behavior wasn't disruptive, Your Honor. The record should be corrected in that. And as I recall you stating before, or not you stating, but us having a conversation about Illinois versus Allen for the record at one point. I got the date in my notes that we had it where I said on the record that there were three options identified. And
Mr. Brooks, I'm not going to have a debate with you on what the law means and whether you understand it or not. I'm simply asking you whether you are willing at this time to abide by the standards of courtesy and decorum that are outlined in SCR Chapter 62 and that are inherent in the concept of courts and judicial proceedings, including making proper objections based upon the rules of evidence, based upon the rules of procedure, based upon the law, that you will not interrupt when you disagree with a ruling made by the court, and that you will generally conduct yourself with dignity and decorum.
But is it not my right? Is it not my right to object?
I'm going to ask Mr. Brooks one more time if he would like to come back to this courtroom and if he's willing to conduct himself with dignity, respect, and decorum.
But for the record, I don't consent to being called that name, and I never stated that I wanted to be removed from the courtroom.
All right, I'm going to mute Mr. Brooks. He is clearly not answering my question. And given his recent conduct, I'll indicate he continues to forfeit his right to be present based upon the prior disruptive conduct. I have given him 3 opportunities to answer the question, would you like to come back into the courtroom? And in other words, to reclaim his right to be present. He has chosen not to answer that. I understand he disagrees with the characterization by this court of his conduct, but my ruling stands and the reasoning for my ruling stands. What I will advise Mr. Brooks is once the jury is brought back out and once the witness is back on the stand, I will unmute him so that he can properly object. And then I'll rule on, of course, any objections. I certainly reserve my right to use the mute function of the audiovisual capabilities that I have should that right be abused. So with that, why don't we have Detective Carpenter come on back to the stand. The jury is advised to come out.
Your Honor, I know you previously ruled that if Mr. Brooks wanted to come back into the courtroom, he could signal to a bailiff in the courtroom that he's in, that he believes he can.
Yes, thank you. He may absolutely signal to the bailiff, and then they can get that information to me, and I will promptly stop and we'll have him brought over. Thank you for that.
Thanks.
That invitation is an open invitation.
Thank you.
He wants to come back? All right. The witness can stay here. Please have the jury remain. We'll have to clear the courtroom so he can be brought back in. We'll be in recess for that. On the record, and I've advised to have the jury brought out. I'm glad you're back here, sir.
Are you, Your Honor?
I am, sir, actually.
I'm not too sure. Especially when I bring up subject matter jurisdiction.
I've ruled on that, sir.
I know, but it hasn't been proven for the record.
If you disagree with my ruling, sir, you can file an appeal.
It has to be proven on the record. Has yet to be proven on the record.
I disagree, sir. You can have it. Sheet. All rise for the jury, please. Seems to me it's hotter in here, too.
Yeah, it's kind of schizo.
Thank you, everyone. Please be seated. All right, at this time, the state may continue with its direct examination of Detective Carpenter. And let me know if you need the audio-visual right away.
I will.
Okay. You want it? It should be coming on.
Sir, regarding the interview, we've been playing a couple snippets of the interview with Mr. Brooks from Exhibit 82 that took place on November 22nd of last year. I would now direct the juror's attention to 1 hour, 4 minutes, 30 seconds.
Objection, I don't consent to being called that name for the record.
Noted.
And I'd ask that it be played till 1 hour, 18 minutes, and 2 seconds.
It's noted, but it's overruled. Go ahead.
Thank you.
So, what's your buddy's name? Can we get that? If we gotta talk to him to verify you're on the up and up and she's on some BS?
His name is Marquez.
What's his last name?
I don't know his last name.
What's his phone number?
467. Oh, wait, hope if I have my freaking phone somewhere. 467. 85 31 or 30 or something like that.
1112?
Yes, sir.
And he lives in Milwaukee?
Yes, sir.
And you guys came out here together?
Yes.
Okay, so he has.
Well, like I said, Stephanie was. She's a older mixed lady, so she's not. You know, she.
Who do you know in Waukesha other than her?
I know a guy named Terrion. I met
Terrion live.
I don't know where he lives now. I've been knowing him for maybe 5-6 years. I just know he stays in Waukesha. He comes down to Milwaukee a lot, and then he comes back up here.
How old is he?
Like 34, 35.
34.
Yeah,
Where did?
Maybe.
I
know a lot of females.
Well, how many times have you been to Terrion's house?
Once in like 2018.
Do you remember?
It was like an apartment. It wasn't a house though.
Apartment?
Yeah.
Do you remember what was near it?
I think it was like right on the main street.
What's the main street? There's a lot of streets. Like is
whatever
it
street
near downtown?
What would be considered downtown?
Where all the bars and restaurants and
It's like a
shops are.
business district. Is Stephanie's place near downtown? Is there a bunch of bars and a business district right near there?
The only thing I can remember is a gas station, like a kitty quarter gas station. I think this street is like a one-way. Whatever street is right here is like a one-way, and it's a gas station like right here.
Remember what kind of gas station? With the Mobile Speedway Quick Trip hometown.
Not a Quick Trip. Not a Speedway. Like the blue and white one.
Blue and white. Any schools or parks nearby our house? Something like that? Anything you remember like that? Trails?
I know that park. I know that park is by old girl's house.
By whose house? Stephanie's?
Yeah.
Park. What?
I don't know the name of the park, but it has like a little creek or something. It was something going on out there yesterday to where a lot of shit was blocked off.
Okay.
I don't like I said, I don't know about Waukesha. I don't know, but it seemed like everybody was at that park, kind of walking around that creek.
Like a playground type park, or like a
park. It seemed like a little creek or something. Well, I don't know if you would say a creek. What would that be? But
river?
Would that be a river? Does Waukesha have a river? Well, I know it's just a small body of water. It's like, how would I describe it?
But there were barricades blocking some shit off here there?
No, it looked like in that area.
In that area?
In that area, it looked like a bunch of shit was like blocked. You couldn't go down certain streets or some shit. I don't know, but that park is close to the old girl's house where, that's why I said, look, when our friend was like, you know, your baby mama trying to get in touch with you. And I'm like, yeah, what's up? What's she telling you? What's going on? And she was just like, well, she said she got some money for you. And I was like, why would she tell somebody else? That's what I started thinking at first. Like, that's like, why is you? Because she'll tell me the same thing. Don't tell people our business. So then when she put us in, when she merged us in, you out here, you out here, you out here. I'm like, man, yeah, but I'm like, what's up? Like, you got, yeah, I'm okay, cool. You gonna fit? No, not staying out here like that. I'm watching the game and I'm gone.
So she tell you where to meet, or you tell her where to meet?
She told me where to meet. Okay. I said, it's a gas station right here. And she was like, is it a park right there? I'm like, I don't know. Is it a park right here? They like, yeah, there's a park right down here, blah, blah, blah. I'm like, well, just meet me over there. I'll get the money from you, give you a hug, give you a kiss, and, you know, I'll call you or whatever. It wasn't supposed to be us hanging out, spending time together. It wasn't that. It wasn't supposed to be that. She got mad because I didn't want to do that. That's why I kind of figured, but like I said, I didn't see her drink. I'm not going to sit here and say I saw her drink. I'm not gonna lie on her. I didn't. But when she started acting like, yeah, you finna, that's when I kind of was like, she probably been drinking. She probably haven't just stopped drinking, but you was drinking sometime today. I know you was drinking sometime today. I didn't tell her that. I said, yeah, because she's acting too, you know what I mean? Oh, you just finna get, oh, you just think you finna get the money and leave, and you must got some bitch waiting on you, and blah, 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 blah. I'm like, see, this is why. This is why I just should have just watched the game and left, dude. Like,
all right, so.
The fuck, man.
So you came out, how did you get out here again?
My friend.
What type of car does he drive?
Oh, man. Like a Kia type of car. I don't know if it's a Kia, but it's a small four-door car like that, in that type of model.
Okay. What color is it?
Like tan.
And was it just the two of you that rolled out together? Did anyone roll out from Milwaukee with you?
No, it was just us two.
Two of us?
He said he probably was gonna be some chicks over there. You know, like I said, the Stephanie girl is an older woman. She, you know, likes to party, drink, you know, watch the game. She cooks.
Sure.
Cool, fuck it, let's watch the game. Shit, I was only gonna probably go to my mom's house and watch the game there, and my mom has to go to work. So I was just gonna be sitting there like this. Fuck it, might as well go. You know what I'm saying?
Did he offer to drive?
And at the same time, cool, I can get the money from, you know, that she been holding for me.
Yeah. Did he offer to drive? What? I mean, do you have your own car? Did he offer to
drive?
No,
I don't.
How did you guys come?
I don't own a vehicle.
Don't own a vehicle?
Nope.
Do you have any car you can drive at all?
No. I have license.
So you have a...
I do have license, but no vehicle.
Don't ever use your niece's, nephew's, mom's car or anything like that?
My nephew doesn't have a vehicle. My niece is 14.
So What about your mom?
No, my mom doesn't even know how to drive.
She doesn't have a car, doesn't know how to drive?
She doesn't know how to drive.
Does
She
have a
never
car?
learned.
Okay. Does she have a car that she lets you use at all?
No.
Does she have a car at all? Maybe that not that she lets you use.
No.
Does she have a car in her name at all?
I think she did at one point.
Does she right now?
Not that I know of.
Okay.
I'm not gonna say no because I don't know. I honestly don't know. Me and my mom we was kind of having family issues for a while, so we didn't talk for a while. Issues that didn't have nothing to do with this. It was between me and her. So we started back talking when I was in Georgia. So whatever she had going on when I was on the West Coast, coming back to Milwaukee, I don't know. But I can tell you this. My mom is 60-some years old. She's never drove. She doesn't know how to drive. She doesn't even have a license.
Okay.
She catches the bus to work, which I don't like her doing because Milwaukee.
Sure.
She has to go. She works at Freighter, so she has to go. The way her bus route goes, she has to go way up to like 92nd. Then somewhere she told me they don't even have a bus depot thing.
Mm-hmm.
So it's getting cold as shit, and it's dark out there, and she's just standing out there. And I was just like, damn, I don't want. So I'm like, you probably gonna have to change your route to catch the bus from downtown Milwaukee on Wisconsin Street, downtown Milwaukee, and then go up because I don't like her.
Sure.
Yeah, I don't like her doing that.
So you just argued a little bit, and then you're saying you walked away yesterday.
Yeah, I just told her. I'm not finna freaking. It was people out there. They would tell you, I did not put my hands on this woman. I did not push this woman. I did not choke this woman.
People
I did not kick this woman. I did not grab this woman. I did not do anything to this woman.
People out there, as in like just regular old civilians.
Just regular
or like
civilians.
People
Just regular.
that know you.
Regular civilians.
Did you meet her by yourself?
I met her by myself.
No one from the house went with you?
No one. And there was people walking up and down the street. Like I said, it was people out because it was daytime. So it wasn't like we was just in some secluded area where it was just me and her.
Mm-hmm.
It was people out there, and they.
But anybody that knows you or knows
nobody
her?
that knows me. Mm-hmm. Nobody that knows me. I don't know if it was anybody around that knows her, but I know people were walking up and down the street. People were walking around that park.
Sure.
It was like, basically, we were out in public. Like, if we was out in public, if something would have happened, people would, yo, what the hell? Like, where was we going to go to not be seen?
All right, so I might have missed this. You touched on it. You were at the gas station or the park? I know the park's nearby. You met her at the
No,
gas
I'm saying
station?
the gas station. No, I met her at the park. The gas station was by the area that we were in. The gas station is by that park.
Yeah, I'm just clarifying.
Yeah.
Okay.
Which car were you in when you met her at the...
I didn't meet her in the car. I walked right over there.
You walked?
I walked right over there to the park, and she was standing, like, right wherever this entrance to this park is. Like I said, it was people everywhere. So
Yeah.
anybody would see us standing out there. She was standing right there waiting for me. I walked up, gave her a hug, and she was just like, well, my friend has my purse, so I don't have the money and all this. I'm like, so you had me come way out here?
Like a power play or something?
That's basically was like, yeah.
Okay.
You know, you basically, you see how fast you caught on to that, and I'm just like, you had me come way out here. You know, I ain't even supposed to be around you like that. You had me come way out here to meet you. For you to try to play and shit like this, I said, no, man, I'm gone.
Yeah. So
I'm out.
It was daylight when you met up with her. Was it still daylight pretty much when you walked away from her?
Yeah, it was daylight the whole time. This was broad daylight. That's what I'm saying. Like, people outside, everything going on, people walking around the park. I'm like, anybody would have saw us talking. Anybody would have saw if anything happened. Mm-hmm. Anybody would have saw if I did something to her, she did something to me, if I ran from the scene, if I did this, anybody would have seen it.
Do you know how she got out here to meet you out here? She didn't say?
She's apparently been staying out here.
Okay. So were you,
This is what she told our mutual friend. I don't know if that's true.
all right,
I haven't talked to her and haven't seen her in like almost a month.
that's fine.
So I don't know.
You said you don't know where your phone is. We're talking your cell phone, right?
Yeah.
You're not sure. Did you leave it? Do you keep that with you? Is that your phone that you have with you all the time? Because you seem, I don't know where it is. I don't have it. You seem confused. It's missing. Is that something?
Yeah.
You take with
Well. Yeah.
you? Like if you go somewhere, do you take your phone?
Absolutely. My mom just got me that phone. It's my first ever iPhone.
Okay.
I don't know if she was using it first kind of thing, but she was just like, I got a surprise for you. No, I never had an iPhone.
Hopefully we'll find it for you. And that's the number with the 610, if I had to call you after
Yeah.
today, the 610, whatever.
Yes, sir.
Okay.
Yes, sir. That's why I was asking him. I said, man, when I told him, I said, look, y'all reaching for my ID. That's why I said, how can y'all not find my flip-flops or my phone? I had on some Green Bay Packer flip-flops because it was game day.
And we did stop at 1 hour, 18 minutes, and 2 seconds. Sir, with regard to this clip, you asked the defendant about his phone, correct?
Yes, I did.
Did you know where his phone was when you asked him if he lost it?
Objection. Hearsay.
Overruled. The witness may answer.
The phone was found inside the vehicle, so he didn't have it with him when he was taken into custody. The red Ford
Objection
Escape.
leading.
Overruled. The witness may answer.
I'm sorry. The red Ford Escape.
And in whose name was that car registered?
Dawn Woods.
And what relationship is Dawn Woods to the defendant?
Objection leading.
Overruled.
She is his mother.
Did you your questioning about the phones, what significance, if any, did that have to you? Or why did you ask him about the phone? Strike the initial question. Why did you ask Mr. Brooks about the phone?
Objection. I don't consent to being called that name.
The objection's overruled. Go ahead, you may answer.
One, to verify his contact information, but two, one, if we were to find the phone, it would help us know whether it is his. And if we were able to find a phone and we know it's his, knowing the phone number, including make and things of that nature, can help be used in location services at a later time to further verify that the suspect was, Mr. Brooks, was in Waukesha at the time when these incidents occurred.
And again, at the time that you asked these questions, did you know that the phone had been located in the car, or you did not have that information at this time?
Objection leading.
Sustained as to the form of the question.
What information at the time that you asked Mr. Brooks about the phone did you have about it?
Objection to the name.
Overruled. You may answer, sir.
Very little. At that point, I don't recall if I knew that the phone was inside of his mother's vehicle.
Okay, thank you. Now directing you to the mark of 1 hour, 19 minutes, and 20 seconds to 1 hour, 38 minutes, and 30 seconds. Let's play that portion of the interview.
That she drinks.
So after you talked to her, Darrell, where did you go? Do you have they found it was cold yesterday.
You didn't have a jacket. Did you have a jacket with you?
I didn't initially have a jacket because, like I said, I was riding with somebody else. So I figured.
But you didn't bring one in anticipation of the cold?
I didn't because I figured I'm going from the house right to wherever we're going. So it wasn't like I'm finna hang out with y'all all night type of deal. We was just supposed to be watching the game, having a few cold ones, and then I'll drop back off home.
So what happened, Darrell, where you ended up, so I know you say you're not familiar with the area. So
At all.
I'll lay this out for you. So follow me for a minute. You say you're kind of near this park. I got an idea in my head of where you're talking, based on my knowledge of the city. It's right near Stephanie's where you're hanging around watching the game and Marcus is there. You came out here with your phone, because you take it with you. How did you end up at this guy's house? Now you said when you walked away from Erica, did she go the other way? You walked away.
From what I remember, she just stood there.
Okay,
she was just standing there like.
Right.
Well,
so
whatever.
you walked away and it was over.
It was over.
It was over. How did you end up at a guy's house asking to use his phone, which is blocks away from Stephanie's? Okay, I can tell you that based on my knowledge of the city, based on approximately where you're telling me it is, without your phone in your shoes. You understand where that's kind of weird? How did you get to be over there? What happened?
Yeah, what basically happened with that was when I got back over here by old girl house, I just said, because I don't really know Stephanie like that. It's my friend's friend or partner or whatever the case may be. They was getting into it about pretty much the same thing that I was getting into it with Erica about. I was just like, him.
Who's him?
Marcus. Him, her, and whoever else, Stephanie.
Was there anyone else there other than
Yeah, at her house, yeah.
Okay.
A few girls that I didn't know, but they had already said it was gonna be people over here.
Okay. All right, so
I was pissed because I feel like I just met up with her, with my baby's mama. I just met up with her for absolutely nothing. You tell me, okay, you out here in Waukesha, I'm out here, let's meet up, I got your money, and then I walk over there and you don't have the money. Or you do or you don't, you just ain't gonna give it to me, however the case may be. So I'm just like, okay, whatever.
Well, hold on.
When I get back,
you're pissed, but
when I get back over there, I'm pissed.
Okay.
They was getting into it, and he like, man, come on, bro, we just finna go. And I'm like, what the fuck going on? Like, I just got into it with it. Now y'all into it. He like, man, this bitch tripping, whatever, let's go. I'm like, nah. No. I'm like, I'm out, dog. And I just started
Marcus
walking.
wanted to leave?
He wanted to leave, but I don't know what the fuck he was on. He probably didn't even get into it with old girl, but he out there like, man, let's just go, bro.
How long have you known Marcus?
I know Marcus for years.
Okay. I'm gonna be straight with you, because you've been asking me for that all along. That doesn't make sense. Listen to me, okay? Just listen to me. You go to this house. You leave. That wind was cold as hell.
Not at first.
Well, by the time it was getting later in the day, I mean, after the Packer game, you're talking 3:30, 4 o'clock, it was getting cold. I was outside for a while.
Yeah, it was about like 3:30, yeah.
By the time you're talking, it was getting cold. All right? Marcus is ready to leave because this bitch is being crazy. He's like, I'm out. You just went through the same experience from what you're telling us. You live in Milwaukee.
I don't know what exactly happened with him, though.
I told you to let me play it out. I know you don't know exactly what happened. But who are you going to trust more? Marcus, who you've known for years, or Stephanie? Why would you walk away, walk all the way down to where you did, leave your phone in the apartment, apparently?
No, I didn't.
Along with your
I
sandals,
didn't leave it.
and go down to where you were and not take the ride back to Milwaukee. You follow what I'm saying?
Right.
Can you understand?
I don't know if he
why
left
that
and went
doesn't
back to
make sense.
Milwaukee, though. I don't know if he did that.
But how are you going to get back if you don't get in the car?
I called an Uber. That's what I did.
So what happened? How did you get all the way to where you went? Because there's all these businesses in between where you were and where you got to. How did you end up at a random house without your shoes and your phone, Darrell?
This is what I'm saying. I had my flip-flops on. I had them.
Okay.
I just said that.
Where did they go?
I don't know. That's what I'm saying. I don't know if when they slammed me down, they just never, I don't know. I've knocked on 2 doors, not just the one.
So you had your flip-flops
I
on
had my
at
Green Bay Packer
that point.
flip-flops on, yes.
Green Bay Packer. Okay.
That's what I'm saying. I wasn't just walking around with no shoes. That didn't happen until after the fact. That's what I'm trying to say, like.
So I guess another question I would have for you is if you had your phone too, correct?
Yeah.
Okay, you didn't leave it at the apartment.
No. That's why I was telling you it should have been on the grass. Remember, I described the phone to you. I said it's black. It has a cracked screen.
Yep. Yeah, you did.
Yeah.
Why are you asking other people to use their phones? Why is that guy letting
My
you?
phone was dead.
Okay. When did it die?
I have no idea.
Okay.
And I didn't have a charger.
But you used it for the 3-way call.
No, I used his phone for the 3-way call.
Okay.
Like I said, we got a mutual friend named Michelle. Me and Erica do. I've known Michelle just as long as I've known Erica. She was the one that was telling me what's going on with you and your baby mama. Y'all not talking because she trying to get in touch with you. I said, yeah, I know she probably trying to get in touch with me. Well, I'm finna merge y'all. That's how I end up talking to her and telling her I'll walk over and meet you to get the money or whatever, give you a hug, give you a kiss, whatever. I had my flip-flops on then. I wasn't, like I said, I wasn't just, because the way he was making it seem like I was just running around with no shoes to begin with.
Right.
It's like, no.
I mean, it was pretty cold. You didn't have a jacket or a sweatshirt.
Well, I didn't have a jacket to begin with.
Okay.
I didn't have a jacket to begin with, but I'm saying my shoes, I had flip-flops.
But you had a jacket before?
I never had a jacket.
Okay.
I had flip-flops. Green Bay Packer
Flip-flops, no
flip-flops.
jacket.
Right, because I didn't feel like I was going to be, like, I'm not going to be outside. Well, I'm thinking I'm not going to be outside. If I'm just going from a car to a house, there's no reason for me to have a coat on, or at least that's how I'm thinking. I always do that. That's just like if I had a car and I know I'm finna go somewhere and I'm like, I'm just going from here to there. Well, there's no reason for me to just get all bundled up and do all this and that. There's no reason for
Were there
me.
still a bunch of people out when you left? When you left her
It
house?
was still daytime.
Okay,
It
you
was
said
still
there were a bunch of
daytime.
people when you were talking to Erica. There were still a bunch of people when you left Stephanie's.
When I was I wasn't talking.
When you left Stephanie's,
It was still daytime.
it was still daytime.
Yes.
Okay. Were there still a lot of people out?
It was
Kinda like there were?
still people out.
Okay.
It was still people out. Not a lot in that area. By the park, it was a lot of people out.
Okay.
Like I said, it looked like something was, I don't know what the hell. But it was a lot of people out. And it was, like I said, it was people, it was older couples walking down the street. It was younger people walking down the street.
It
People
looked like an event or something was going on?
I don't know, but it kind of seemed like it was a lot, like it was something going on to where it was vibrant. Because there was a lot of people everywhere.
Walking
everywhere.
up and down the street.
Everywhere. It's people. That's what I'm saying. Like, if I got into a fight with her right there, it would be impossible for somebody to not be like, hey, this guy's fighting this chick or whatever the case may be. Like, how could somebody not see something?
How long was it between leaving Stephanie's and those cops yelling at you at the door of that guy's house?
Was it dark when they yelled at you?
Yeah, by the time they came, it was dark.
Okay.
But we had been sitting out there. We had been sitting out there for a minute, me and the guy. We was sitting right there on the porch. We was just sitting there.
How long? Estimate.
Maybe 20, 30 minutes, maybe.
Okay.
It wasn't long, but it was long enough for, like, 'cause like I said, he let me use his phone. We sat on the porch. We were sitting right there, just like this, just sitting on the porch. Why call me an Uber? I called the Uber. I said, look, man, I let him know. I said, look, I ain't trying to rob you or nothing like that. Because when I knocked on the door, he kind of was like, whoa. I'm like, look, I don't got no weapons. I'm not trying to break in your house. I'm not trying to rob you. Nothing like that, dog. I just need to call an Uber. That's it. I'm not, he was just like, okay. I'll come out. Boom. I need an Uber to, what's your address? He told me the address. And we was just sitting there waiting. That's how I was going to get back home. I told him, I said, I got the money on my card. I'm not asking you for no money. I just need to use your phone. That's it. That was it. That was all. And then from there, we sat on the porch and just shot the shit out.
I'm saying, you told me last night he was cool with that. Like, he wasn't,
yeah,
he wasn't being weird. He was just like, oh yeah, I'll help you out.
Yeah, we just sat there on the porch. And he did ask me, he said, do you need a jacket? I said, no, I'm straight. Like, I'll be home as soon as the Uber come. I know it's probably going to cost me probably like $40 to get from me. I'm guessing. I don't know, but probably. But I had enough on my card to where I knew I can get home. And that was the main thing. I'm like, I'm just going home. She can keep the money or whatever. I didn't even try to contact her further. I just was like, I'm gone. I'm calling this Uber and I'm going home. That's it.
Let me ask you this, Darrell. So you weren't out in Waukesha Saturday, just Sunday.
Yes, sir.
Right? Okay. Nothing physical yesterday. Like I told you, you're a part in the investigation. There's a lot of parts, right? To any investigation. There's people we talk. Well, this domestic abuse thing I'm telling you about, right? Okay.
So wait.
Hold on. Let me go.
I'm sorry. I just had a question, but
you talked about being a religious man, right?
I could do better. I could definitely do better.
We all could.
I'm not.
We all could.
No,
That's why.
Yesterday was a mistake. I should have just freaking watched the game and just fucking went home.
Right.
Because.
And that's the thing. What do they teach us in Christianity, Darrell? That they teach us that we're broken, right? We're sinners. Even when we're born sinners. We're broken. That's why
Psalm 51,
we're so
17.
thankful for God's grace and forgiveness, right? When we ask for it. Even though we don't deserve it. But when we ask for it, He gives it. All right? You're a father. You got 3 children. 18, 14, and 7?
Yes, sir.
All right? You got a mama that raised you well. And a God you believe in.
Absolutely.
All right? And all of them are, here's the thing they'll all want, is to tell that you're telling the absolute whole truth and nothing but the truth, right?
Absolutely.
So help you God, right?
Absolutely.
Sound familiar? We've all heard that, right? And I just have concerns if I fact check that Darrell's not telling me the truth. You don't have a car, so Marcus had to bring you out. You don't own a car, your mom doesn't own a car, right? So Marcus had to bring you out. So why did we find you with a car key in your pocket?
It wasn't in my pocket. I don't even know where they said that was laying on the ground.
That's yours.
Yeah. It should have been by my ID.
Yeah, it's yours. It's your car key, okay? Because it goes to a Ford Escape in your mom's name covered in Waukesha. Okay. Listen, Darrell. I'm trying to be as open and honest with you as I can be. I'm Christian too, and believe me, I'm not perfect. And neither are you. And I'm not calling you a terrible man. I'm not saying you were out yesterday hunting, and just let me finish. But you did not walk to that house. You did not walk to that house. You did not come here in a tan Kia. You didn't.
In a who?
You did not come out here in a tan Kia. Okay? You got a key in your pocket to a car in your mom's name. Okay? And that key works for that car. For the love of God, Marcus. For yourself, for your family. You know what happened yesterday. For the people. Tell me what happened.
With what?
With the car.
What am I being
with your mom's car? You were driving goofy. People called in. You drove out of there in your mom's car, the red car. You're driving a little silly, probably because you're pissed. You met up with Erica in the car at the park. Now, initially, I believe you told us the gas station. Do I have that right? And then you changed it to the park. So that's an
No, I said the house was by the gas station. When you said what was by.
You said you went and it was by a gas station. That's where you met her.
No. I said I met her at the park.
Okay.
At a
Well,
creek.
you met her,
I did say that.
You met her at the park in your mom's car, a red Ford Escape. She got in. You talked. And what you're telling me seems pretty consistent, that there was nothing physical between the two of you.
No.
But you met her in the car.
I didn't put my hands on her or nothing.
But you met her in the car.
What's going on, man?
Asking you a question.
You
were out there
just tell
driving
me
kind of
what's going
crazy.
on,
Some
man.
people said you were driving kind of crazy. We got reports of it. You got the key. You got the car. Did you take the car, or did your mom give you the car? I know you know what car I'm talking about.
I just want to know. So
some people
now
reported,
listen,
you had all those
okay,
people out there that
no.
reported that car driving a bit erratic.
I know what you're saying. All I'm saying is this. We all been straight up with each other. You knew it was more to what you was asking me yesterday.
Didn't know
That
for
would
sure.
explain the FBI and all that, right?
They're not here today. So if it's that big a deal, you don't see them here today.
Come on, Kurt. Hey, we been.
You guys met in the car in the park.
We been cool, man, the whole time. If I did something wrong,
That's why they were here. But do you see them here today? They're not here today.
Yeah, but y'all lied to me, man. You made it seem like they just come for no reason.
Well, here's the thing, Darrell.
And I'm like, what
Hey,
if it's
listen to
that?
me for a minute.
I apologize.
I can give you a clean slate here.
I apologize.
Because you have lied to us as well. Because you came out here in the red Ford Escape. Okay, that is what you came out here in. You had the key. Alright? So what I want to do is try to give us all a chance to reset. You understand what I'm saying? Start over. Because you're not giving us an accurate story. You didn't ride out with Marcus in a tan car. You said your mom doesn't have a car. I've just told you we've disproven that. All right? I don't know what kind of woman she is. I don't know what y'all been through. But you were seen in the car driving kind of acting a fool. Okay? In basically the same area that you've already been able to describe to me. I'm just trying to figure out how and why it happened. What made you tear out of there? What made you so mad where you're like, fuck it, and you raced on out of there? And then people go, man, this guy's, he's driving around here kind of fast.
All I want to know, like I said, y'all been cool with me. Am I charged with anything? That's all I want to know. I'll tell you anything you want to know.
Right now.
Listen. I was.
You were driving a bit
so,
reckless.
Listen,
Might be an OWI.
Listen. No, I don't drink.
You said you had a couple cold ones during the game.
No, yeah, but I'm saying the hard alcohol is not my thing. I was not drunk. When you get the
And the video stopped at 1 hour, 38 minutes, 30 seconds. Detective, can you explain what was occurring here during this clip?
Objection. Excuse me. The objection's noted. It's overruled. Go ahead. You may answer.
So in this clip here, my goal and intentions were with Mr. Brooks to start getting into the details of him driving the red Ford Escape through the parade route, and to begin confronting him with information about the Ford Escape key that had been found in his pocket. Obviously, to this point, Mr. Brooks had told us his mother didn't have a vehicle that she let him use. He didn't know if she had one at all. The vehicle was in his name.
So is it in his name?
I'm sorry, in his mother's name, Mrs. Woods, Dawn Woods. He had stated he didn't have a vehicle at all.
Objection, leading.
The previous objection, it's noted, it's overruled. The witness may continue.
He had made statements earlier in the interview he didn't have a vehicle at all, that he had ridden out in the Kia, which is not true. The investigation showed Mr. Brooks came out here in the red Ford Escape by himself, so he was in fact in possession of a vehicle. He was in fact driving a vehicle. In regards to the area, you know, it should be known that Mr. Brooks's description of the park, Frame Park is the park where I should say people in the parade, whoever they might have been, lined up. They were lining up at Frame Park. Frame Park is a park that has a body of water, as Mr. Brooks described, more specifically the Fox River running through it. So he was able to describe that park. There were people everywhere walking up and down the street, just as he said. Streets were closed off via barricades, via marked squad cars, via police tape. So he was able to describe that, and the way he described the area was exactly almost how the area looked with the parade. It was extremely crowded due to the people marching in the parade. It was in fact shown to be daylight when Mr. Brooks met with Miss Patterson and then departed from Miss Patterson. That is something we learned, and I was able to confirm that based on how he described it. And you know, furthermore, you know, he describes and he gives the impression, Mr. Brooks does, that, well, if I was in a domestic, someone would have seen it. Someone would have seen it because there were all the people there, and there were, but it's not necessarily going to be seen as easily as Mr. Brooks was trying to lead me to believe, because it took place inside of the vehicle. Mr. Brooks did not walk to the park to meet Miss Patterson. That was proven as evidence in this investigation. He drove there and met up with her in Dawn Woods' red Ford Escape, which is the same vehicle after departing the park, drove along Main Street in Waukesha through the parade route.
The key found in the defendant's pocket, did that operate the red Ford Escape that was eventually located, that was registered to Dawn Woods?
Objection. That's been answered numerous times.
Overruled. The witness may answer.
There's never any depiction of a key being found in the defendant's pocket.
The objection is noted. It's overruled. The witness may answer.
Yes, it did. And you know, as we discussed the key more, you can even hear in there that Mr. Brooks acknowledges it should have been near his ID.
And was his ID also found in his pocket? Do you know?
Objection.
Yes, it was.
Leading.
Please wait till I rule on the objection. Sustained as to the form of the question. I'll strike the last answer. Please rephrase.
Where was that, his ID found?
In his pocket.
Thank you. And the information you had, where was the key found?
Objection. Leading.
Overruled.
Objections. Hearsay.
Overruled. The witness may answer.
The key was found in his pocket.
Yeah, how do you know that?
Now, you also talked to Mr. Brooks about his phone. Where did he say his phone was?
According to Mr. Brooks, at this point, the phone should have been near him. I believe he said in the grass.
And what did you take that to mean? It should have been near him in the grass.
Objection. That was never stated.
Overruled. The witness may answer.
I would interpret it as right next to him, where he was arrested.
Okay, that's what it's just where he was arrested?
Yes.
Objection. Leading.
Overruled. The answer may be given.
Yes.
After the defendant met with Erica Patterson, what did he describe his emotion as being?
Angry, frustrated over the fact that Miss Patterson brought him to the park and did not have the money to provide him that she indicated to him prior to that she would have.
Where did he say his flip-flops were?
Objection. Answer.
Overruled. The witness may answer.
Well, when he indicated that he departed Stephanie's house, they were on his feet. However, during the course of his arrest, he indicates he doesn't know where they went. So somehow, apparently, they, I guess according to Mr. Brooks, disappeared.
Now, the clothes that the defendant's wearing in this video, specifically the red shirt, was that a shirt that was provided to him by law enforcement?
Objection. Hearsay.
Overruled. The witness may answer.
No, ma'am, that's the same shirt he was wearing at the time of his arrest.
Did he indicate to you during this interview whether or not he had a coat?
Objection. So on the video.
Overruled. The witness may answer.
Mr. Brooks indicated that he did not.
And how long did he say he was on the porch with the homeowner whose house he was arrested at?
Objection. Relevancy.
Overruled. The witness may answer.
I believe it was like 20 to 30 minutes.
The weather that evening, was that an appropriate shirt to be wearing for 20 to 30 minutes outside?
Objection. Relevancy.
Overruled. The witness may answer.
No, it was not.
So now direct your attention to the video. I'd like to play 1 hour 40 minutes, 0 seconds, to 1 hour 41 minutes and 30 seconds. If we may play that now. Go ahead.
Did not touch her.
Right, so what had you so mad? Because you had your mom's car. Or I don't know if you use it. Who uses it? You got the key in the car. Is it hers? Is it yours that she lets you use? Let's clean that part up. Whose car is it?
It's my mom's car.
Okay. How often do you drive it?
Not very much.
It's the red Ford Escape?
It's all I want to know. Please. Just please. Whatever you can't tell me, I understand. I understand. All I want to know, just so I can have a peace of mind, just for my girls, man. What am I looking at?
Well, the fact you were kind of racing around up and down the street. That's the first part. Right? So, we're not quite there yet. I'm trying to figure out if I've got all my facts right first. So, this wasn't a three-way call. Let's back up to there for a second. How did you come to meet her in the park?
So y'all can't tell me nothing?
Well, you were driving.
And the video stopped at 1 hour 41 minutes and 30 seconds. Sir, is this the first time in this interview that Mr. Brooks acknowledged knowing about the red Ford Escape?
Objection. Leading, and that was not stated.
The objection's noted. It's overruled. The witness may answer.
I don't consent to being called that name for the record.
Overruled.
Yes, that is the first time.
Now, again, Mr. Brooks is asking about the charges. Did you recall seeing that on this clip as well as a clip contained within 1 hour 19 minutes and 20 seconds and 1 hour 38 minutes and 30 seconds?
Objection. Leading and compound questions.
Overruled. The witness may answer.
Yes, I recall that.
And again, what was the significance of that question in terms of timing of both clips?
Objection leading.
Overruled. The witness may answer.
Well, to that point, I've been talking about the domestic abuse incident with Mr. Brooks, and I started talking to him about driving and just driving kind of fast. I had not noted to Mr. Brooks yet at that point that he had struck anybody. It seemed to me, based on Mr. Brooks's behavior, reasonable to believe that Mr. Brooks, it was clear to me he could remember something else happening, and I could sense what Mr. Brooks was attempting to do at that point was draw out of me more information. And again, as I stated in my earlier testimony, to gauge his truthfulness, I wanted to hear what he had to tell me about the incident before giving him too much specific detail. At this point, Mr. Brooks, for example, Miss Woods' vehicle, he indicated she did not own one. He had lied to me. There is the risk if I start giving him too much specific information, he's going to create a lie about what I gave him, and so on. So Mr. Brooks kept insisting to know the charges before talking to me, but for the integrity of the investigation, that was something I couldn't and wouldn't provide him.
Direct your attention to 1 hour, 44 minutes, 30 seconds, and playing until 1 hour, 45 minutes, and 35 seconds. It is at 1 hour, 44 minutes, 30 seconds now. I'd ask that it be played. Go ahead.
Objection.
I want to tell you that, you're charged with XYZ. If you didn't do XYZ, we got to correct it. It's all fact gathering.
I just feel like y'all know more than what y'all say though, and that's what has me like why should I cooperate when there's no cooperation with me? Nothing I'm saying is gonna help me.
I mean, like, it doesn't make sense to you that we're trying to gather the facts.
Yeah, he did.
Right.
I mean, I'm not saying it doesn't make sense,
Okay.
what you guys are doing. I'm just saying I don't want to get railroaded by people not being honest. That's all I'm saying. And if I don't know what I'm looking at, it's like, what the hell? Like, why should I just sit here and be like, oh, this is everything and blah 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 blah, and then people come back and be like, okay, now so now we're gonna charge you with this and this and this and this and this when y'all knew this from the door.
Well, we don't know that we're gonna charge you. That's again the fact.
And it's like,
we're asking the questions about, you know what I mean? That's why we're.
What's going on here, sir? Oh, I'm sorry. For the record, it stopped at 1 hour, 45 minutes, and 36 seconds.
Thank you. Go ahead, you may answer.
So at this point, Mr. Brooks is still continuing to try to determine what exactly he's being charged with, and another part of this investigation is it was so broad. I didn't know exactly what some of those charges even were going to be. I had an idea, but I didn't know exactly. And in reality, what we wanted to know at that point is where he drove, have him tell us where he drove and why he did it. But Mr. Brooks just was not willing to indicate that to us and explain that to us without us telling him what specific charges he was looking at. And this is a theme that continued over the next several hours.
Direct your attention to 1 hour, 49 minutes, and 36 seconds, playing until 1 hour, 54 minutes, and 30 seconds. And it is starting at 1 hour, 49 minutes, and 36 seconds.
Go ahead.
So your issue right now with us is you feel like we're not sharing.
I'm getting railroaded.
Okay.
I know I am. No, y'all not telling me what's really going on.
But we're not getting the full truth either.
I know, but and what I was saying was,
I didn't give that an issue. So when you left, you guys met in the car. You didn't walk there. She got in the car.
If I tell you everything that happened, and y'all gonna be straight up with me about what I'm facing. That's all I want to know.
Well,
I don't want to know anything else. I don't need you guys to tell me, hey man, this is this, that is that, this is this. I just want to know. Just for the fact that, like I said, my girls.
Yeah, no, I got you. I don't know the entirety right now. So while I'm here, a couple of officers talked to Erica. I'm not the only one working on it, so I don't know everything. I got a report to a boss, so I don't know exactly everything that's going to be yet. And that part's not a lie. I don't know exactly everything that's going to be yet. I'm just trying to figure out to get to that point where I can have a clear idea and call who I need to call to get some of the information to find that all out. I'm trying to get a clear idea of what really happened regarding you and her. And when you drove away, where you were going. Or did you not know? You know what I'm saying? Because right now, I don't know everything.
Wow.
Because I'm out here and they're out there. Oh, Waukesha.
Right, and I'm like, how long do I gotta sit in these, where are we at?
Skigo.
How long do I gotta sit in this jail before I can call somebody? Get a phone call, let my daughters know, hey man, I don't know what's going on, but it's good to hear your voice. Are y'all okay?
Yeah, we're trying to get to that point, Darrell, but the question I asked you when you left, where were you going? Did you know or did you not know? Were you just mad and you left? Where were you going when you initially drove off? That's an easy, if you didn't know where the hell you were going, or you didn't have an idea, or you didn't have a particular destination in mind, so be it. And we've been talking a couple hours. You want to sit and eat a minute?
I wish they had some Tylenol. I've been trying to fight this pain, man, since.
They might, I don't know.
They show. I
don't know how. Did you ask them?
Yes.
So they don't?
They just said they'll see.
Okay.
We'll see. It hurt worse now than it did yesterday, or last night, rather.
Yeah, it's going to be sore.
It's definitely sore.
There's no doubt about that.
Oh, my God.
Take a break and see if we can round up some Tylenol, let him eat.
Yeah, we can see if we can. How about we see if we want me to see if I can find some?
Yeah, I just wanted to.
Let me see if I can find some.
It's so many things going through my mind right now. The pain, I didn't even know she called the word.
She didn't call.
Called the cops or.
Yeah, someone else did. I know you said you lost your phone, or you didn't know where it went dead, and now you don't know where it is. If we find it, so we know it's yours, can get it back to you. I know you said it's cracked, but
no. Well, the screen is cracked, but it has a. I don't think it went all the way to the
what's
glass.
The code, so we know it's yours, and if we can try to return it.
It doesn't have a number code. It has. You have to.
Can you draw it?
Do it with that.
Can you draw it?
It's dead. It's not even gonna turn on.
Well, yeah, but
we don't want to give it to somebody else.
We don't want to give it to somebody else. It's like.
It's a 7.
Typically, it's 6.
The phone is dead, so.
Like I said, we can charge it. I don't want somebody else to say, "Oh, that's my phone." Now we're giving your property to somebody else.
Wait a minute. So that sounds like y'all got my phone.
If we find it, I didn't say we had. I said if we find it.
It's a 7.
All right. So in that direction. Okay. All right. So this way down. Okay. No, I don't know if they have it now, but if we find it, you don't have it, so I would think it'd be somewhere in the area of that house.
And the video stopped at 1 hour, 54 minutes, 30 seconds. Can you explain to the jury what just happened in this clip?
Objection leading.
Overrule. The witness may answer.
So in this clip, there's a couple things. First, obviously, the conversation with Mr. Brooks at this point has gotten into the parade issue, the driving issue, which is a little bit more serious. I noted that for the first time in a long time, he began bringing up pain in his shoulder again, something he hadn't been doing for quite some time up to that point. It seemed and felt deceptive, as if it was perhaps a stalling tactic. The other issue became, in the context, was the phone. So the phone that we ultimately recovered from Mr. Brooks One was an Apple iPhone. That is the code I was specifically requesting from Mr. Brooks at this point. We have forensic analysts who download electronic devices. Those could be DVR systems, computers, but most oftentimes in our technology today, they're cell phones. And when I provided that code to Detective David Fine, who does that type of work, he indicated that could not be the code, as the Apple iPhones did not have swipe codes. They should have had numeric or facial recognition.
Thank you. Directing you now to 2 hours, 2 minutes, 30 seconds, and playing until 2 hours, 5 minutes, and 45 seconds. And it is starting at 2:02:30.
For me to look forward to, but it's like this woman, man, and I love her to death, man. I want her to be my wife, man, but I just wish somebody could tell her that. Like, I wish somebody could really tell her, like, man, this dude loves you, man. Why are you doing this to this guy, man? He literally wants to marry you. 16 years, man, off and on. I'm not gonna go mess with nobody else, man. That's the person that I want to be with, but I'm not gonna continue to be the scapegoat because you want to drink. And when you know I don't, you making it seem like I just beat up on you. Like I'm just like you're a punching bag or something. I don't wake up and be like, oh, bitch, I'm gonna hit you. Well, I'm like, what? Mm-hmm. It's like almost like I'm demonized here. Like,
I'm not saying you're a demon.
No, not you. Not y'all saying that. But it's just, I feel that way because
you're trying to just.
I know you heard that. Oh my God. Oh, that fucking hurt.
Sure.
I know you heard that.
I heard it. It's in check.
We're gonna go check with them. Maybe they'll listen to us a little bit better.
Fuck.
You want us to check?
Yeah. Oh my God.
Yeah, give us a minute. See what we got.
Dude, it gotta be something wrong, man. How in the hell does it?
Sometimes sprains will pop too.
Yeah, but why is it hurting like this? And they say there's nothing. Dude.
Because sprains can actually be more painful than a break. So
whatever they did, it hurt so bad.
Mm-hmm. You want to keep the food? Why don't you keep the food and the soda and we'll be back in a few
God.
Yeah. I think we got that Tylenol. We'll be right with you.
And the clip ended at 2:05:45. Can you describe for the jury what you saw here?
Yes, ma'am. So what I noted is that Mr. Brooks initially, as we're in the room, continues to suggest that he's in severe pain. And once we're out of the room, there's no more groaning. There's no more grabbing of his shoulder. Rather, there's an interest in looking at the paperwork that's left behind and attempting to use the phone. As soon as that door opens, Mr. Brooks then suddenly places his face into his hands and is suddenly in despair again.
Okay, moving to 2 hours, 49 minutes, 0 seconds, and playing till 2 hours, 50 minutes, 40 seconds. And we are at now 2 hours, 49 minutes, 0 seconds.
So this is my thing between me and you, man. What if it wasn't me driving?
What if it wasn't you?
What if it was my mom's truck,
Mm-hmm.
but I wasn't driving?
Mm-hmm. What if it was you?
What if it wasn't me?
Mm-hmm. Who else would it be?
That's what I'm asking. Not asking you who else would it be, but I'm just asking, what if I knew?
Mm-hmm.
Would I be asked to give that information?
Well, like I said, we're here to gather truth. So if somebody else was driving that car, yeah, I would want to know who that car is so we can go talk to that person. But a huge part of that is going to be your honesty with it.
Right. No, I was just asking, because you just asking.
You've already figured out you're not an idiot. You're not a dumb man. You're a smart guy.
Right.
I see that. You know that we've been working on this.
The video stopped at 2 hours, 50 minutes, 40 seconds. What's going on here?
Overruled the witness. May I answer?
So at this point, Mr. Brooks, I've stepped out of the room, is offering up to Detective Stern that there's a possibility that someone else may have been driving the vehicle. Now, when asked about that, as we can see, he pretends he doesn't know who that person would be. It's untruthfulness, it's deception.
Hold on a second. I'm going to advise the witness to refrain from characterizing what Mr. Brooks is saying or not saying. It is solely up to this jury to determine credibility of any of the witnesses and the believability of even any statements made during these interviews. And I'm going to strike that characterization from the record. Please ask another question.
So this interview goes on for another 2+ hours, is that correct?
Yes.
Objection, leading.
Overruled, it's foundational. At this point, the witness may answer.
Yes.
Does Mr. Brooks at any time ever tell you that someone else is driving his mom's red SUV?
Objection, I don't consent to being called that name.
Overruled, the witness may answer.
Leading the witness.
Overruled, the witness may answer.
No other individual or no other name is ever provided.
Thank you. I now direct you to 2 hours, 57 minutes, 30 seconds, playing till 3 hours, 5 minutes, 41 seconds. It is now at 2 hours, 57 minutes, 30 seconds, and as the video commence.
It's hurtful.
So you brought that up, where you don't want to see anybody.
What are those?
I'll show you in a minute.
Oh, okay.
You don't want to see anybody get hurt, or sorry, you don't want to see anybody get charged for something they didn't do. But you already brought up too that if somebody did something, that they should be held accountable for it, and that you're willing to accept responsibility.
What's going on with
if
that?
it's?
Can I show you something?
You look like you gotta film me or something.
No, I'm not filming you. That you? That's you.
Nah, I ain't got no, it look like whoever, it look like Gray.
Right there. You can see your face.
Nah, that's not me.
That's not you.
That's not me.
That's not you.
No, I don't.
Darrell.
That's a
Darrell. That's you.
That's you, Darrell.
Why you say it like that, man?
Because we talked about the honesty piece. You keep telling me that you tell the truth when you did do something. And you take responsibility when you do something.
There's your mom's car again. There's your mom's car again. Next to a child, which I know you care a lot about, children.
Next to a child, from somebody.
Yeah. Uh-huh. It's your mom's car.
Yeah, I was just asking him about about.
That's your mom's car
What's going on with that?
that we took the key for from you. So, you can't tell me at this point I'm playing any games anymore, you know?
I didn't say you was playing games from the get-go.
Well, you felt like
Just
we were being totally straight.
last night I felt like
It wasn't
y'all-
as fluid
y'all
as
knew
you
more.
wanted.
No, it wasn't the flu. It was just
And it wasn't as much as I wanted either.
I knew that y'all knew more than what y'all was saying, and I felt like last night with that whole, them coming in the way they did, and because I'm sitting there in the thing and I'm watching them walk past, like, what in the hell? And seeing that, I just felt like, okay, y'all already know what y'all want to do, what y'all, you know what I'm saying? Y'all just want. I didn't know what y'all want. It just seemed like y'all knew more than what y'all was gonna tell me. It was more so like I feel like I was being railroaded to be like, okay, tell me this, but we already know over here what we gonna do. We already know what we're gonna do right here. We just want you to tell them yourself and say you did this and did that, so we can already justify what we already want to do. And it's like, I don't feel like that's fair.
What time did you come out here with the car? What time did you head out from Milwaukee to Waukesha?
I don't want to talk, man. I don't want to talk if I'm not getting nothing.
I just showed you 3 pictures.
Okay,
man.
you showed me pictures, but you're not telling me what I'm facing.
You know what you're facing.
I don't. That's the hope. That's why I keep asking.
You drove down a parade route. You got a pretty good idea what you're facing.
You see what I'm saying? So now this is more stuff coming out, man.
Yep, we told you we were looking for that explanation.
And that's you.
And all I'm saying is,
behind the
look,
wheel.
all somebody got to do is just tell me what I'm facing. I'll tell you guys whatever you want to know.
Okay, there it
I
is.
said that 3-4
There it
times.
There it is.
And it's like, yo,
So, Darrell, what were you thinking when you went driving through this parade?
what am I facing? That's all I want to know. I don't have no
got-
problem talking with you guys.
You got people injured that had to go to the hospital.
So they're saying I injured somebody, or you're saying I
You
injured
did.
somebody.
Yeah.
So I'm looking at what, reckless endangerment?
The very least, yeah.
The very least.
People got hurt. That's reckless endangerment. I don't know exactly what they're going to classify it. Yeah, people had legs broken.
Endangerment's where you may have hurt somebody by your actions. You did hurt somebody by your actions.
So what am I being charged with? That's what I'm trying to say.
I don't know exactly
We're
yet.
still working that out. That's
I
what
don't
we're
know
talking
all
about.
of the details. You're not going to get that out of me. I'm sorry. I'm explaining to you. You're driving down there. You're looking at people got hurt. People got some broken legs.
And y'all saying that's me.
I know that's you.
How you know that's you?
Because I can recognize you. I can tell it's you. And that's your mom's car, which you had the key for. I can ID you, Darrell. I'm just asking you to be honest about it.
Be honest about what I'm facing.
What do you think you're facing?
I don't.
What
All I
should you
said
be
is
facing? What do you think hypothetically? I mean, you've been through this gamut before.
right, and y'all knew I was getting charged with this from day one. So why y'all couldn't just charge me and take me to county jail where y'all was gonna take me, man?
Because we
Because
wanted those
that-
answers.
yeah,
Because you wanted me to tell them myself.
Because
That's
that
basically what y'all wanted me to do.
You told us that
was
there was
complete.
reasons for everything.
No, I'm saying, but, and I'm not
Tell me
trying
what
to,
the
because
reason
y'all
is.
still, I'm not tripping with y'all, because y'all been straight up. So I'm not, but I'm saying, come
You are
on, dude,
tripping.
if y'all knew this already, why y'all just didn't take me to, why y'all just didn't do what y'all had to do?
Here's where you're at right now.
And
Darrell.
it's like, you take me through the
Here's where you're
runaround
at,
to get me to do something that y'all already,
Can I speak? Here's where you're at. Okay. I'll tell you straight. Here's where you're at. One of 2 people did this. And
and I mean that from a human perspective. There's the God-fearing Christian who loves his kids and his mom that you say you are, and I want to believe you are, and in many ways you've presented yourself as, who went out, got in a fight with his girl, argument, whatever you want to call it, and went and just done screwed up. Or there's the malicious guy. The malicious guy who has lied to me about his love for God, who's lied to me about his love for his mother, who's lied to me about his love for his children.
Don't spin it, man.
It's one of those two people, man.
I'm just saying, don't
what
spin
is it
it.
then?
Don't spin it, man, because I'm not.
Which one are you?
You're not gonna spin it, dude.
Which guy are you?
I'm the God-fearing guy that you've been talking to since last night,
Then
man.
tell me the truth about
And you know that.
driving down
And you
that
know
road.
that.
Then tell
you
me
know
the
that.
truth about driving down that
Tell
road.
me what I'm facing.
I've just told you some of what you're facing.
Some. Reckless endangerment. That's almost like saying I killed somebody.
No, you want me to give you the entire case without
You don't
giving
have
me
to.
anything, and I'm
No,
not
I'm
going
not.
to do that.
That's not what
I'm
I'm
not
asking.
going to do that.
That's not what I'm asking.
Yes, you are.
No,
From
I'm
my
not.
perspective.
No, I'm
Remember when
not.
I talked to you about perspective?
I'm not.
Remember when I talked to you about perspective? Truth somewhere in the middle, all that?
Yeah.
That's how
yeah.
I see what
And
you're
saying
asking
you
me.
got me doing all this and that, but y'all sit up here and come in here. Well, I'm not blaming it on you guys. I'm not. But y'all sit up here. The police do this every single time. Even when you try to be, look.
Show me
you try,
the guy
you
say
try to be straight up with them. You try to tell them the truth. You try to do all this and that, and they still railroad you.
You're not trying
every
to tell me the truth.
single time.
You're not trying to tell me the truth.
Not anymore. It's not even, no, it don't got nothing to do with that, because I just told you, I don't have a problem with telling you everything you want to know. I just wanted to have an idea. I just wanted to have an idea. That's all I said last night.
You know what I want to know.
And that's all I said today.
You know what happens.
Okay, what am I being charged with? What are y'all going to charge me? What are y'all going to recommend? What are y'all going to do? Because at the end of the day, I'm still, this is why I feel the way I feel.
The video stopped at 3 hours, 5 minutes, 41 seconds. Sir, you had walked into this room, or I believe you had presented a cell phone to Mr. Brooks. Do you recall that in the video?
Show that on the video.
There's been an objection. I'm going to sustain it and just ask you to lay a better foundation.
Sure. Sir, you came in and you had your cell phone with you, is that correct?
Yes, it is.
Did you receive any additional information when you and Detective Stern went out of the room prior to this clip?
Objection. Relevancy.
Overruled. The witness may answer.
Yes, I did.
What information did you receive?
Objection leading.
Overruled.
Specifically the photographs that I brought into the room.
Okay. And what was on your phone?
Objection.
Overruled.
Relevancy. Can't see what's on the phone from the video.
Overruled. The witness may answer. You can ask him on cross-examination if you have questions.
So the video, or the photo I showed on the phone, if you look at the monitor right now, as I'm facing it, if you face it up there, the right half
And you can,
is,
it's a touch screen, so if you want to circle something or point to something, and you can use your finger.
Your finger, not that
Yeah,
tool. That
sorry.
tool doesn't work.
sorry, I kind of drew over it, but that half of the paper is a photograph that I was able to positively identify as Darrell Brooks, the defendant, behind the wheel of the red Ford Escape while it was in the middle of the parade route. That picture was the same one that was on the phone when I showed it to him.
Okay.
How do we know that?
You will be able to cross-examine the witness. That statement by Mr. Brooks is, I'm directing the jury to disregard, as it's not proper testimony. Go ahead, next question.
I apologize, Your Honor.
Thank you, I appreciate that.
What were the other, what was on the other papers that you put down on the table?
So the other papers, one of them was Mr. Brooks' vehicle shortly after it had entered the parade route. That is where I specify to him he's driving past a child. There's a child towards the passenger side of the vehicle. Another one is the vehicle where it was located parked on Maple Avenue within the city. I would also note that when you look at those photos carefully, the initial one as Mr. Brooks is entering the route and passing by this child, you can see the vehicle is undamaged, where the second one I showed him where it's parked is significantly damaged on the front end.
Were those the photos, all the photos that you showed him at this time?
At that point, yes, they were.
Okay. Now, he had said twice in this, I don't know if you recall, I will tell you what you want to know. Do you recall that being stated by Mr. Brooks?
Objection, leading.
Overruled. You may answer.
Yes, ma'am, I do.
What did you want to know?
I wanted to know why he drove through the route. I wanted to know what caused him to make that decision, what was going through his mind. The evidence at that point, and this is evidence, as I'm stating, it indicated his mother's vehicle drove through the route, that he was the individual driving through the parade route when the vehicle went through the route, and I was looking for explanations. Why? Intent, motive, whatever it might be, for him to tell me, and he's not willing to do that.
This video goes on for another hour and 50 minutes. Did he ever answer that question?
Objection, speculative.
Overruled. The witness may answer.
No, he did not.
Direct your attention to the video at 3 hours, 5 minutes, 57 seconds to 3 hours, 13 minutes, and 58 seconds. It is now starting at 3 hours, 5 minutes, 57 seconds.
Go ahead.
He'll probably go before a judge, right? What do you want him to think?
I mean, it's nothing I can have him think, because y'all already basically said, okay, this is what happened. We just want you to tell us that this is what happened, so we can just charge you with this, which we're going to charge you with.
Are you the good guy that screwed up, or the evil guy that doesn't care?
Oh, I definitely care. I definitely care. I definitely care. Why would you try to spin it like that? Just because I don't want to tell you something, now I don't care, now I'm the malicious guy, now I'm this, now I'm that, just because I don't want to talk?
One other option, you know the truth. We've been talking for a couple
Y'all
of
apparently know the truth too.
Apparently. I told you when we came in, it was to get
Man,
your
you knew this
perspective and
last
your side.
night. Come on, Kurt, you knew this last night, man.
This was,
You
I told
knew
you
this
that.
last
This was
night.
chaotic. Yes, I told you that.
And you could have been like, yo, some people got hurt. We want to know what happened, man.
I didn't know enough details last night. There were people out there all night, processing a scene, the entire night, until about, I don't know, noon today.
Come on, man. Y'all knew,
Till about noon today.
y'all knew all this, man.
I didn't know everything. I'm telling you, you can believe me if you want, but I got no reason to lie to you. It was complete chaos.
I'm not saying you're lying.
It was complete chaos.
I'm not saying you're lying.
So that's what took so long.
I'm not.
But you know how it got to be that way.
But
So tell
also,
us how it got to be
I
that
can't
way.
even get a word in.
Because we're going round and around and around, Darrell.
We're just going to keep going around and around here.
And you're acting like you don't.
I mean,
you're acting like you don't know what these are, and you do.
No, you making it seem like I don't care. Like I'm just this heartless type of person, dude.
Well, it
I
feels
couldn't
that
even.
way.
Okay, that's fine. But look at my position. I've been in here for 24 hours. I haven't even gotten a shower, good sleep. My shoulder's fucked up. I haven't even got a phone call to even notify anybody, talk to my family whatsoever, not one time.
I'm disappointed, Darrell.
I'm disappointed too because you lied to me, Kurt.
Because
you lied to me.
Talked about what
Nothing.
you want
Listen.
him to do if
Listen.
one of your kids.
And didn't I just
What
say
do you want him to do if it was
I
one of your
don't
kids?
have any problem telling you what happened? The only thing I'm saying is I feel like you were trying to railroad me by how you went about it. That's all I'm saying. That's it. I'm not saying.
Okay, we
I'm
discussed
not saying,
that for about an hour. So tell me what happened when you drove
what I'm
off.
saying?
We're not going to make any more progress on that. I get you're pissed about that, and I'm not going to fault you for it. I'm not going to tell you not to be mad. I'm not going to tell you not to feel like, man, that was bullshit, but Carp, why'd you do that? If that's the way you feel, gotcha, it's okay. I'm not gonna tell you you can't. I'm not gonna sit here and tell you how you should or should not feel about how I went about presenting things last night. Okay, but what I've confronted you with and told you today is your mom's car's out here. I've now shown it to you. You know, you want me to, you know, tell you all these things.
No.
Hold on. But what I told you from the start, and I did tell you this, is that part of it's a give and take. There's things I'll tell you, but I can't just tell you everything. We've shown you pictures, all right? We talked about if the roles were reversed, what you'd want my partner, Ben, to do.
Yeah, you did say that.
We talked about that. What would you want it to do if it was your kid with the broken leg? And look,
so a
I
kid
want
got
to
hurt?
believe a lot of people did.
A lot of people got hurt.
Yeah.
Are you serious?
Yeah. Darrell, you were there.
No, I'm saying a lot of people got hurt.
Yeah, there's people hurt, man.
Like bad?
Broken legs and stuff like I told you. Concussions, hit their head.
Yeah, I wouldn't want to see that happen to nobody, dude.
I don't believe you would either.
Yeah, but you
and I'm not saying it's on purpose.
you just thought, yo, this dude is heartless.
So tell us otherwise.
You know
I
what
didn't
I'm
say
saying?
that. I'm
It's
asking
like,
you,
fuck,
what
man.
do you want it to be perceived as?
Tell us how it is then. If we're wrong and it's not heartless, tell us what it was.
I'm here to listen if it's something different. I'm sitting here. I haven't walked out.
Come on, Hart. Come on. Y'all know. Listen, man. Y'all know. If I did not talk to that woman, I would have never, ever be sitting right here talking to y'all right now.
Mm-hmm.
I'm not blaming her. Like I told you, I'm not going to demonize that woman. She's a good woman when she's not drinking.
It's not about her anymore, Darrell.
I know, but
and I
I'm
believe
just
that she wouldn't be in this position if you hadn't talked to her. I
would.
believe that.
You didn't have to put the picture down. You didn't have to.
The stroller.
That's a stroller.
Yeah.
So a kid got hurt.
Yeah.
A kid.
Yeah.
Bad. You said a lot of people got hurt.
Checked out. Yeah.
A lot of people got hurt.
To me, it's a pretty good injury if a doctor's got to check you out or you got a broken leg.
Yeah, so what do you call my shoulder? I'm just making a joke, but yeah.
I don't know. Well, I want to believe you're the man you say you are, Darrell, but I'm not laughing because there's nothing funny about this.
No, I was just saying. No, it's not. It's never been that. Dude, I don't take my life as a joke. I don't take my life as no joke. I was just making a joke about my shoulder when you just said, you know, if it's a serious injury, if you got to get looked out. And I was just saying I had to get looked out, but they didn't say it was serious. They treated it like, oh,
let's say spend the night.
You're the guy in cuffs, so.
Well, you said that part, not me.
No, I'm just saying that's how they, not how you acted, that's how they were acting. It's like, oh, well, there's nothing broken. Well, why do I keep having this throbbing, burning pain if there's nothing wrong?
Where were you going, Darrell? Help us understand something.
I can do that. I just want to understand what's.
So these parents
I
know
want to understand
why their kid got hurt, just the way you want to know why your kid got hurt.
I want to understand what I'm looking at. That's it. A reckless endangerment.
Yeah, that's something you're looking at, right?
Just because some people got hurt.
Yeah, people got hurt.
Now, I just want to say this. You know that when you said it wasn't the end of the world type thing?
Because nothing's the end of the world.
It is. I'll tell you why.
Not when you have God in your life. It's not.
It is, because
That's what I believe anyway.
I believe that too, but you don't want to have God in your life and you're sitting in prison. Can't see your family, can't see nobody. What does it matter then?
And the clip stopped at 3 hours, 13 minutes, 58 seconds. Sir, what went on in this clip?
Overruled, the witness may answer.
So in the clip, I was continuing to try to get Mr. Brooks to tell myself and Detective Stern what occurred, explain the reasons why, understand, you know, how and why it happened. I was more direct with him at this point and, you know, told him that recklessly endangering safety was certainly a possibility as a charge here. I let him know that people got hurt, including broken legs and concussions, yet Mr. Brooks was still unwilling to explain to us, give us the clarity, give us the information we were asking for to understand, you know, why he did it. You know, despite us talking about God, we, you know, I talk about Detective Stern and what, you know, if he had injured one of Mr. Brooks's children, that's something that comes up, and what he would want a person to do if this was one of his own family members, I guess, to say if the roles were reversed. But none of those things were anything that made him any more willing to speak to us. It continued to be really demands to know what he was being charged with, even though at that point he's being told what he's very likely looking at. But that kind of back and forth just continued to occur.
At any time during the time you spent with Mr. Brooks on the 22nd or the 21st, did he ever ask how any of the injured people were doing?
Objection. I don't consent to being called that name in this leading the witness.
Overruled as to both, the witness may answer.
No. I mean, for example, I gave examples of concussions, broken legs, but there was no follow-up as to whether these concussions were going to cause people brain damage, whether the broken legs would impair people from walking again, or if there'd be amputations. He never addressed that.
Finally, directing your attention to the video at 3 hours 40 minutes to 3 hours 44 minutes and 2 seconds. It's at
I would like that last answer by the witness strike. How can anyone determine what will happen as a result of an injury? How can you even determine that?
Your objection is noted. It's overruled. May I have that timestamp again for this clip?
Sure, it's 3 hours 40 minutes 0 seconds to 3 hours 44 minutes 2 seconds.
All right, thank you. Go ahead.
Where the charges go again?
Just watch something. Just watch something for me.
And more incriminating stuff. I'm already like I'm about to lose my life, man. Can I ask a quick question?
Hold on, watch it.
I know. Why do you want me to watch it?
Yes, I'll show you. I just want you to watch it. Watch it.
Why though?
Watch it for me.
Why though?
Because I want you to see what's in the video. Did you watch it?
No.
Will you?
I just want to know why you want me to watch it.
Because I want you to see what's on the video. Why don't you want to watch it?
I just want to know why you want me to watch it. I didn't say
I just want you to see what I told you.
Problem.
You're not accepting the answer. I told you I want you to see what's in it. That's why I want you to watch it.
You wanted information from us, we're
I
sharing
want
it.
you to watch it and see what's in it. Yeah, it's a good point. It's information sharing. Yes, I want
Yeah,
you to
but
watch
it's like
it and
you
see
trying
what's in it.
to, it's like you, like, badgering me, like, a little
But
bit.
Darrell, you asked me a question. Okay? And this is more than what we had before. So I am showing you more. I'm asking you to watch it. Will you watch it?
I mean, I don't have a problem with it.
Okay,
I
that's
just
fine.
want to know what was the reasoning.
Because I want you to see what's in it.
I mean, I pretty much.
It's not complex. It's just, you know what I'm saying? It's just that I want you to see what happens.
I understand. I'm just saying I already know. I already have an idea from what you guys was saying earlier.
But I want you to see it.
It's like watching all I'm thinking about right now is.
Here, we'll talk in a second.
What a hell of a journey it's been, but this is how my story ends. That's all I've been thinking about. Like, it's nothing that I want to.
Can you look down?
Why do you want me to see that card? Why?
Because I think it's important.
Why is it important? Is it to make, what is it?
Well, why don't you want to look?
I'm just asking. I'm not trying to raise my voice at you, or I'm not.
I'm just asking you why you don't want to look.
I'm just saying, why do you want me to look?
So because I think it's important, so you see what happened.
You told me what happened. You already told me what happened, Kurt. Y'all told me what happened. I understand my life is over. I'm trying to come to grips with that. Mm-hmm. I'm trying to come to grips with the fact that this is how my story ends. From trying to love somebody, I'll never see my kids again. My mom, my relationship is gone from me, and it's like, what is it to look at more? My life is for me to look at my life end.
That's you, Darrell.
Is it looking at my life ending?
These are the same photo. I'm just telling you that. Okay? I think it's important you see these.
It's important for me to see my life end.
It is important for you to see them.
For my life to end.
Are we gonna keep going round and round about this, or is there something you want to tell me?
Nothing's gonna help me at this point. Everybody knows what was going on from that y'all knew last night, why I was getting investigated, why I was, you know what I'm saying?
Those are children right there. Those are kids. See that little kid right there? You gonna look at it?
Sir, and it did stop at 3 hours, 44 minutes, 2 seconds. What were you showing Mr. Brooks?
Objection leading.
Overruled. You may answer.
I don't consent to that name being used.
At that point,
Hold on. Were you done with the objection?
Yeah, I was done.
All right, it's noted and overruled. The witness may answer.
at that excuse me, at that point I was showing Mr. Brooks a video that had been provided to me of him operating the red Ford Escape through the parade route. At that specific point, Mr. Brooks struck members of the Waukesha South Marching Band, and I wanted him to see it. It was more information. He was asking for it. I felt it was important to see his reaction to it, to see if he'd be willing to talk about it. And at the point where I paused it and brought the piece of paper that his head is now down on, I paused the video at a point where you could see that it was Mr. Brooks behind the wheel of the vehicle. And the point at which I paused was a still photo of that moment that was on the paper. So it was, I guess, the same picture.
Did you get any further with Mr. Brooks in the next hour that's contained in this interview?
No, I did not.
Objection. I don't consent to being called that name.
Overruled. The witness's answer may stand.
On the 22nd, did you end up collecting DNA from Mr. Brooks?
Yes, I did.
How was that obtained?
Overruled.
Through buccal swab, so they're basically Q-tips out of a sterile package. I used 2 of them, one to swab the inside of the right inside of his mouth and the other the left inside of his mouth.
Sir, just directing your attention back to this video one last time. Did the defendant ever watch that video?
Leading.
Overruled. The witness may answer.
No, ma'am, he did not.
Nothing further.
All right, we will pause for our lunch break now. It's 12:43. I appreciate everyone's patience as we were able to at least complete the direct examination. When we come back from lunch, Mr. Brooks, you can start your cross-examination. We'll take an hour and 15 minutes, so come back at 2 p.m., everyone. All rise for the jury, please. All right, thank you. We are in recess. On the record in State versus Brooks, appearances are as they were before. Just want to make a quick record. It's not something we need to address right at this moment. I provided to the parties the pattern jury instruction 152 related to jury view, and then an instruction I drafted based on that. And I say based on that because this has to do with the view of the vehicle, because I view a view of a scene differently from a view of a vehicle, which is evidence. So again, we don't need to go over this now, but I at least wanted to give those to the parties so that when the appropriate time comes, we can discuss whether the court should say anything regarding the view of the vehicle, if that is in fact still the request of the state, and then if so, what that should be. So I've provided that to both the parties in written form. Go ahead.
Actually, I appreciate that, and I wanted to bring this up this afternoon so we can plan. Obviously, I don't know if the mics are on.
It should be, yes.
Okay. I'm soft-spoken, I'm sorry.
Said no one ever. Oh, that was all loud, sorry.
So, with the court's permission, we would like to schedule the jury view to occur at 12 noon tomorrow. Now, we may not be through testimony at that point with the state's case, but like we did with the interpreter, if we could get a commitment from the court to pause whatever we're doing around 11:45 or 12 noon tomorrow and lead the jury to the location for the jury view. There's obviously some planning that needs to take place by the sheriff's office. The tow truck needs to be arranged, and I believe the maintenance division needs to assist in some way as well. So what I'm learning is that it's best if we just pick a certain day and time and set it, and then, you know, again, with the judge's permission, kind of work around that in the courtroom. So that is our request, if the court is willing to accommodate that.
In regard to that request, I know I had internal discussions with the sheriff's department because they're in charge of security over the trial, and I don't frankly know how much we've talked about this previously, but it is in a secure location, or will be. I've made arrangements, or I've instructed the sheriff's department that because of the location that we will be in, it's not something that will be that anyone can just follow us to, but contemporaneous recording will be made and then placed into the record so that the public is aware of what happened, but after. So I did want to add that to the record. In terms of the request, Mr. Brooks, this relates to the viewing of the vehicle that was recovered by the Waukesha Police Department. There were preliminary discussions when you were still represented by counsel, and the request is being made that the viewing of this vehicle take place tomorrow. Your response, if any?
First of all, I accept for value in return for value this paperwork. I guess I'm still confused as to why there needs to be a jury view.
I can have the state put their request on the record again. I'm responding to their request. So go ahead, Attorney Opper.
Yes, Judge, and I believe the court has already approved this request. The motion was filed and ruled on by the court previously, but as Mr. Brooks has been charged in every count with acting while armed with a dangerous weapon, we believe it's relevant and appropriate for the jury to view what we're alleging to be the dangerous weapon in this case, that is the 2010 Ford Escape. It's essentially, would be no different than bringing a firearm into the courtroom during a shooting case.
And I would just simply note the first-degree intentional homicide and first-degree recklessly endangering safety charges are what carry the enhancer for use of a dangerous weapon. Of course, the hit and run does not have that enhancer, nor do the bail jumping and batteries. But with that caveat.
Yes, thank you for that correction, Your Honor.
All right. Mr. Brooks?
I'm confused to that too. Why are there only certain charges that have an enhancer?
Well, the court's not going to answer that, sir. Those just happen to be the charges. The state is tasked with proving each one of those charges and any special verdict question that goes along with it. Beyond a reasonable doubt, they bear the burden of proof, as was spelled out in all of the preliminary jury instructions. So that's how I'll answer that. In terms of the jury view, I did grant the motion previously. It was unopposed, and I'm not hearing anything that would cause me to reconsider that. In terms of the time that's being requested, do you have any position on that?
Do I have to be present for this?
I would like you to be, and yes, we're making arrangements for you to be there, sir.
Do I have to be present for it? And also, for the record, I don't consent to the name that's being referred to.
I'll use this opportunity, sir, to ask what name you prefer to be called, because we now have evidence in the record where you provided your name to, upon questioning. There was video from when you were taken into custody, and then, of course, Detective Carpenter has testified about that as well. Again, I try to refer to the parties by name because that is how I believe I demonstrate respect and decorum in this courtroom. And we've been given no other name, sir, by which to call you by. And I must, at that point, go back to what's on the criminal complaint, which is the initial charging document. That is what was filed in order to initiate the case.
With all due respect, the record should be corrected. I didn't put anything on the record that was...
I didn't state that. I said there's
said
evidence in the record.
Well, evidence, what you referred that evidence to me.
So there's evidence in the record, but be that as it may, I'm just letting you know I'm going to keep referring to you sometimes as defendant, sometimes as sir, sometimes as Darrell Brooks, sometimes as Mr. Brooks. I understand you may still have an objection, but I've been given no other name from you by which to call you.
I follow, but there's still a lack of understanding. Are you referring to the name that was in all caps on all the filings?
Because
every filing that I have,
I find the response to be kind of disingenuous, sir.
So there was
this is, I believe, a tactic by you to create some type of confusion, which I don't believe there is any, about who you are and what name I need to refer to you as.
I never said you had to refer to me by any specific name. That's not what I'm saying. I'm saying that every filing that has ever been filed was in capital letters. That's a fact. I have paperwork to prove that. I don't recognize that name, nor do I know any individual by that name. That's all I'm stating.
Well, let's assume for a second that it's not in all caps. Do you recognize that?
No, I do not.
Okay, well, we have our answer then. We're going to keep going, sir. We're a little bit off topic. In terms of the request by the state, I'll give you one more opportunity to answer that. They've requested that whatever we're doing tomorrow morning, whether it be their case, whether it be if you are calling witnesses, that we pause about 11:45 in order for the jurors, the court, and the parties to be taken to that secure location for that jury view. Do you have any position as it relates to that?
Yeah, my position was, when I answered, I said, do I have to be present?
I'm requiring you to be there, yes.
And what reason do I have to be present?
Unless you're willing to go through a colloquy with this court and intentionally waive your right to be there, because then I'm going to require you to be there.
And that's not explaining why I have to be there, though.
Because I'm requiring you to be there, sir.
And you just made that decision now?
All right. He's not answering the question that I asked him. We will pause at approximately 11:45 tomorrow morning for that jury view of the vehicle to take place as soon as we're able to walk over there, but I think given the logistics of everything, it is on campus, but it is in a secure location. That will take place approximately at noon, and as I indicated, the court will require the Sheriff's Department to make a contemporaneous video of that view, which will subsequently be made part of the record to capture that.
Don't I have rights though, Your Honor?
All right, then with that.
Could I ask another question?
Go ahead.
Scheduling, Your Honor. Could you please indicate your intentions as to how late we will proceed this afternoon so we can line up witnesses?
Sure, I'd like to try to, we had a little bit of a long day yesterday, so I try to balance that out for the jurors. So generally between, 4:30 and 5 is when I would like to break, depending on where we're at. If we need to go a little earlier because of the witness, or if we need to go a tad later, that's fine as well.
Okay. And then the last item, Your Honor, is that, to my knowledge, we still have not received anything from Mr. Brooks as to the date and time when he would like his witnesses ordered to appear. I don't see anything was e-filed. So if he is still requesting the assistance of the state to secure the appearance of those witnesses, we will need that information, Your Honor. He does not have to give us the exact order, but if he could tell us, as you had suggested, either morning or afternoon, and what day of the week he wants these people here. We have served the subpoenas that he requested at his request in order to assist him. And these witnesses obviously have jobs and other commitments, so it's reasonable to be able to give them a time frame on when they need to be here.
With that, when do you expect to rest?
We're still hoping to rest by the close of business tomorrow, Your Honor, unless something unforeseen happens.
So we're talking about Thursday and Friday at this point?
Yes.
Which is what I suggested from the beginning yesterday.
But Mr. Brooks, we need to know which particular witnesses on which day and whether it's AM or PM. Don't need to give me the order. We'll have them come in groupings, but it's not reasonable that they all come on the same date.
I never said it was.
All right, so you need to provide that to the DA.
How am I supposed to provide that to the DA?
You can write that down, or you can put it orally on the record right now. I asked you to bring it with this morning, and I didn't cover that this morning, so you were put on notice of that. But I'll give you until...
I was put on notice of what?
Let me ask Attorney Opper a question. Would tomorrow morning first thing be sufficient for the state to make those arrangements, given that you don't believe you will close your case until the end of the business day tomorrow?
I understand what the court's saying. I think that's reasonable, with the understanding that if somebody needed to give notice to an employer and it can't be accommodated, then that may affect things for Mr. Brooks. But I think 24 hours notice is generally reasonable, and we will do our best. We can assure the court we will do our best to get them here, but I don't know if we'll be able to exactly accommodate the timing that he may or may not want.
All right, so Mr. Brooks,
Objection to that, because when the subpoenas were served to them, I'm assuming that they would have let any employers or anything know that they were expected to testify in a trial. I don't understand why it will become a problem at the last second.
Well, if you recall, sir, near the end of last week, I don't recall exactly what day we were on, but we knew we weren't going to finish with the state's case at some point, and we had a discussion on the record. If there was any objection by you, if the state told those witnesses they didn't need to appear on Friday, so it obviously had to have been before Friday, that they didn't need to appear, and that they would work with those witnesses to provide them with a more definitive time. So now is the time when we need to provide them with more definitiveness. So by the start of court tomorrow, you need to bring with you, either in writing or be prepared to put it on the record orally, which witnesses you want. We'll start with Thursday morning, then Thursday afternoon, Friday morning, and Friday afternoon. I don't need to know the order, but I need to know the day of the week, right? So Thursday or Friday. I would just note the dates for those. Thursday is the 20th, Friday's the 21st, and then which witnesses. Only you know how much you want to question them, so you should be able to gauge if we can get 2 in each morning or afternoon, 3, 4, whatever. Use your best judgment on that.
Yeah, I don't know how I'm gonna come up with exacts on that.
I presume you're gonna prepare some questions and you might be able to kind of gauge how quickly that will go or not. If not, we'll do our best, but you've got to provide some definitiveness. It's not reasonable to just have these witnesses all come on one day.
I'm informed of what you're saying. I just feel like that same courtesy wasn't afforded to me by the prosecution. They didn't have to tell me exactly what witnesses was being called on what day and all this and that. Why is it not even
I am requiring it, sir, because they are assisting you, because they graciously agreed to do that because you are representing yourself. If you want them to be out of the loop on that, then I can just put it on your responsibility and your shoulders. But that is up to you.
What do you mean by put it on my shoulders?
You can contact them.
How am I supposed to do that?
You have access to a phone in the jail.
So I'm supposed to call everybody that I subpoenaed, not knowing their information?
That is one way to do it, sir. Their information is in the police reports.
That is highly unreasonable. When one person that's on my witness list, I'm not even permitted to have contact
That
with.
would be a good exception to that. So that's very astute of you to point that out, sir. That would be one exception. But other than that, in any event, sir, we're kind of a bit off track. We're going to get back on track, and you need to provide the information that's provided, that I've outlined here today.
I don't think that's fair, Your Honor.
Oh, your objection is noted, but it's my ruling.
The state didn't have to do that, but I have to do that.
Sir, I remind you that you are nonetheless required to follow the rules of procedure just as any attorney would have to if they were representing you. You've chosen to represent yourself. The state has graciously agreed to assist. They've served the subpoenas on your behalf. They didn't have to do that, but they did. They've agreed to contact the witnesses throughout so that a better idea can be provided to those witnesses as to when they need to testify. They're simply asking for some basic courtesy so they can then relay that information to the witnesses you want to call in this trial.
I'm informed of that, Your Honor, but...
All right, then let's move on.
That's actually under the confrontation clause in the Sixth Amendment. I should be able to have the right to have witnesses subpoenaed. It shouldn't... Why is that?
Again, we're getting a little far afield here, sir. Subpoenas were provided to you. The record is very clear on that. We assisted you with that. I even reviewed them for completeness, and then the state assisted you with serving them. That is something they are not required to do, but they agreed to do in this case. So nothing about your Sixth Amendment has been violated in that regard.
Did I say violated, or did I say I'm not?
So you need to understand that, sir.
I don't understand anything, and for the record,
All right.
I didn't bring up the word
Let
violated.
us continue then. We're going to move on, Mr. Brooks. Let us continue with the questioning.
So we're going to move on to subject matter jurisdiction that has yet to be proven?
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not going to address that at all? That's not going to be proven for the record? Is that a judicial determination that you don't have to answer the question, Your Honor? Is there also a tactic agreement?
The state would move Exhibit 82 into evidence at this time.
All right, you want to do that in front of the jury or just with me?
I wasn't sure if the defendant would have any objections that would need to be heard off the record or outside the presence of the jury.
Well, can you have them hold for a second? Do you have any objection to Exhibit 82?
Yeah, I got an objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern. Your objection is to relevance? Your objection's noted, it's overruled, and I will receive Exhibit 82.
The court will let the jury know that when they come
So
in.
are
Yes.
you overruling the fact that the true nature and cause has not been presented to me, that I don't know what the true nature and cause of the charges are?
You can have them brought out now. All right, thank you.
All rise.
Your Honor, may I see a sworn affidavit of the nature and authority of the court? Or is that a judicial determination? You won't answer that as well.
Welcome back, ladies and gentlemen of the jury.
I hope the record reflects that.
All right, thank you, everyone. Please be seated. Record will reflect that Detective Carpenter is back on the witness stand following the break for the lunch hour. And Mr. Brooks, you may start your cross-examination.
I don't consent to being called that name, Your Honor.
Your objection's noted. It's overruled. Please ask your
Can't be
questions.
overruled. Detective Carpenter. Did you attend the parade that evening, November 21st of 2021?
Yes,
In what capacity?
as a member of the Honor Guard.
And what time did you arrive?
I don't recall the exact time.
What time did you leave?
I don't recall the exact time.
And when you left, where did you go?
Our temporary police department.
Temporary. Explain what do you mean by temporary?
So at the time of the incident, the building we are in currently, which was our main building, was under construction. So we were displaced.
What do you mean by at the time of the incident?
At the time of the parade.
And so the regular station was, what did you say, under some type of construction or something?
Correct.
And so what were you guys using for the temporary police station?
The city annex and city hall. We're in two different buildings.
Does any of those buildings consist of a room for interrogation?
There is at the annex.
And so when you initially interrogated the suspect, why was the annexed interrogation room not used?
Well, when I interrogated you, Mr. Brooks, the annex room was not used because the situation was very fluid. There was a lot of information being learned. We knew this was going to be drawn out. There is no municipal lockup facility at the annex, so it could not be utilized.
And so the police holding room in the hospital was more sufficient.
You asked to go up there for medical clearance.
So the police holding room in the hospital was more sufficient than your temporary station, which would have been more suitable?
Yes, it was more sufficient.
And why would a hospital police room be more sufficient than the actual police station that you were utilizing at the time?
As I stated in my previous testimony, there was no secure lockup facility at the station. In addition to that, you requested medical clearance at the hospital.
So was there sufficient lockup at the police room in the hospital?
We had areas in the hospital, so when you were being treated by the doctor, you could be handcuffed to a bed. There is no place in the interrogation rooms you referred to at the annex to handcuff you to anything, and the doors did not lock sufficiently.
And to the best of your knowledge, would a detainee have that information that you just stated?
No.
So how come the suspect couldn't be handcuffed at the annex for the interrogation without having to be handcuffed to a specific bench or whatever you refer to it as?
Well,
I guess essentially what I'm asking is, could the suspect still be properly detained while being interrogated at the annex versus police holding room in the hospital?
So let me make sure I have this straight. Your question is about detainment. Do I have that right?
I think the question was very clear, Detective.
I can't answer it if I'm not going to get clarification.
And where was the suspect taken upon being detained?
You were taken, Mr. Brooks, upon the time you were arrested, down to the substation on Les Paul Parkway in Waukesha.
And do you recall if the suspect was put into a holding room?
Yes.
And do you recall if that holding room had something that would secure a detainee?
Yes.
So why couldn't the interrogation happen there if the suspect can be secured at that location?
Well, there are various reasons, and one of the most important reasons is when we took you to the hospital, Mr. Brooks, for your medical clearance, there were now a total of 4 officers there, myself, Detective Stern, and eventually the 2 federal agents. The situation was still very fluid. When I began the initial the initial questioning, it was 11:04 p.m. and there were still a lot of unknowns. So the determination was made to start questioning you, see what information you might be willing to provide us, because with 4 of us, we were confident we would be able to keep you where you belonged, where we needed you to be, as opposed to risking another unnecessary transport. Because and it's not just personal against you. Any transport of any prisoner, there's a risk. So there's no point in taking that risk of that transport when we had the ability to do the interview there, especially when there was such limited information that we had.
So FBI agents were present at the substation that you referred to?
They arrived there at one point, yes.
Was that known to the defendant?
I don't recall.
Is it fair to say that the detainee could have been Is it fair to say that you could have made sure the suspect was contained while at the substation, seeing as how that there was multiple officers present?
Objection, I think this has been asked and answered.
I think he's referring to the substation versus the hospital, so I'll allow it. Overruled.
You were contained initially at the substation, Mr. Brooks, but you requested medical transport, so you were transported. So what I'm explaining to you in my prior testimony is I didn't know at that point if you'd end up going straight to the county jail or what have you. Every transport, as I stated in my earlier testimony, there is a risk. There is a danger. It's not just personal to you, it's any prisoner. So the decision was made to start the interview there based on not knowing where you'd end up for sure, not having all the information, that we weren't going to take the risk of an extra potentially unnecessary transport back to that facility. You couldn't be held there. You couldn't be held at the sub. There's no beds.
You referred to interrogation starting at a specific place. I'm referring to the substation. Is it fair to say that there was no interrogation that took place at the substation?
Yes.
Yes, that's fair to say?
There was no interrogation at the substation in Waukesha.
Do you recall what information was obtained at the substation?
Yes.
Do you recall what that was?
Yes.
Can you state for the jury and for the record what information you obtained at the substation?
Yes, sir. Basic biographical information. So I obtained your first name, Darrell Brooks, your last name being Brooks, your full middle name, I should say, being Edward. I learned that you were a junior, the date of birth, February 21st, 1982. Additional information obtained was your home address, which was you provided as 4014 North 19th Street in the city of Milwaukee. Phone number, your emergency contact, which you provided as Dawn Woods, whether you were employed, going to school. I remember talking with you about your tattoos and other physical marks that might be on your body, your hair color, eye color, photographs were taken, things of that nature.
Kept mentioning that name, pretty slick.
Sure, disregard that last statement, sir. Please ask questions. You'll have an opportunity to testify later.
Oh, I got a lot of questions. And at that point in the investigation, what did you initially know?
At that point, we knew that the red Ford Escape had driven through the parade route and that you'd been identified as a suspect.
And why was that information not provided at that time to the detainee?
The information at the time wasn't presented to you, Mr. Brooks, because, as I stated in my earlier testimony, it was still very fluid. It was very chaotic out at the scene. There was still a lot more that needed to be learned.
So is that standard procedure to not tell a person why they're being detained?
Well, we didn't not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is that the same as...
Can I finish, please? I just didn't bring up the parade part of it.
Why not?
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
So it'd be fair to say that it was not a fact as far as the information you learned to that point in the investigation.
Objection made.
Grounds.
Sustained is to the form of the question.
So at that point in the investigation, it wasn't a fact.
Objection, same question.
Grounds.
Sustained is to the form of the question.
At that point in the investigation, the information you had at that time, you weren't sure about.
I guess which part?
All the information that you had up until that point.
Okay, about the prowling or parade, I don't understand which part of it you're talking about.
All the information that you've obtained at that point in the investigation, you weren't sure about. As you just said, you don't try to assume guilt or anything like that until you have all the facts. So at that time, at that point in the investigation, is it fair to say that the information that you had obtained so far, you were not sure about?
I wasn't sure if you were the driver initially, but it was believed you were involved.
And you knew that to be fact?
Yes, the information being provided was that you were involved.
So it'd be fair to say you knew that as a fact?
Well, hold on. I'm going to not allow him to answer that. This jury will determine the facts of this case. If you want to ask him his opinion, you do that at your discretion.
He said fact. He said facts.
You asked the question, sir. So
he brought it up first.
I'm going to strike the question from the record. And Mr. Brooks, you're directed to rephrase.
I will rephrase, but I do not consent to being called that name for the record.
Noted and overruled.
You stated that there were some loitering and prowling allegations. Why? To your knowledge, were those ever charged?
Objection relevance.
Grounds.
Overruled. The witness may answer.
No.
And do you recall why not?
No.
So why did you constantly tell the detainee that they were being detained for loitering and prowling if you in fact knew that there was another reason why they were being detained?
Objection asked and
Grounds.
answered.
Sustained. That's the form of the question and assumes facts not in evidence.
What was the significance of the FBI being present?
The significance of the FBI presence was the early on concern that this was a terrorist style event.
And you said that this was a terrorist element. And what is the this? Can you explain what the this is?
When you drove your vehicle through the parade and struck people.
Which at the time you stated you did not know is fact, correct?
That was still being investigated, yes, but I know that's what occurred now.
Now versus then.
Initially, it was unknown if you drove.
That's what I was
stated.
That was the question.
But the investigation showed that you were the driver of the vehicle.
And initially, you didn't provide that information, correct?
Correct.
So, do you know if the FBI continued their part of the investigation?
Eventually, the investigation was strictly run by our department.
And do you recall why that decision was made?
My understanding is there wasn't a terrorism link.
I'm sure throughout your career you've done lots of interrogations. Are there usually multiple officers that do the interrogation, or usually just one?
It can depend on the circumstance. It's not always more than one, but it can be.
And what would you estimate would be the normal procedure for interrogation as far as law enforcement wise?
I really can't speak to that. I think every department probably has their own potential way of doing things.
Up until that point in your career, when you interrogated the detainee, had you ever conducted an interrogation with FBI present?
Not prior to that day, no.
Made reference to car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
No, I did not.
Were you told by other law enforcement?
I guess told what exactly?
That a car key was found.
I was not specifically. Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
And to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
At the time that the detainee was detained in the substation.
Thank you for that clarification. Go ahead and answer.
I just want to make sure I guess that I understand. So you're asking me what I knew about the key, or if I knew where it was found at the substation? I don't understand. Can you clarify that, sir?
I guess the clarity that you may be looking for is what was found and brought into the substation?
Okay. The Ford ignition key and other items that I alluded to in my earlier testimony include your photo ID and credit cards with your name, or debit card, credit and or debit cards with your name on them.
That you did not search and find yourself, right?
That's correct.
Did you conduct any searches?
I don't recall if I did or not of your person.
So it'd be fair to say you don't know where certain items were found at the time that you learned of there being items found, correct?
No.
No, as in?
No, I knew those items were found on you in the search. Maybe not the specific pocket, but I knew the officers found those items in your possession.
Were you at the scene of the search?
No.
So how do you know where they were found?
Because they were turned over to Detective Stern as your property.
How do you know where they were found, though, if you weren't at the scene?
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Can you strike that last answer from the record? I didn't refer to any house, grass.
You asked
City.
an open-ended question. His answer will stand. Your request is denied.
So it'd be fair to say that in the question I did not mention a house, grass, or a city? That'd be fair to say?
You didn't mention it, but I know you were found at a house in the city of Waukesha. And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
Can you strike that last answer?
Request is denied.
On what grounds, Your Honor?
You asked the question. He answered it. If you want to limit, ask leading questions and direct him. That is your right.
You made reference to the house where the detainee was found, the grass, the city. Could it be possible that that's where they were found? The items that you are referring to?
No.
Even though it'd be fair to say that you were not present?
Correct.
You made a lot of reference to the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
No, sir.
So it'd be fair to say that you cannot know how a person's body is feeling. That'd be fair to say?
I can't explain exactly what another's body's feeling, correct.
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
I think that depends on the circumstance. In this specific circumstance, you told me...
The last follow-up if he wants it.
Okay.
Next questions.
You made a reference on one of the exhibits. I'm not sure exactly which one it was. It was the first interrogation in the police holding room in the hospital. In that exhibit, you made reference to the FBI being present because you were short-staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence, yes.
And you made a reference to short staff. Can you explain what does short staff mean?
I don't recall if I said that or not.
I don't know if it's exhibit 172 I'm referring to. Can you pull up exhibit 172, please?
We refer to the photo of the identifiers and the items found.
Is that
That's
172?
172, yes.
Well, I don't think, is it 81 then I'm referring to?
81 is the audio recording.
Okay, it's 81.
I'm sorry, 81 is the video and audio.
Of the,
Was it just the audio? I was right the first time. It's
okay, I think it's 81.
You would like the audio recording from the hospital?
Yes, Your Honor.
Is there a part you'd like to direct the state to when they pull it up?
Because it's the audio, I'm assuming it'd be probably as soon as the defendant is brought into the room.
It was played starting at 4 minutes and 25 seconds through 14 minutes and 25 seconds. Do you want it started right at 4:25?
Yes, Your Honor.
Okay. The state would please assist with that.
How long would you like it to be played?
Do you know how long you want it played, or do you want the whole thing? The
I don't-
same clip?
I don't need the whole thing played. From what I recall, the point that I would refer to is pretty early in that.
Well, how about we start at 4:25 and then you say pause, please, when you want it to be paused by the state.
Okay.
All right, go ahead.
See right here, Darrell. I'll go grab you.
I'll tell you. Tight.
Darrell?
Yes, sir.
Hey, Darrell. I'm Jeremy Wojciechowski. I'm the FBI.
FBI.
Yeah. That's my partner.
FBI.
I'm Mary. Yep.
They're just kind of helping out because we're so short-staffed tonight. So,
thank you.
It's paused at 4 minutes and 56 seconds. Go ahead.
From hearing the audio on this exhibit 81, do you recall saying that the FBI was present because you were short-staffed?
That is my voice. I don't recall saying it in the moment, but that's my voice.
That is your voice.
That is me talking.
So from your recollection, do you recall being short-staffed at that time?
Yes.
And can you explain what the short staff mean as far as at that time, what would short staff mean?
That we were just very short on resources with what happened down at the parade route and the mass casualties and the amount of officers it took to secure that location. We were very short on people.
And
people were called in off duty.
You made reference to the short staff being the reason why the FBI was present.
Yes.
Is FBI usually present in a situation of short staffing?
No.
May we put that off, or do
yes,
you need it?
I'm sorry.
No, it's okay. I just want to make sure if you needed it, it's up. All right,
Sometimes
take it
I have to
down.
get it still.
Makes two of us.
Yeah. And you made reference to recording the interrogation on your phone, correct?
Yes.
And why would you use your phone to record an interrogation? Especially one of this magnitude.
Because the camera in the room didn't have audio capability.
And were you informed of that? Or let me back up. When were you informed that the camera that was in the room did not have audio?
I don't recall exactly. Prior to the interrogation.
And who were you told by?
Hospital security.
Was that the first time you had ever used that police holding room in that hospital?
No.
So it would be fair to assume that you were aware that that room had cameras.
Yes, I knew it had cameras.
And have you ever conducted an interrogation in that room before that evening?
Interrogation, no, but I'd use the room for other purposes.
So what prompted an interrogation in that room that specific evening?
Well, as I explained in my earlier testimony, the situation down in the downtown area of Waukesha where the mass casualty incident had occurred was very fluid. It was still unfolding at that time. We were learning more and more and more about what occurred. We decided to start the interview at that location to see if you'd be willing to shed light on for us as to what you did or did not know. And again, I'll go back to statements I made earlier. There's a risk inherent with every transport. I didn't know where your ultimate final location was going to be that night, so to now start bouncing you from facility to facility to facility unnecessarily was just something we made the decision not to do.
And at some point, the detainee was moved to the Muskego Police Department, correct?
Yes, you were moved to the Muskego Police Department later in the evening.
And when did you learn that that would be a location that the detainee would be going to?
We made the decision to try to use that location after the first interrogation attempt.
I'm sorry that I didn't hear the last part.
I'm sorry, after the first interrogation attempt.
First interrogation attempt. How would you define attempt?
Well, when we were at Waukesha Memorial Hospital that night in the police holding room that we've discussed, I read you your Miranda rights verbatim from the Waukesha Police Department Miranda statement form. And at that time you indicated you didn't wish to speak with me.
So it would be fair to say that the Fifth Amendment right was exercised at that point.
Right to silence.
Under the Fifth Amendment.
Yeah.
So acknowledging now the fact that the Fifth Amendment right was invoked not to speak, or as you say, the right to silence, why did you continue to record on your phone?
So we are trained at our police department when you do an interrogation, the recording is to be left on pretty much until you try to effect transport. So typically what we would do is if our building hadn't been under construction and when we'd been able to get you back to our police department, where in that situation we may very well have transported you, just because we would have had a municipal lockup there and we could have held you for the night. But that again was difficult based on the fact that we didn't have that possibility at the time. So if someone's in an interview room and at our police department, we'll leave that, even after the interrogation's over, we'll leave that video running until we come back and remove the individual from that room.
Even once a detainee has invoked their right to silence, you still continue to record? Is that a standard practice of your agency?
Yes, it is, for as long as they remain in the room.
And so when did you start recording?
Are you talking at Waukesha Memorial Hospital?
Correct.
Prior to you entering the room.
So you started recording before the detainee entered the room, and you said you keep the recording on until they leave the room. So would it be fair to say that there should only be recording while the detainee is in the room?
No.
And you did say for the record that that's standard procedure in your agency.
In regards to the interview rooms at our normal police department, which wasn't available at that time. Yes.
Would it be fair to say that you were not at the normal police department?
Yes, however, with the audio, I was still trying to make sure I followed the policy to the best of my ability.
Can you show proof of that policy?
I don't have it.
So it'd be fair to say that there's no way to determine if that truly is policy if it can't be proven.
Objection, argument.
Grounds.
Sustained. As to the form of the question, it's argumentative.
How can that policy be proven?
Objection.
Grounds.
Sustained on relevance grounds.
Do you know where that procedure is located in your agency rules?
Objection,
Grounds.
relevance.
Sustained.
Grounds for the sustain, Your Honor?
Relevance grounds. Relevant. Not relevant. Next question.
It's not relevant?
No, keep going. We can take it up later outside the presence of the jury at our afternoon break, but for now, keep going.
I follow, Your Honor. I apologize.
Keep going. Okay.
So once the detainee was taken to the Muskego Police Department, that would be a pretty standard police department. Would that be fair to say?
Yes.
And a second interrogation also took place at that police department, correct?
Yes.
Any reason why the first interrogation couldn't take place at the same police department that the second one took place at?
Well, the first interrogation, again, wasn't at a police department. You know, Muskego was utilized as they had a lockup facility, so we interviewed you there.
Around what time was the detainee taken to the Muskego Police Department?
I don't recall the exact time.
And you also stated that another law enforcement
Mr. Brooks,
officer...
I apologize for the interruption, but I just want to make sure my jury is in good shape. If you want to just take a moment to stand. It's a little slow, I think, for them, so we're just going to stand for a minute. Again, my apologies for the interruption. Anyone on my jury need a break? Are we good? I'd like to keep going. Anyone? Okay. No response to that. They said they're good. All right, we'll sit back down. And again, my apologies, Mr. Brooks. Hopefully you know where you were.
Yeah. It was another law enforcement officer who actually did the transport of the detainee at that time, correct?
Yes.
And you stated earlier in testimony that you and your partner followed behind that transport. Is that fair to say?
Yes.
And I'm assuming at some point that you will actually strike that. You stated to being present during the booking process into the Muskego Police Department. Is that fair to say?
Yes.
So why couldn't interrogation be conducted at that time, which would have been more ideal considering that you said there was a lockup. I forgot how you referred to it, but basically like a room that the detainee could be secured.
Well, you had been talking about at that point when we arrived at the facility with you that you hadn't eaten all day, you hadn't slept, so we wanted to give you an opportunity to eat, sleep, clear your mind, and refresh yourself.
And what bearing would that have on interrogation?
Well, I mean, you said you hadn't eaten, you hadn't slept. So I think a person is more focused when they're fed and they're rested. So we wanted to give you the opportunity to do that.
In your opinion, how would that have affected interrogation?
I'm going to excuse the jury right now. So if our jury, we could stand for the jury so I can take up a legal issue, please. All rise. All right, thank you. Be seated. So I'm going to take up two issues right now. One is when I paused earlier and told Mr. Brooks I would allow him to, it was regarding the policies. I want to know, as the proponent of the evidence, why you think that's relevant. And then secondly, the questions I believe that you are asking related to the interrogation, unless you can convince me otherwise, go to a legal issue that this court has already determined, but I'll hear you out on that. I didn't want to make an assumption, but I also didn't want to have you question this witness about what really are legal issues that this court previously addressed regarding the admissibility of the interviews.
Well, to the first one, about the policies, that's relevant because I think it should be stated for the record why he left his phone recording after he acknowledged that the Fifth Amendment right to silence had been invoked. At that point, interrogation is supposed to stop completely.
Well, I understand what you're saying from a legal perspective, but that doesn't mean the recording had to stop in and of itself at that point. He did provide an explanation on the record.
His explanation was that it's policy, right?
He answered the question, why do you believe having the specific policy and him testify about the specific policy is relevant to his testimony?
Well, I believe that if that's in fact policy, it should be proven. It should be proven that that's a fact, that is a real policy. For all we know, he could just be saying that it's a policy. And at that point, it makes him continuing to record after the Fifth Amendment had been invoked.
Well, right now you assume facts that are not in evidence, sir. And so you're the proponent of this testimony through your cross-examination. And so without something more, sir, I don't see where there's relevance as to what the specific policy is.
Can you see what I'm getting at, though, Your Honor? If he's saying that this is a policy of his agency, he should be able to prove that that's policy. Because at that point, if there's no way to know that that is the correct procedure that they use every time, then
you're,
why?
Again, making a lot of generalizations that I don't think are accurate as to what he said. This is a trial, sir, where the allegations in this case are that you drove through the Christmas parade, right, and caused death and injury to a number of individuals. There's also those other charges related to the bail jumping, the battery, and frankly, his conduct isn't on trial. We're not here about a police misconduct trial. I'm not saying that some of this information might not be relevant to his credibility, things of that nature, but you have to, again, you're the proponent of this. Why do you believe those policies relate to an issue of fact in this case or otherwise go to your defense?
I believe that is relevant because it can show that at the very minimum that first interrogation and anything related to it should not be admissible as evidence.
That's a legal determination that I've already raised. Your attorneys represented you at that time. They made a variety of arguments. So to then make this trial about that interrogation, it's not relevant.
I'm not making the whole trial of it.
But the issues are legal issues that this jury will not be asked to answer. I've already ruled on the admissibility. That's a legal determination. So I'm not seeing the relevance to those specific policies, and there is simply no requirement that the state or this witness has to prove those policies. You are representing yourself. Hold on, let me finish. You're representing yourself. I'm not aware of any subpoena that required him to bring those policies with. So that would have been on you if you felt it important to cross-examine him on those policies to require that. I'm not aware of that. Have you done that?
Obviously, it was going to come up.
Did you issue a subpoena ducis tecum to this witness to bring with any of his policies related to interrogation?
How can I do that myself, Your Honor? How can I do that from a jail cell?
You were given all of those blank subpoena copies, sir. And you could have filled that out in a way for this witness to require. You didn't do that. So
who would have served him?
The state would have. They served your other subpoenas. But be that as it may, that's not what we have here. So I believe that your line of questioning is on a topic that's not relevant to the issues in this case. So I'll give you one more opportunity. Why do you believe that questioning him about the policies are relevant to your case?
It's relevant to the case because why would he be recording before people are even in the room and then after?
Well, that's argumentative, sir. So that's not a legal basis.
Once the Fifth Amendment is invoked, interrogation is supposed to stop. Period. There's supposed to be no more recording, no more questions asked. That should be the end of the whole interrogation.
These are legal issues that you're trying to raise before the jury. I've already dealt with the admissibility, so you've not provided a legal basis to further question this officer about policies related to the interrogation and the recording. He has answered questions. I gave you some leeway on that, and his answers are before the jury. Certainly you'll be able to argue the meaning of that or the lack thereof during your closing arguments if we get to that point. Let's move on, though, to this issue about why I excused the jury. And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent. You want to question him. What's the legal basis you believe I should allow you to continue with that?
What legal basis are you referring to?
I believe you were attempting to elicit information or evidence, testimony from this witness on issues that are not relevant.
Is that referring to the same question?
Not the policies, what I just stopped the testimony for, because I don't want to create issues in front of this jury related to legal issues that are not before them to determine.
And is that referring to the question about the policies?
No. You were asking him, why did you stop? Why did you not question him further? Meaning, why did this detective not question you when you got to the Muskego Police Department? Why did they wait till the next day? I stopped because I know the law on this area, and I know that when a subject invokes their Fifth Amendment, or when you're a defendant in state, it's the 14th Amendment, but nonetheless, right, you have rights under the Wisconsin Constitution as well, but that because you only invoked your right to remain silent, they waited to question you until a sufficient amount of time had passed, in addition to the other reasons. I'm not going to let you question him in front of the jury about that specific thing. Or at least I'm cautioning you that I'm stopping it because I don't see where that's relevant, but if you keep pressing him on that, you're going to open up the door to him saying, because I was following the constitutional requirements and giving you a break in the questioning so that I could, get a statement I believe would be admissible later on. That's what I'm trying to avoid.
With all respect, Your Honor, I don't think he would have said that.
My concern was we were headed down that path. So if there's some other reason you want to question him.
The 14th Amendment would have been referring to the having the attorney present.
I'm sorry, say that again?
So you said, when you stated that you know the law in that area about the Fifth Amendment and the 14th Amendment, what were you referring to on the 14th Amendment?
I'm not going to explain that any further, sir. Let me just ask the state if they see this any other way, you think I'm mistaken, and I was concerned we were headed down that path, which would be a legal determination. But if there's something the state sees that differently, please let me know.
I actually thought that Mr. Brooks was questioning this witness about why they didn't do the first interrogation at Muskego. So I thought that there was some miscommunication between the two of them. And I just wasn't sure. I didn't want to object for that reason because I just wasn't sure what Mr. Brooks was talking about at that time.
Well,
and
that's fair enough, because if that's what you were trying to question him on, then I think that's fair game. But
I agree with Attorney Daisy. That's what I was getting at. I didn't mean to cut you off, but I agree with Attorney Daisy. That's exactly what I was getting at.
All right, well, you understand it's my job to protect the record too. So I want to make sure that, all right, so with that understanding that you are questioning this witness about why they didn't take you to Muskego for the first interview, is that where you're wanting to go with all of this?
That was the question.
All right, well, I might have misunderstood, but in any event, it gave us an opportunity to talk about the other thing, so that's okay.
So is that a fair question to ask then? Because I'm confused now if I'm even allowed to ask that question.
I think part of the issue sometimes, sir, is there's either sometimes the questions aren't as artfully worded as they could be. I know you're doing your best. I like to look at it this way. Questions that are a sentence at a time, meaning a thought at a time, because then they're not compound, are the easiest for a witness to answer. And when you start bringing in other things, it can be confusing, and then I might not understand, or a party or a witness might not understand what you're asking. So looks like it's one of those situations where I was a bit unclear. It's been clarified. If that's the line of questioning that you are going to go, then that's fine. Then I would allow that. I'm not going to stand in the way of that. If the state objects, obviously that's a different story, then I'll have to rule on it, but I think we're all on the same page now.
And just for the record, Jared, I will be objecting. I don't want there to be, just because I think this has been asked and answered. He was taken to Waukesha Memorial Hospital for medical clearance. They want to minimize the number of times that he's transported, and they needed the information sooner rather than later. So I will be objecting as to asked and answered. I just didn't want to, we asked the question that the court suggests, and then I object, and so I do want to put that on the record just so that the court's prepared for it.
Understood.
The question of why wasn't the first interview conducted at Muskego Police Department had not been answered.
I'm going to let you ask that question. So even if they object, we'll put everyone on notice. So because I think it's reworded a bit differently, so I think it's fair. I'm going to let you ask that. All right? Let's bring the jury back out. It's time. I might have to get me more water too. Thank you so much. You have enough water, sir? You have water?
Yeah.
You have enough?
Run through this one.
All right, we'll make sure there's another one. All right, I can't see the hand monitor. What you got or don't have.
Thank you.
Mm-hmm. right, thank you, everyone. Please be seated, and Mr. Brooks, you may continue with your questioning of this witness.
And do you recall why the first interview was not conducted at Muskego Police Department?
Yeah, so in regards to the first interview at that point, as I kind of stated in my earlier testimony, we didn't know exactly where you'd end up. Muskego didn't become an option and something we thought of as a final place for you until after the first interrogation was attempted and was over with.
And do you recall if you made that determination yourself, or was it your supervisor or something of that nature?
Objection, relevance.
Ground.
As to where they were going to take you?
Yes.
Overruled. The witness may answer.
I discussed it with Detective Casey.
And at that time, that's when you learned that Muskego Police Station was a viable location?
Yes, that's the point at which we made the decision.
Had you ever used that police station before in any of your investigations before that evening?
Objection, relevance.
Grounds.
Overruled. The witness may answer.
I had not, but when our department first closed, that was given as an option for us, being we didn't have our own municipal lockup.
And do you recall around what time you started to conduct the second interrogation?
Yes, 12:11 p.m. on the 22nd.
And do you recall how that interrogation started?
Yes, I explained to you I had more information about the domestic, and that's what I was looking to speak to you about.
Do you recall making a statement that we all know how women can be, they're crazy?
I do.
And what did you mean by that?
It was just additional rapport building that I've talked about in my earlier testimony. Speaking to you on a person-to-person level, quite honestly, it wasn't a judgment I generalized towards all women in the world. It was just wanted you to feel comfortable talking to me as a person. I felt we had rapport. I felt I could tell the night before you were comfortable speaking to me. And it was just a continuation of that.
So it'd be fair to say that that comment doesn't reflect your opinion of women.
Correct.
Why did you feel that would have been necessary to build a rapport that you stated that you already felt that you had?
Because it was just being relaxed. I was relaxed. I didn't want to make you feel unnecessarily nervous. We had been, talking to each other in the casual conversation from the night before, very civilly, very openly about non-custodial topics. And I was just continuing to go along those lines. It wasn't anything other than that, just to communicate with you on a stiff level, relaxed level.
And do you feel, would it be fair to say that other comments could have been used to keep the detainee at ease?
Objection, vague.
Grounds.
Sustained as to the form of the question.
Was there any other conversational tools you could have used to keep the detainee at ease?
Objection, same.
Grounds.
Overruled. The witness may answer.
Perhaps, maybe.
So it'd be fair to say for the situation, you felt that the conversational tool you used would be more appropriate at that time?
So just ask that one more time, please.
You felt that, would it be fair to say that you felt that at that time, the conversational tool that you used would be more appropriate for the situation?
I don't know that I was really thinking about appropriateness. Like I said, I was just conversing you on a normal person-to-person level was my intention at the time.
So it would be fair to say that you assumed that would put the detainee more at ease by starting the conversation with along those lines?
I wanted you to be relaxed. That's not anything that I did just specifically for you, Mr. Brooks. I always want people to be as relaxed as they can be. I want them to feel comfortable to talk to me if they are willing. It doesn't change the fact that ultimately I have to read Miranda. But I always want all the people I talk to feel comfortable and be willing and know that they can talk to me if they want to.
Speaking of Miranda, do you recall reading the Miranda rights in the second interrogation?
Yes, I do.
Do you recall how long into the interrogation before you read the Miranda rights?
Objection.
Grounds.
Objection, misstatement,
Grounds.
and mischaracterization of the evidence.
Grounds.
Well, sustained as to the form of the question.
It would be fair to say that the second interrogation was pretty long. Would that be fair to say?
Yes, sir.
Do you recall when in the second interrogation you read the Miranda rights?
Your Honor, I am going to object again to the form of the question. The interrogation began, the court made a finding as to when the interrogation began prior.
I'm going to sustain the objection as to the form of the question. It calls for a legal conclusion. Next question.
Did you immediately start the second interrogation with the reading of Miranda rights?
No, that is not the first thing I stated to you. First, I explained to you what I was wishing to talk to you about.
And do you recall how long you were in that explanation phase of the interrogation?
Maybe around 15 minutes, 16 minutes.
So it'd be fair to say that you didn't read the Miranda rights till somewhere after already interrogating the detainee for 15 minutes at least.
Objection.
Grounds.
Misstatement.
Sustained. Calls for a legal conclusion. Misstates the testimony as well.
You read
Next question.
You read the Miranda rights after 15 minutes.
Yes, thereabouts.
Do you recall why you didn't start the second interrogation with the Miranda rights?
I'm not required to read them immediately, so those first 15 minutes were verifying your personal information, explaining that I now wish to talk to you about a domestic involving your girlfriend, and then I read them before asking you any specific questions about that event.
Would it be fair to say that you had already obtained personal information the night before?
I had, but I didn't have it in front of me, and I have to recomplete the whole Miranda sheet. So I had to refill out the top form of the sheet, which is your name, so I had to verify that.
So it'd be fair to say that you had obtained personal information that you didn't bring with you for the second interrogation?
I did not have your information written down at that point. Yes.
Do you recall why at that time? You didn't have the personal information that you had already obtained?
No.
No, as in?
I don't recall why I didn't have it.
And you said you started off the second interview with information about domestic allegations. That'd be fair to say?
Yes, after reading Miranda, if that's what you're asking.
No, I didn't.
Right. I don't know what are you asking then? Just so I'm clear.
The question was, again, you started off the second interrogation with domestic allegations.
Yes, that was part of the beginning, explaining to you those allegations that had come forward. Things I didn't know about the night before.
Any reason why you wouldn't explain the real reason why the detainee was being detained?
At that point, the domestic was part of the real reason why you were being held in custody.
Did you have any more knowledge about the incident from the previous night at that time?
Are you referencing the parade aspect of it?
Yes.
At that point, yes, I did.
And why wasn't that information given to the detainee at that time?
As I explained in my earlier testimony, the idea behind the second interrogation was I began with the domestic abuse issues, questioned you about those, and then moved into the parade aspect of the investigation.
And why not start with all the information you knew?
Objection, relevance.
Grounds.
Overruled. The witness may answer.
Can you repeat the question, sir?
Why would you not start the second interrogation with the information that you knew?
In regards to the parade?
In regards to all the information that you had at the time.
Well, as I stated again in my earlier testimony, as we began the second interrogation, I explained it was about a domestic with your girlfriend, Erica Patterson. But again, I can't give you all the details because part of gauging truthfulness and avoiding I'm not leading you is not telling you every single thing. I had told you she alleged there were physical injuries, but I can't really tell you what they were because I want to see if you're going to be honest and tell me what they were. Additionally, telling you what the injuries were as far as Mr. Patterson could cause you to create a lie to avoid those, and it's the same issue with the parade.
Did you speak to the complainant of the domestic allegations at that time?
Objection. The use of the word complainant.
Sustained as to the form of the question.
Had you spoken with Ms. Patterson about the alleged domestic allegations?
I did not.
So it would be fair to say that you, at that time, didn't know if they were true or not?
No, that wouldn't be fair to say.
And why would that not be fair to say?
Well, hold on. It's for this jury to determine the facts of this case, including the domestic allegations. So I'm not going to let a witness comment on his belief or not on any other witness's testimony or information. Fair enough?
I apologize.
All right. Next question.
Had you at any time before the second interrogation spoke with Ms. Patterson?
No.
you made reference, I believe it was in both interrogations, to reading. It was in reference to the Miranda rights, stating that if I was at home on my couch, do you recall making that statement?
Yes.
And what do you mean by that? At home on my couch. What do you mean by that?
Well, Miranda is strictly custody based, so I could interrogate you or question you about a matter in which you were a suspect at your home, and I would not be required to read those warnings. Being we were in custody, we were at the Muskego Police Department, you've been handcuffed, you've been transported, custody was obvious. I'm required by law, therefore, to read you those rights based on you being in custody.
You made a reference to that's a requirement by law. In custody, you have to read those by law.
Objection. Relevance for this hearing.
I'm going to sustain that objection. I believe it's also been answered. So, next question.
Do you recall if those Miranda readings are to be at the beginning of interrogation?
This has been asked and answered as well.
Sustained. It has. It also calls for a legal conclusion, which is not appropriate. Next question.
In the first interrogation, you spoke of the detainee being detained for loitering and prowling. Did you make reference to that in the second interrogation?
No, I did not.
Any reason why?
By the time of the second interrogation, the primary focus had shifted to the domestic incident between yourself and Erica Patterson, and also the parade, because by this point I had more information about the parade and that incident specifically.
So what happened to the initial loitering and prowling allegations? Why were they discarded?
At that point, they were not the primary concern. Eventually, the interrogation came to a stalemate, so to speak, and we didn't discuss it. The primary concern was the domestic issue between you and Ms. Patterson, which at the time I began to start the first interrogation, I didn't know anything about. And then the fact I now had more knowledge on the parade.
So, do you recall who made the decision for the loitering and prowling allegations to be discarded?
Your Honor, I think that mischaracterization of the testimony, the fact that it wasn't charged isn't on this officer.
I didn't say anything about it being charged.
That's not an evidence, and for the other reasons indicated by the state, I'll sustain the objection.
Just for the record, I didn't say anything about it being charged.
Understood. My ruling stands, even with that.
So would it be fair to say that in both interrogations you gave different reasons why the detainee was being detained?
The explanations that I explained to you did change. However, again, the domestic was not known at the time, so that circumstance changed a bit. That became something that was of importance to us. Domestic abuse is taken seriously. And again, there was more knowledge about the parade.
Would it be fair to say that because of the change in information between the first interrogation and the second interrogation that can be misleading?
Objection calls for speculation from whose perspective?
Sustained as to the form of the question.
is it fair to say that someone who is being detained would perceive that as being misleading when there's two different reasons why they're being detained that was told to them?
Objection, speculation. This witness cannot know what is in someone else's mind.
Calls for speculation.
At any point in the interrogations, did you knowingly lie about the information that you had?
There was information I withheld from you, yes.
So it'd be fair to say that you lied.
Objection mischaracterizes this officer's answer.
It's argumentative, sustained as to the form of the question.
Just for the record, there is a point in there where you
Sustained
stated
as to
that
the
he
form of the
lied.
question.
Why did you continue to withhold information repeatedly?
I guess at which point? Through the whole, are we talking about in the middle of the second interrogation at this point? What
Do both
point are we talking about?
interrogations. Do both of them.
Well, there really wasn't a first one, because when I got interrogation doesn't truly begin until I'm asking you incriminating questions potentially after you've agreed to waive your rights and speak, something you didn't do on the first day. On the second one, quite honestly, it goes back to what I've stated in my earlier testimony. I wanted to make sure the information I was getting from you was truthful. I wanted to make sure that I didn't lead you down a path of potential lies. And third, quite frankly, Mr. Brooks, I didn't believe if I gave you the information you were going to tell me anything.
You made reference to the first interrogation saying that there was no waiver of that interrogation?
Objection.
I'm referring to what he just said at the beginning of the answer.
I'm going to sustain the objection. Next question.
Grounds for the sustain?
Next question.
Grounds for the sustain, Your Honor?
Next question.
I can't get no grounds. Okay. So you made reference to not being sure if you would. I'm trying to remember exactly what you said. You wasn't sure if you were going to get the information you were seeking?
Correct.
And is that what led you to lie about the information you knew?
Objection mischaracterizes the testimony.
Grounds.
It's argumentative, sustained.
Did that lead you to not be forthright about the information you knew?
Objection. Argumentative.
Grounds.
Sustained as to the form of the question. His words were that he withheld. You may.
That led you to withhold information that you had obtained?
I'm sorry, did what part with all that? Can you restart the question?
Because you were not sure if you were going to get the information you were seeking, that led you to withhold information that you had obtained.
Well, again, as I've stated in prior testimony, strong part of the reason I withheld information is I wanted to gauge how honest and truthful you would be. I think it's important to note you lied to me, and this was proven by evidence, about your mother owning a vehicle. You know, you lied about coming out here in a tan, possible Kia. So there were lies that were told at this point. You lied about being body slammed by officers. That was later proven to be not true.
Advise the jury of a couple different things at this point. Obviously, ultimately, the juror will determine the credibility of all witnesses and the weight of the testimony to give for any witness. So whatever any person's opinion about the testimony or previous statements or information from another individual, I'm telling you, is not evidence. You need to determine for yourselves what the facts are in this case. And the other thing I want to remind the jury of is that an accused has the right to remain silent, and when that silence cannot be used against him, since there was a comment earlier. To the extent that it was commented on, I'm going to instruct the jury to disregard that as well. Go ahead.
I'm sorry, continuing. So it just was that...
It's narrative at this point. He's going to ask his next question.
Okay.
If the state needs to redirect, they will.
You made reference to, well, let me back up from that. Is it standard practice in your agency to withhold information in an interrogation?
Yes, it can be to gauge truthfulness.
And what do you mean by it can be?
So obviously, so a person understands what's going on, you'll give them the basics of why you want to question them, but you're never going to tell them every detail because you want to see if they're being truthful. You want to see what details come out.
So would it be fair to say by saying that it can be means that it's not all the time used in that fashion?
Oftentimes it is. Oftentimes there's information that I won't tell a suspect unless, it's something where I've actually caught the suspect in the act and we both saw the same things. But yes, typically if I want to make sure they're telling truth, if there's certain information I have, I will withhold that. I'll see if they're willing to provide that, and if not, at some point confront them with that information.
You had a partner with you during both investigations, but I'm referring to the second one primarily. With that officer had used the same method if they were taking the lead in the investigation at that point?
Objections, calls for speculation.
Sustained is the form of the question.
Would it be fair to say that the way you interrogate is your method specifically?
Yes.
So it'd be fair to say that that is not standard policy of your agency?
Correct.
You made reference to the suspect's family. Specifically, I'm referring to the children. How were you able to come into the knowledge of the suspect's children?
I believe I asked you about them.
I'm referring specifically to where they lived at the time of the incident.
That was information that came afterwards. Well, actually, I don't recall. I don't remember if you told me specifically where your older daughter lived that day or not.
Well, we be fair to say we saw a lot of the second interrogation. Would that be fair to say?
Portions of it.
Well, yeah, portions of it, but a lot of it.
I don't know exactly how much we watched. That's really, I guess it depends on your definition of a lot.
At any time, do you recall it being stated where the defendant's children lived?
Not that I can recollect watching today.
Had you seen that video before today?
Yes.
The second interrogation?
Yes.
Have you seen it in its entirety?
Yes.
Do you recall? Well, scratch that. In reference to the second interrogation, in reference to finding the phone, did you ever find the phone of the detainee?
You asking if I personally did?
Yes.
I didn't, no.
Do you recall where the phone was recovered?
In your vehicle.
When you say your vehicle, who are you referring to?
Your mother's red Ford Escape that you were driving that day.
So it'd be fair to say it wasn't my vehicle, as you stated. Grounds.
Sustained as to the form of the question.
And what was obtained from that phone, if you recall?
I don't recall.
Do you recall asking for the code to get into the phone?
Yes, sir, I do.
At any time, did you learn at any time if the phone was able to be opened up?
I don't know if it was or not.
So what would be your reason to ask about the phone code if you didn't intend to open it up?
Objection mischaracterizes the testimony.
Grounds.
Sustained as to the form of the question.
Did you yourself intend to inspect the phone?
No.
So why would you ask for the code?
Well, because for the purpose of the investigation, we have people that are trained in doing that types of thing, getting into the phone, downloading the digital evidence, if they're able. So having the code would assist them in being able to do that when that time came.
And do you recall if it was more than one phone that you were attempting to access?
Yes.
Did you ask for the code for, well, back up. How many phones were you seeking to gain access to?
I believe it was 2.
And do you recall asking for the code for the second phone?
Yes.
Did you inspect the second phone?
Me personally?
Yes.
No.
And from your recollection, what would be the significance of the phones at that point in the investigation?
Well, it's really this digital evidence that could be inside. So as it pertains to domestic abuse, it's not known if there's going to be any phone calls between yourself and Ms. Patterson. Some of the data, location data, can be relevant. Although you were arrested in Waukesha, it still helps to show that data as well. So things of that nature. We really don't know what could or could not help us until we try to see what's in there.
At any time during the first night that you were with the detainee and during the second day, which would primarily be the second interrogation, do you recall there being any drugs and alcohol in related to the detainee?
As in whether you were under the influence?
Yes.
No, you were not.
And do you know that to be fact?
There were no signs of impairment that I observed.
Did you smell any alcohol?
No, sir.
Did you smell any drugs?
No, sir.
Did you find any alcohol or drugs?
No, sir.
And during both those days, that the night of the first interrogation and the time spent during the second interrogation, someone was always with you when you had contact with the detainee. Would that be fair to say? Meaning you never had interactions with the detainee just strictly by yourself?
Not that I recall.
So it was always you and someone else?
I believe so.
Well, you were always with your partner, though, correct?
Well, I mean, he may have used the bathroom at a point. I don't remember. If I was ever alone, it was very short.
But from the best of your recollection, you were just never, for a period of time, just by yourself with the detainee.
The second day before transport, there was a period of time when Detective Stern stepped out of that interview room at Muskego. And I don't know how long it was just you and I in the room, but that's all I recall.
But nothing extended from your recollection?
No.
And was it your belief at the time that you were set to conduct the second interrogation that you believe that without the FBI present, the detainee would likely be more willing to speak with you?
Objection. Speculation.
Grounds.
I'm sorry, can you repeat that again?
Was it your belief that the second interrogation without the FBI's presence, was it your belief that the detainee would be more likely to speak with you at that time?
He may answer. Go ahead.
Yes.
And do you recall how you came to that determination?
Yes, it was a sense of how I felt you interacted with me, you know, the night before. As I stated with you, or stated in testimony, you know, we had casual conversations. Part of those casual conversations were talking about sports you played, sports you enjoyed, the Packer game that day. You seemed very calm, very relaxed. How you seem right now, Mr. Brooks. And I sensed the nervousness with the FBI being present. I thought you might be comfortable talking with me, and that's why I decided to just have it me and Detective Stern.
You made reference to how I seem right now would be consistent with how I seemed that first night. How would you be able to tell that just by observation?
Calm, lucid, your speech is clear. You seem to be knowing what you want to ask. I understand there's been some questions that have been clarified, but you know where you are and you know what you're doing right now.
Would it be fair to say that you can't say for sure how I'm feeling at this moment?
Objection. Not the question that was asked, and argumentative.
Sustained as to the form of the question.
Would it be fair to say that at the time of that first interrogation, you weren't sure how I was feeling?
I guess I can't get in your head, but you presented yourself as being very calm and very comfortable.
Based on your observation?
Correct.
Do you yourself have any training in psychology?
No, sir.
And there was a point in the second interrogation when you were attempting to show the detainee a video. Almost as if you was forcing it in his face. What were you attempting to show the detainee?
I was attempting to show you a video of when you drove your vehicle through the parade route.
Any reason why you were being so forceful in trying to do that?
Well, I felt it was very important for you to see the damage that was caused from the incident. And Detective Stern made the statement as well. You were asking for more information, so we attempted to show you more information.
Would it be fair to say that the question of asking for more information was asked even on the first night during the first interrogation?
Yes. Yes.
Do you recall making a report of the night that? Let me back up. Do you recall writing a report of your interactions with the detainee on the first night and the second morning?
Yes.
And did you write the report yourself?
So how it's done is I dictate it and then it is typed by someone else.
What do you mean by dictated?
So there's a phone system that I talk into and it's recorded and then it's later typed.
Do you recall who types it?
One of our clerical staff. I don't know specifically who it was.
So you made reference to a phone. You gestured with your right hand and made a phone, I guess, symbol. So I'm assuming that records what's being said. That'd be fair to say?
Yes, when I'm speaking into the phone.
And at that time, speaking into the phone, were you stating verbatim? Was it off the top of your head what you remember, or did you, I guess what I'm saying is, did you speak into that phone based on a report that you had already previously written or had obtained?
Well, I guess I want to make sure I understand the question. Could you ask it again so I understand?
I guess I can be more clear. I guess what I'm trying to say is, like, by speaking into this phone, would that have been what you recalled at the time, or would it been based on a report that was already written by you or someone else?
Okay. There was no prior report, so that what I speak into that phone and what is typed is my best recollection of the events at that time.
That just gave me a little clarity. I knew what I was trying to say, I just couldn't. So at that time, when you spoke into the phone, you hadn't yet filed your report at that time.
Correct. As I'm talking, I'm completing it. So it goes into a recording and then it's later typed.
And then is it filed after being typed?
Yeah, eventually it's sent to court.
Do you recall if that was, I'm guessing that would be the night of the second interview or sometime after that?
Yes, it was the night of the second, after that interview had been completed.
After that second interrogation, had you learned any more information additionally that you didn't have during the first and second interrogations?
Yes.
And did you put that into your report?
I believe I did, if it's the one thing I'm thinking of, yes.
Do you recall how many reports you filed in relation to this incident?
I think 4, maybe 5.
Why so many?
Well, you have to understand that after the second interrogation, the investigation wasn't simply complete. There were additional things that need to be done, and additional things I assisted with that led to other supplements being done.
And do you recall, well, let me back up a minute. You said 4 or 5 reports?
I believe so. I don't know the exact number.
Do you recall when the last one was completed?
I believe in June.
And would the June report contain additional information that you didn't have in November of 2021?
I don't recall either that or clarification. I'd have to see the report, I guess, to know exactly what you were driving at.
You don't recall what you reported?
Not exactly.
Do you recall what you reported in the second report?
Not exactly, no. I believe, I don't want to speculate.
So it'd be fair to say you don't recall what you reported in any report except for the first?
That is the one that is most clear because it was such a substantial piece of what I did in this investigation.
And that was the one when you spoke into the phone and it was recorded and then typed?
Well, they were all done the same way.
All reports are done the same way. And do you recall coming to the Waukesha County Jail to serve any warrants in relation to this incident?
Yes, I do.
Do you remember what they were for?
Yes, it was a search warrant for your jail property.
And do you recall what that jail property was?
Property that would have been turned over to the custody of jail when, at the time that you were, so personal belongings.
And what would personal belongings refer to exactly?
Are you asking, it could be anything you had with you. Are you specifically wanting to know what I seized?
Yes.
Your red t-shirt that you were wearing on the 21st and 22nd of November, the blue jeans, as well as socks.
And do you recall why you needed to seize the clothing?
Yes, the determination was made to go back and seize the clothes as it's the items you were wearing during the event. The parade event is what I mean by event.
Would that be the only reason why you needed to seize the clothing?
There was also possible DNA evidence, but I do not know how that came back.
Did you yourself inspect the clothing?
I just retrieved it from the property, put it in a bag, and brought it back to the police department.
Do you recall if you seized anything else besides the clothing?
Not from your property at the jail, I didn't.
And do you recall if that was the only time you came to the Waukesha County Jail to serve a warrant?
Correct. That's the only time I recall.
Do you recall when that was?
November 30th, 2021.
So roughly about a week after the incident?
9 days.
And you made reference to bringing it back to the department. Did you learn who would be expecting the clothing?
No, I believe it would have gone out to the state crime lab.
Did you obtain any additional information from the state crime lab?
I don't believe I've received any information from the state crime lab personally.
I want to go back a little bit, specifically to the night of the arrest. When did you arrive on scene to Elizabeth Street?
Shortly after you had been taken into custody.
When you arrived, what did you see?
Can't recall exactly. I believe you were already in the back seat of a squad car.
So at that time, suspect was already detained.
You were detained.
Suspect. Already
Suspect
detained.
is you, Darrell Brooks.
Can you strike that last comment?
That was his response. It will stand.
And did you do any search of the area at that time?
I did not, no.
And what did you do from that point?
At that point, myself and Detective Stern were assigned to follow Specialist Mark Howard, whose vehicle you were ultimately placed in, and follow him to our substation, where you were taken.
Do you recall well, let me back up. Do you recall seeing a lot of different law enforcement there from different jurisdictions?
Yes, I do.
What else do you recall about the scene as far as law enforcement personnel?
Basically just that they were there.
Do you recall any weapons being drawn at that point, or?
I did not see any officers with weapons drawn when I arrived. There were officers with rifles across their chest, but they were not pointing them at anyone.
Any distinct vehicles, to your recollection, utilized by law enforcement?
Just squad cars, marked squad cars that I recall.
Do you recall seeing a vehicle that was more like a ground rover type vehicle?
No, sir, I don't.
And so once you came to the scene, learned that the suspect was in custody, you followed the other officer to I'm guessing the police station or whatever it was?
The substation.
Substation, I'm sorry, substation.
Yes.
And what information did you have at that time in regards to the investigation?
The information, again, was still very limited. That you'd been loitering in the area, would receive calls, and that you were identified as a possible suspect that was in the vehicle.
Did you yourself receive those calls, or any of those calls?
You mean as in like the phone calls?
Yeah, in reference to the loitering.
No, those went into dispatch, and then they were broadcast over the police radio, which I heard.
And did you immediately respond to that radio call?
Yes, I made my way to that area.
The area of Elizabeth Street?
Yes, sir.
Do you recall what time that was?
It was right around, took place over a few minutes, 5:30, 5:35, getting a little after 5:30.
And what time did you arrive to the scene?
I don't know the exact time.
I want to go back to the phone really quick in reference to the phone. In the exhibit that we were shown, you made reference to not wanting someone else to claim the phone. Do you recall saying that?
Yes.
What reason would someone else claim a phone that isn't theirs?
Could be their own reasons. One thing we have to do once we have possession of property, we have to make sure that we release it to the appropriate person. So that would be important.
Is it fair to say that all property obtained from a detainee is sealed?
I guess, what do you mean by sealed?
Like placed in a sealed bag, pursuant to whoever's the property belongs to, it's sealed.
Typically, we would take property and probably put it in a paper or plastic bag. We don't necessarily seal it and then place it in a locker.
Would you write on the bag who the property belongs to?
Well, if it's personal property and it's going to be returned, it would go in a locker, typically that's associated with their cell. But if it's evidence, it would go, to a different place. It depends on the type of property you're talking about.
Would it be some type of identifying something to identify the property to the owner of the property?
Yes.
When you came to the Waukesha County Jail to serve the warrant for the clothing or personal property, as you stated it, was that property sealed?
It was in a secure room.
Was it sealed?
Like the bag it was in? No.
The bag was just wide open?
I don't recall if it was wide open. They have it in a property bag that I don't remember the exact conditions of it.
Did it have any identifying name on it, or a birth date, or?
They utilized a system in which they looked up your name, and the bag had a number. The number was associated to your name. So they were able to find it that way. And then, once I got in the bag, I recognized the clothing as your clothing.
So it'd be pretty fair to say that the system that they use is pretty easy to identify what property belongs to whom.
It seemed to be. To get the specifics on it, you'd have to ask them, but I mean, they looked up your name, hit a number, and your bag came right across.
Does your agency use a similar method?
No.
And what method does your agency use to identify property?
My agency would simply, well, we're not a large county jail, so we only hold about 5-6 people at a time. We would take personal property, put it in a paper bag, put that paper bag in a locker that typically would correspond with the cell number that you were placed in. And then your property would also be documented on an electronic form, so we knew it belonged to you.
You made reference to not being a large county jail. Are you referring to the holding station?
Our standard department that we're back in now has a municipal lockup. Correct. It's very small.
So it'd be the holding station.
I call it the police station, the booking room.
Police station, substation, holding station.
Yeah, correct.
At any time during the second interrogation, were there any other law enforcement watching the interrogation from another location?
Yes, there were.
Can you explain why?
Well, again, the FBI was present in a different room because we still did not know whether there was a terrorist nexus to this incident at that point.
Is that the only other law enforcement that was watching the interrogation?
There may have been some of our own officers. I don't know how, if they were moving around the building or I don't know what they were doing.
So it'd be fair to say you can't recall if
Correct.
If at that time there was still uncertainty about the nature of the incident, to the point that the FBI still were kind of involved at that point, any reason why they wouldn't accompany you and your partner for the second interrogation as they did with the first?
Objection, relevance.
Grounds.
Sustained. Relevance, 90611.
Is there any reason why the FBI can induct their own interrogation?
Objection. Calls for
Grounds.
speculation.
Sustained.
If you knew at that time that you and your partner would be conducting the second interrogation, why did the FBI need to be present?
Objection, relevance.
Grounds.
Asked and answered. Next question.
Answered?
It's sustained.
You said asked and answered?
You've asked why the FBI was there multiple times. Under 90611, please move on.
Is it standard procedure for other law enforcement to watch interrogations from another location?
Objection, relevance.
Grounds.
Overruled, you may answer.
I wouldn't say it's standard, but this wasn't also a standard incident.
So the magnitude of the incident is what prompted the change?
That's right.
Do you recall who made that determination?
Objection calls for
Grounds.
speculation of relevance.
Yes, do you know? So overruled, the witness may answer.
So I'm sorry, just so I understand the question correctly. Why the FBI is the question why they'd be there at all?
No, that wasn't the question.
What is it again?
The question was pertaining to standard procedures.
Okay.
And I believe the question was,
You asked who made the determination to allow for other agencies to observe the
Right.
interview or interrogation.
thank you, Your Honor.
You're welcome.
I don't know exactly. I only know that the FBI became involved due to the terrorist concern, so that's why they were there.
My question wasn't towards the FBI. It was law enforcement in general. Just to give more clarity, the question was, did you know who made the determination for other law enforcement to watch from another location?
No.
Were you at any time aware that there would be other law enforcement watching the second interrogation?
I knew the FBI was coming back, yes.
Did you know if there would be any other law enforcement outside of the FBI, like from your agency or anything like that? Were you aware that they would be watching as well?
Objection relevance.
Grounds.
Overruled, the witness may answer.
Not that I knew of.
But you do recall other law enforcement outside of the FBI being present?
Yeah, so we had an officer, based on you being in our custody, that had to stay in the room with you, their jail area for the night. I don't know how much of the interview that officer was or was not present for from another location.
Do you recall leaving out of the interrogation room during the second interrogation?
Yes.
And at that time, did you speak with any other law enforcement?
FBI.
And do you recall what those conversations were about?
Not specifically, no.
Do you recall if there was directives given by the FBI?
Objection hearsay.
Grounds.
Yes, do you know? Not what they were. You may answer.
I don't recall if they gave directives.
Do you recall your partner stepping out of the interrogation room at any time?
Yes.
Do you know if they spoke with FBI at that time?
If my partner did?
Yes.
I don't know.
At any time during the second interrogation, did the FBI leave?
Not that I know of.
So to your recollection, they were there the whole time?
I believe so, yes.
And I want to go back to the phone for one quick second. You made a reference to the kind of code on the phone. Do you recall what that was? in reference to the phones that you were intending to access?
You talking about, there were two, one of any one phone specific? You talking about the iPhone?
Yeah, the iPhone. I'm sorry.
Yes, you gave a pattern code.
And what about the other phone?
No code was ever provided that I recall.
And do you recall if those two phones were placed in the evidence?
Yes, they would have been.
And did you place them in evidence?
I did not.
Do you recall whom?
I do not.
During your investigation, what? Let me back up. I don't want to say what. You made reference to the suspect being involved. During that initial information that you received, did you receive information that there were multiple suspects at any time?
We're talking about the parade incident at this point, yes, no?
The parade incident, yes.
Initially, yes, so, and I've covered this in prior testimony as well, it was very chaotic early on, and there were reports of possible multiple suspects, yes.
That just about does it. No further questions.
How much redirect, if any?
I have some. I would think I could get done in 10 minutes.
All right, I'm just gonna have my jury stand for a minute. I need one too. And anyone else in the courtroom may do that. All right, thank you. Please have a seat.
Exhibit 174, which has previously been admitted into evidence. Do you recognize this form?
Objection, leave.
Overruled, the witness may answer. It's been testified to previously.
Yes, I do.
Sir, if you talk to the same person 3 different times while they're in custody, do you have to fill out a separate form each time you talk to them?
Objection.
Overruled, the witness may answer.
3 times.
Yes.
Would you have to fill out that top portion of the form each time?
Yes.
That's all I need for that exhibit. When we talk about, do you recall Mr. Brooks' questioning of you with regard to the recording made by your cell phone at Waukesha Memorial Hospital during the first meeting with the defendant?
Objection, I don't consent to being called that name.
Noted, overruled, the witness may answer.
Yes, I recall.
Are you familiar with the term excited utterance?
Yes, I am.
Meeting.
Oh, overruled, the witness may answer.
Sorry.
What is that?
It's It's when an individual, whether it be Mr. Brooks or any individual, begins making statements on their own accord and not response to a question. Typically, an utterance may reference why they're in custody in the situation that you were either questioning them about or preparing to question them about.
Is it important to capture those types of utterances on tape or recording?
Objection, speculative.
Overruled. The witness may answer.
Yes, it is.
Would that be a reason to continue recording after an interview's been ended?
Objection, answered that already.
Overruled. The witness may answer. It's redirect.
Yes, it would.
With regard to the two phones, you indicated that someone else located the phones in the defendant's car. Is that correct?
Yes.
And in order to access the contents of a phone, if it's passcode protected, do you need the passcode to enter it?
Objection, leading.
Overruled. The witness may answer.
It makes it easiest. They can, the men that do that, the men and women that do that do have ways around it, but it makes it much more difficult without it.
And would it be fair to say that there's not all software can enter into all phones without the passcode?
Objection, speculative.
Sustained as to foundation.
Have you had experience in your position as a detective seizing phones off of defendants?
Yes.
And have you had opportunities to turn those phones over to your forensic unit to have them analyzed?
Yes.
When you don't have a passcode or a swipe pattern, have you received those phones back with information that they were unable to be accessed?
Objection, asked the form of that already and answered.
Overruled. The witness may answer.
Yes, I have.
So if you're not provided a code or you're provided an incorrect code, there's a possibility, or are you definitely getting into that phone?
Objection, speculative.
Overruled.
No, there is certainly a possibility that we would not be able to access the content.
You had talked about on cross-examination your reports that you dictate over a phone line. Do you recall that?
Yes.
Those you testified were based upon your recollection?
Correct.
Do you take notes during interviews?
Objection, speculative.
Overruled. You may answer.
Yes, I do.
Do you use those notes at all when dictating your report?
Yes, I do.
The defendant asked you about multiple suspects. You having information about multiple suspects. Do you recall that line of questioning?
Yes, I do.
Did the defendant ever tell you that there was anyone in that car other than him driving it and possibly Erica Patterson?
Objection, leading the witness.
Overruled. The witness may answer.
No, he did not.
And finally, you've been a law enforcement officer in Waukesha County for approximately 18 years. Is that correct?
Yes.
Who makes the charging decision when deciding what charges get issued in a criminal case?
Objection, leading.
Overruled. The witness may answer.
The prosecuting attorney at the Waukesha County District Attorney's Office.
You don't decide on the charges?
No.
Objection, relevancy.
It's overruled.
We can forward what we believe is appropriate, but we don't ultimately make the decision to charge.
So when Mr. Brooks asked you, what am I being charged with, did you have any ability to tell him that?
Objection, I don't consent to being called that name.
Noted. Overruled. You may answer the question.
No, ma'am. Not with 100% certainty, no.
Nothing further, thank you.
All right, thank you. Detective, you may step down. Ladies and gentlemen of the jury, as Detective Carpenter is stepping off, I will read the instruction that I've read to you every day, but it's important that you hear it again. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite you telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. And while I still have you here, I neglected to tell you one thing about an exhibit that was received. Exhibit 81 has been received by the court. With that, you are excused. Thank you, everyone. 82. Boy, it's been a long day, but okay. 82. Thank you. Yep, you're right. 82. Had 81 in the brain. All right, thank you, everyone. We are in recess. We'll see everyone at 8:30 tomorrow morning.